Mpofu, the evidence leaders, Advocates Bauer and Mayosi, members of the media with us, our entire support staff, their various duties, and lastly but not least, those who brought us here, the members of the public and their various platforms, YouTube, 408. You all welcome today. We are proceeding with our inquiry with the next witness today, which will be introduced very shortly by Ms. Fatima Ibrahim. We have this witness the whole of today up until midday tomorrow. And so we're going to do our business within that timeline. Thank you very much for your attention. Without any delay, I'm going to ask Ms. Ibrahim to do the preliminaries, introduce the witness, and then we start our proceedings. Thank you. Over to you, Ms. Ibrahim.
Thank you, Chairperson. Chair, the witness for today is Professor Madonsela, the former public protector. Prof. Madonsela, can you hear us?
Yes, Advocate, I can hear you.
May I please ask that you switch on your camera so that we can, oh, I see you now.
Yes.
Thank you. I'm going to be administering your oath. Prof. Mdntv, you have been invited, subject to the provisions of Section 16 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act of 2004, to appear before this committee as a witness and to answer questions in respect of the committee's inquiry into the removal of the Public Protector, Advocate Mkhwebane. Please be informed that by law you are required to answer fully and satisfactorily all the questions lawfully put to you, or to produce any document that you are required to produce in connection with the subject matter of the inquiry, notwithstanding the fact that the answer or the document could incriminate you or expose you to criminal or civil proceedings or damages. You are, however, protected in that evidence given under oath or affirmation before a House or committee may not be used against you in any court or place outside of Parliament, except in criminal proceedings concerning a charge of perjury or a charge relating to the evidence or documents required in these proceedings. Please be aware further that in terms of Section 17(2) of the Powers Act, a person who willfully furnishes a House or committee with information or makes a statement before it which is false or misleading commits an offence and is liable to a fine or to imprisonment for a period not exceeding 2 years. You are now going to be required to take an oath or to affirm that the evidence you are about to give is truthful. You may choose either the oath or affirmation. What is your preference?
The oath, ma'am.
May I please ask that you raise your right hand and repeat after me? I swear that the evidence I shall give.
I swear that the evidence I shall give
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
Thank you, ma'am. Chair, the witness is now duly sworn in.
Thank you, Ms. Ibrahim, and welcome back, Professor Thuli Madonsela, to the inquiry. This now seems to be a real start than the false start we had. So welcome you back. I am aware, before I invite Advocate Mpofu, that you had requested to make a few remarks, and I now allow you to do that. Thank you.
Thank you. Thank you, Chairperson and honorable members of the committee and colleagues. I appreciate the privilege to appear before you. Nonetheless, I come before you reluctantly because you've asked me to respond to questions primarily on two cases that have been extensively dealt with by the courts. And therefore, my reluctance to appear before this committee had nothing to do with lack of respect for this important pillar of our democracy. It was because of apprehension that I'll be put in a situation where we are rehashing what the courts have decided about this South African Reserve Bank matter, also known as the CX matter, and also about the Freddie Dairy matter. I therefore apologize if there's a sense that has been given that I was reluctant to appear. I secondly would like to just place on record that it is not true that the delay was primarily because of arguments about whether CX is spelled with an S as opposed to a C, which was a mistake that the Secretariat could correct me on without lawyers being involved, or that the matters that were the focal point were two instead of one. The crux of the confusion that I was placed in is the fact that the lawyers of Advocate Mkhwebane sent me a litany of questions that when I looked at the charge sheet, I couldn't find any reason whatsoever why I should answer those questions. And I responded accordingly, asking relevance and also indicating that to the extent that they need that information, I'm not the person who has the information. The information is with the public protector in the archives and staff members. So that was the first concern. The lawyers wrote back, yes, they questioned whether CX was spelled with an S or a C, and the small matter of whether the cases were one or two. But the crux of it was still about what are the questions that I'm supposed to answer? Instead of answering the questions about the previous questions, the new letter provided new questions. Again, my response was to ask, what's the relevance of these questions? Is this my impeachment process? Because if it is, then this is the wrong forum. I was protector until the end of, until the 14th of October, 2016. But if it is indeed that somebody is accusing me of anything that I did wrongly, then this is not the right forum. This is a forum about my successor, Advocate Mkhwebane. If Parliament needs to question me on what I did or didn't do, we would have to have a separate investigation. We can't turn an investigation into parallel investigation. And in any event, I do not think that Parliament still has jurisdiction to question me over those matters. But should there be merit in questioning me, which I think there's no merit in any event, the right forum might be at this stage, the public protector, where I am reported to the public protector. as a former public protector who did something wrong, or it could be the Human Rights Commission, but certainly this is not the right forum. And in terms of the statement, I place on record that a statement that I've put before you that says the basic things of who I am. I'm a professor of law, currently employed at Stellenbosch University, and I'm the director of the Center for Social Justice. I have indicated that all of the facts that are contained here are, to my knowledge, true and correct. I must indicate, though, that I don't have access to the investigative reports, and therefore, where there are questions about dates, the public protector kept an extensive register that would indicate who I met, when I met them, what documents were received in that office on what date, and when those documents left the office. And on the two matters, I have just indicated that all I can confirm is that I was the lead investigator at the commencement of the CX investigation. Talk about an attempt at rectitude being turned to look like turpitude. That's a classical case in the CX investigation. I conducted this investigation initially with a trainee investigator by the name of Mkhwebane, who then left to be with the NPA. How did I end up doing an investigation? The Public Protector Office never did investigations. They were done by staff, and I would come in at the level of matters that were called special attention matters, SAM. But again, as a supervisor, overall supervisor or supervisor general, as an investigator general, after these matters have gone through chief investigators, executive managers, and then coming to my desk. This investigation was rejected by the staff of the Public Protector when it came in. I can confirm the one time it was rejected, but it may have been more than once that it was rejected. I only came to investigate it because when I attended the World Justice Forum, I met Advocate Paul Hoffman, and we sat together on a bus, and he convinced me that there was adequate information that showed that this is an easy matter, and the bank concerned had admitted that it owes this money, and that I didn't need to investigate anything. I was also told that there were documents, but as Public Protector, of course, any document that you're given, you still have to authenticate and you have to conduct your own investigation. So we did this investigation with Mkhwebane, which meant investigating it over and above my overall responsibilities as a Public Protector, which accounts for the delays in this investigation. And eventually Mkhwebane left, and then I was left alone, and there was no proceeding with this investigation. I couldn't bother staff because we had a triaging system. There was an intake assessment committee that duly assessed and found this investigation not worthy to be investigated for several matters. That firstly, the events complained of occurred before the Public Protector was established. Even if the money was recoverable, it would have prescribed. Also, it was firstly an issue of jurisdiction, given the fact that the matters preceded the existence of the Public Protector. So why did I decide to investigate it regardless? I've already indicated that Advocate Paul Hoffman convinced me that there's already sort of relative agreement. And also that if this money is recovered, it could it could make a difference in terms of the challenges of funding mainly social and economic rights such as education, health, RDP housing, etc. Then how did I overcome the fact that the public protector only came into being in 1995, and this matter happened before then? We overcame that hurdle by looking at only whether government did process the CX investigation report and dealt with it properly. And to the extent that it did not, whether that was improper. And so our focus therefore was not on the original loan, lifeboat, or whatever people may call it. Our focus was on what happened after 1998. And of course, it turned out that it was a very complex matter. A lot of people that appeared before me wanted us to investigate the original loan or gift, or whatever each one of them called the original transaction. I must also indicate that before me, there had been investigations by Justice Dennis Davis, Heath, etc. And therefore we had to distinguish what we were doing and why would we repeat this? And that's why you will see in the investigation report that we looked at them. So regarding what happened afterwards, the courts have already found that the report that was issued was broader than the original focus. The courts have already found that the remedial action to change the constitution was neither part of the investigation nor is within the remit of the public protector. And there's nothing really I can do about that, given the fact that that's a decision of the court. From my side, I left no final report or approved a provisional report. But I've looked at the documents that purport to be documents from my desk. They are totally changed. Again,
just a pause, Professor Madonsela. I have a hand from a member here, Honorable Maneli.
No, thank you, Honorable Chair. Apologies for the disruption if it is, but I just wanted to be sure in terms of the notes I take as to where we are. Because I understood you, Chair, because I'm not addressing the witness now, but you, was that there were to be opening remarks, and then we then get to actual evidence and so on. I'm raising it because having listened, some of the matters that are raised are matters of evidence that would have come before the committee, which we may need to interact with. So if you can just indicate, which will also help us with time also, to what point would those opening remarks be done.
Okay.
Thanks, Chair.
No, thank you, Honorable Maneli. Before I respond, I'm told there's another hand. So, okay, slow it down. Thank you, Honorable Maneli. I did observe that Professor Madonsela did make her opening remarks and also has begun to take us through the statement in a way. So I was in two minds whether it was, in any case, we're still going to have to do that. And with Advocate Mpofu, also just like me, still listening, I thought we should allow her to complete that. And then, even though it was just to clarify your point, it is now explanations into the statement. I'm aware of that, that she's taking us through beyond the opening remarks. And I'm just saying, I was just using my discretion to allow her to continue to place everything. Because at the end, when Advocate Mpofu starts, he might have started there on that issue. Maybe that helps his time also. So I have, unless you are objecting, then I'll have to attend to
not
that.
objecting, Chair. Well, with the clarity that we are now on another level, as long as that's done. Thank you. Can proceed, Chair.
Thank you. I think, I hope that helps to clarify. We're just following. So, because having received and read the statement, we can see where she is speaking into the statement. So that was clarity sought, Professor Madonsela, from a member. As I indicated, there being no objection, I'm going to allow you to continue.
Thank you, Honorable Chair. If honorable members would prefer me to stop here,
Chair,
I am happy to do so.
Chair, my hand is up.
Just pause, Advocate Madonsela. Honorable Mautwe.
Yeah, no, thank you. I had my hand up earlier on. You are correct. I lowered it when the honorable member almost covered me, which is a question you did not answer, to say how long is this address going to take? Because you indicated that we've got the witness today and half of tomorrow. So we don't have time, Chair, because Advocate Mpofu must still come in, Advocate Bauer must still come in, and as members must still come in. So how long are you giving her the time allocated to her? Like you always do, Chair, with everybody, including the PP and Advocate Bauer. So let's just understand how much time are you giving her so we can manage our time properly. Thank you, Chair.
Thank you, Honorable Mautwe. That's fair. We almost halfway there in the middle of it, I think, Professor Madonsela. I think the issue now is perhaps so that there's an indication from members how far you are and so on, but members are not saying you must stop, but it's just those clarities. So I would want you to continue.
Thank you, Chair. Person, and thank you, honorable members. I will try and read through the statement as is so as not to delay them. I left no final report or approved provisional report. I found that the principal debt of the final loan had been paid, but interest not. I considered it legally impermissible to claim the money, considering that prescription had been raised as a legal defense much earlier. The tone, scope, findings, and remedial action in both the issued provisional report and final report differ materially from drafts the investigator had worked on and submitted to me, though I did not approve same and requested further changes. The State Security Agency was never involved in the investigation, except for an interview with Mr. Billy Masetla regarding why his institution got involved in the original contract with CX and how the process unfolded. And that was clarified by Mr. Masetla when I met him on the On the 7th of, on the 27th of, sorry, on the 22nd of March, 2013. Strangely though, after leaving documents with a colleague from the South African mission in London, which had been given to me by CX's Michael Oatley at an interview, this colleague accompanied me to the accompanied me to the documents arrived from the State Security Agency, opened and with a note from the State Security Agency Director General. They were meant to be transported by DECOM. I met Michael Oatley on the 15th of September 2015. And we agreed then that I would leave the documents he had given me and further documents he was going to give me with the colleague from the embassy. And the record of that meeting was also kept by that colleague and later sent with the box that came already opened from the State Security Agency. Now, key changes that I've observed in the final CX report include the remedial action regarding changing the powers of the Reserve Bank, which was not an issue, as the issue concerned lending and debt collecting practices. Regarding the Freddie Dairy investigation, I confirmed that 1, the investigation was conducted by the Public Protector Regional Office in Bloemfontein during my term. 2, the investigator and her team struggled with drafts being sent back from my desk and from their peers in the think tank, presumably because the investigator had been doing service failure or early resolution nature cases whilst at national office. And until my time, regional offices did not conduct investigations on complex matters, particularly involving corruption and related financial impropriety allegations. 3, they still fail to meet the standards in the standard operating protocol, which I personally developed and issued as a handbook. Even after training the team with the same tool. One of the key reasons was omission of names and failure to conduct a forensic investigation, which is compulsory in the SOP in matters where corrupt relationships are alleged or suspected. When Mr. Samuel, not Samuels, I'm sorry about the S, took over as regional representative, I asked him to take the investigation over. My concluding remarks touch on the staffing arrangements in the office, which staffing arrangements just basically were primarily the domain of the deputy. I found it so, I left it so, and the CEO. So 1, I inherited a well-run institution that had been built virtually from scratch and improved step by step by my predecessors. Through learning and growing together, we kept improving the system, guided by Seneca's assertion that, quote, "Will I not walk in the steps of my predecessors. I will indeed use the ancient road. But if I find another route that is more direct and has fewer ups and downs, I will stake out that one. Found in William Stevens, 2020. 3, 2 of the investigation guardrails I personally developed, followed by peer review by the team, was the handbook on administrative investigations and public protector mandate book. So the handbook on administrative investigations was a standard operating protocol that investigators had to comply with. Before then, we had guidelines, and the feeling was that guidelines are guidelines, and therefore to have proper guardrails that people could be held account on the basis of, we needed a standard operating protocol. Before then, we also had developed a public protector handbook to make sure that we know which version of which law to apply and which laws were applicable to us. 4, I further did what I could to collaborate with colleagues towards guardrailing the Ombudsman institution globally, which included establishing the African Ombudsman Research Center, AYOC, a process commenced by immediate predecessor, Advocate Lawrence Mushwana, and personally suggesting and developing the OR Tambo Declaration on Minimum Standards for Effective Ombudsman Institution.
Chairperson.
Right.
Just a pause, Professor Madonsela, Advocate Mpofu.
Okay, yeah. Good morning, Chairperson, and everyone. Yeah, I'm at sea as to what is actually taking place now. I think the issues raised by the members are quite valid. If the witness is just going to be reading her statement or reading it out, I think the process here has been that once a statement is tabled, everyone can read the statement, and that the evidence is led in the form of questions by someone. Otherwise, yeah, Chair,
Okay.
I think let's get into that.
All right. Yes, that's what we attended to earlier. I'm just going to ask her to conclude. She's about to conclude. Thank you, Advocate Mpofu.
Thank you, Chair.
Thank you.
It's just 2 lines now, or 2 paragraphs. 5, I resisted being spied on by the State Security Agency through sudden repeated requests to vet me as I was finalizing the Waterkloof lending incidents by the Gupta family. What I could not prevent is it lending with the CX box and flash disk, all of which had been opened on arrival. I've included this because there have been questions around the CX investigation and the involvement of the State Security Agency. I just want to confirm here that it was never involved. The only person that was interviewed on the 22nd of March 2013 was Billy Masetla, simply because I needed to know what was the basis for the State Security Agency getting involved and how the process unfolded, and he clarified that. And lastly, we worked as a team, building and executing systems that tried to balance rigor with promptitude, gave priority to what we refer to as Gogo Dlamini cases, while ensuring that the investigation standard applied and duty of care was uniform. It is my considered view that the above is all that is relevant in the light of this section 194 investigation. I therefore do not believe I should be asked a lot of the questions that were in the 2 letters that were sent to me. Thank you.
Thank you, Professor Madonsela, for firstly those remarks and walking us into the statement as well. We are now going to invite Advocate Mpofu to interact with the witness. And I'm going to ask Advocate Mpofu, because a bit of your time would have been taken. So you returned time last week, so it seems that we're going to have to return some time to you. It's very quick. But we want to start with you now, and perhaps we can stretch it to 3 and up to 4 o'clock this afternoon. Again, if you can save time and give us back, we are happy to receive that. But over to you, Advocate Mpofu.
Thank you, Chair. Well, I may expect you to return the favor in the spirit of give and take. Thank you, Chairperson. Good morning, Advocate Madonsela, or Professor. Would you prefer to be called Professor or Advocate?
Whatever is easy for you, Advocate. Okay. Good morning, sir.
Good morning, ma'am. No, that's fine. So please don't mind if we shift from the prof to the advocate. The Advocate Mkhwebane rolls easier on the tongue because that's how we referred to you for a long time. But so it will be no disrespect if we use that title. Okay. Now, maybe, Chair, we should do it like this. I think, in fairness, I'll take much shorter time just to put context to how we're going to approach this. Now, Professor, I don't think that there's going to be much quibbling between you and me regarding the scope of what we're going to cover. And I'll explain to you just now why I don't think so. So there's a lot of time and energy that has been spent even this morning about scoping and whether these questions are legitimate or relevant and so on. And we all accept here that according to the directives, the chairperson is the final arbiter of relevance. You understand that?
I do understand, but you are paid for every word you utter. I am losing time for every word I utter. So as professionals, we also have to be self-regulating about what we ask and what we discuss without waiting for the chairperson to tell us.
No, anyway, you're wrong, madam. I'm not paid for every word I utter, but I forgive you for that because you wouldn't know, but that's fine. I was simply saying that in terms of the directives of this particular committee, the final arbiter, for better or for worse, is the chairperson of relevance. I'm just informing you.
It must be for better.
Probably for better, yeah. But not always. I'm informing you. All I was asking is whether you understand that. I'm not debating the point with you. It's in the directives.
Yes, but if I think you're asking me an irrelevant question, I will say so, sir.
Okay, so let's wait until that happens. For now, I'm just asking you if you understand.
I fully do, sir. Thank you.
You do. Thank you. That's better. Okay. Now, my understanding, therefore, is that subject to issues of the validity or otherwise of your affidavits or whatever version thereof. But the reason why I'm saying I don't think there's going to be much quibbling between you and me is that my understanding is that your statement is really anchored by 3 paragraphs. Where you say that your statement, paragraph 4, sorry, that will be, it will be bundle H, Madonsela folder, the final affidavit or the third affidavit, 31.6. Yes, paragraph 4. There you say that the statement sets out a summary of what you intend to share with the committee. And that's the summary that you've just given now. So in other words, what you've put in the statement is just a summary, not the full version, correct?
It was a summary, but
yes,
sir, I have now been given an opportunity to present what I could, and I have done so.
Good. So that's the first anchor paragraph, paragraph 4. And then you then refer to the chairperson's letter wherein you were invited to, among other things, or rather you were told that you deal with issues which are relevant to the motion. I think on that we all agree, correct?
Yes, sir.
Yes. Now, but the most important paragraph, I think, is paragraph 10, which is your last paragraph, which you just articulated now, where you say that in my considered view, the above is all that is relevant in the light of the section 194 inquiry and the contents of the letter, the chairperson of the committee. So everything above paragraph 10 is what you call all that is relevant, in your view at least. As I said, we might differ on what's relevant and not relevant, but at the very least, your version is that whatever is from paragraph 1 to 9 is all that is relevant, correct?
As a summary, yes, sir.
Yes, good. Now then, that's perfect, because in my view then, unless if there's any difference between you and me, which I will indicate to the chair towards the end, I am happy to proceed on the basis that start with what you and I agree is all that is relevant. And if at the end, there's still 1 or 2 issues on which we quibble, then obviously we'll refer that to the chair to determine. I think that's a fair way of proceeding also, so that you and I will be on the same page. So we will, for the first part, then be governed by your statement, correct? Are you happy with that?
Very happy. Thank you,
Good.
sir.
Perfect, perfect. All right. Now that we've got that clear, I said it was subject to determining whether there's even a statement before this committee or an affidavit or not. We are at this stage confused as to whether there's an affidavit. As I understand, you are reading now from the 3rd version of your statement, correct?
As far as I know, there's only one version of my statement. And again, Advocate Mpofu, I did say that you paid for every word you utter. There's only one version of my statement. And that version was sent on the 25th with a very tight deadline. because of the quibbling between the lawyers of Advocate Mkhwebane and myself about what exactly should I cover. Finally, on Saturday, I was given the deadline of the 24th, and I requested that it be moved. I think it was the 22nd. I requested that it be moved to the 25th, which was a Saturday. And against several odds, including load shedding, I sent the statement, and only to discover that there were small typos on the statement, and those typos were corrected, and a corrected statement was sent. Nothing in the statement changed, except maybe you could say the most substantial change in the statement was saying Advocate Paul Hoffman is advocate and SC. Everything else was just spelling corrections. But if you want to make an issue out of that, and we use taxpayers' money to quibble about that, be my guest, sir.
Okay, now I will be a guest, Madam, especially if there's a possibility of criminal conduct. I think the taxpayer will be very interested in that. But okay, let's just take it step by step. Am I correct that in your letter of 20th of February, you invited the public protector's team to indicate
What you called truly relevant matters before you prepare your statement, that where she still needed answers from you. That's what you invited the team to do, correct?
Yes, I did.
Right. And in response to that invitation, the public protector's attorney then wrote a letter to you on the following day, the 21st of February. Firstly, indicating to you that you had made a mistake in indicating that there was only one issue, but that there were two. The issue about the spelling is a non-issue really. The substance was that you had indicated that you were only going to be testifying on the CX matter. And we indicated to you that even on the version of the chairperson, which we didn't agree with, you were supposed to do two matters.
So you harbored that issue on the 1st, and I guess you were paid for that time. I dealt with it earlier. I don't know what else must we do with it.
I think
But also, can I
just answer the question, ma'am? I think it will assist us if you just answer the question.
Can I just finish also? That my answer is yes, there was quibbling about, no, you don't cut me like that, say. There was quibbling about that, you, but in my earlier statement, please don't talk over me. In my earlier statement, I had also indicated that you compacted the quibbling to those two matters, yet the real confusion was around whose inquiry is this? And all of those vague statements where you say, oh, courts have made these remarks about your cases, what is your comment on that? So I wanted to know, number one, am I being investigated now? And two, which cases? Must I go all over the internet to find out what have courts said about my cases? And three, I specifically mentioned to you that as far as I know, no court has accused me of not understanding the Constitution or being dishonest. Those were in those letters, say, we can't reduce it to how I spelled CS and the matter of the two cases.
Okay, ma'am. Okay. can I ask you to please firstly listen to the question and then just answer the question that is asked of you. Then we will get somewhere, because on your theory, I don't only get paid by words I utter, but even the words I listen to. So let's not make them too many. I'm asking you a very simple question, that in response to your invitation for us to indicate which other areas other than CX that we needed answers to. Number one, we indicated to you that the other issue is Friede, because that's common cause that was from the chair. That's what we did at paragraph 6 of our response, correct?
Yes.
Thanks. That's now we're getting somewhere. And then the other issue where we corrected you was to say that it is false to state, as you stated in your statement, that the public protector's team had, quote, forbidden the evidence leaders from assisting you with a statement. And we said, please indicate to us who advised you of that non-existence fact. That was the second issue that we raised in that response, correct?
Yes.
And as it happened, the Secretariat, I think, without our knowledge, had also sent you a letter indicating that that allegation was incorrect, right?
Yes, sir.
Thank you.
That was my mistake, which I admitted.
Yes, and which you apologized for, which apology was accepted. So,
And which you dealt with last week and you're dealing with again today.
yes. What did you give evidence last week?
Well, it's on the record.
All right. Okay. Anyway, so at least we settled the fact that it was at your invitation that we indicated those areas. Good. Now let's come back to this issue of the statements. You were aware that
I'm sorry, sir. With your permission.
Yeah.
You see, giving answers out of context.
With the chair's permission.
With your permission, Chairperson,
Yeah.
can I just clarify that Advocate Mkhwebane, let's not mislead the committee by narrowing. If you're going to quote that letter, put the whole letter on record. Because yes, it was at my invitation, but in response to your previous letter, where I was saying I am confused about all of these matters that you've raised. And this is what the chair says I should do, and you are saying I must do something else. And you ended up actually providing new issues instead of clarifying my question. So it's important that we give those who are going to judge this matter context and not be selective about the evidence we put on record. You must bear in mind that I'm representing myself here. And therefore, when I feel that there's a need to put all facts on the record, I will say so with the permission of the chairperson.
Right. Okay. Now, you are also aware that there was, shall we say, confusion as to whether you were called as a witness by the committee or by the public protector. Were you aware of that?
No, I wasn't.
Yeah.
I was very clear from the beginning that only the public protector wanted me as a witness, because the committee had discussed with me earlier the possibility of me being a witness, and that was abandoned because my response, as I said in my earlier statement, was there's nothing I can say that can change what the courts have said on the matters that you want me to be a witness on.
All right, okay, fine. Okay, maybe then the confusion was not on your part, but I suppose you're saying you are still clear when you received a letter from the chairperson dated 9 February 2023, where it says the committee has offered assistance to all witnesses who have requested it, but such assistance is limited to the drafting of a statement under the auspices of the evidence leaders as settled and signed by yourself. The committee will certainly not be in a position to provide you with any assistance beyond this, and so on. And also further down, the chairperson, should you require the assistance of the evidence leaders to prepare a statement, kindly contact the committee secretary. Even with that, you still regarded yourself as a witness just for the public protector. Am I right?
Absolutely. My understanding was that I've been called by the public protector, but I am a witness owned by no one. Read my letters. In all of the letters, I say, I do not understand myself to be owned by any particular group. Well, I'm paraphrasing myself here. I teach on investigations. I wrote the investigations manual of the public protector. I also teach on commissions of inquiry. So my understanding is that witnesses are really there to help find the truth wherever it is. They're not supposed to be embedded with any party. And this was what I said in my letter to Advocate Mkhwebane's lawyers.
Yes.
I didn't consider myself owned by anyone, say.
No, that's fine. That's fine. I've already said that the confusion must have been on our part only, but I'm just explaining to you where it came from. Well, for your information, in this particular inquiry, when the evidence leaders call a person, they prepared a statement for that person. Even when they subpoenaed a person, in this case, Mr. Kekana, then they prepare a statement for that person and lead that person. And the same with us, when we have called a person, as we did with Ms. Mviana, we prepare a statement with her and lead that person. But
Sir, may I say a word? No, sorry, sir. With the chairperson's permission, read the first letter from the attorneys, the one that I missed for a long time. It didn't say it was compulsory that I should be assisted by the attorneys. It said that if I so wish to be assisted, I can be assisted.
Yes.
So what you're saying, you seemingly saying something different from what the letters said. Even the last letter said, if I so wish, the assistance may be provided. And I chose not to be provided with that assistance. And I insisted that I want to do this independently.
No, that's also not entirely correct. You said that you preferred to do the statement with the evidence leaders, didn't you?
Well, for the first time, the first letter, it was with the evidence leaders because they had already offered and we were going to do it on the 20th. But my last letter indicated that I preferred to do it independently. No, my last two letters actually said
no, that's fine. So in other words, the only, yes, fine. So you would do the evidence leaders or independently. So the only people that you were not prepared to do a statement with was the public protector's team.
Certainly.
Good.
Precisely because of the kind of questions that had been asked, it didn't seem to me that I am a witness to assist with providing evidence that could assist your client to explain herself to Parliament. The questions that I was sent in the very first letter were accusing me of certain things. And how are you going to have your statement prepared by somebody who already appears like they're trying to throw you under the bus? Why would you do that?
All right. So just a minute. So these are the issues that we had wanted you to assist us with.
Yes.
Firstly, it was the two witnesses who had accused you of ill treatment, and we wanted to give you an opportunity either to explain that away or to put it in its context and so on. Do you think that's putting you under the bus?
Absolutely. This is not an inquiry into my conduct. To write to me about two witnesses, at that stage, I didn't even know who were they. Your letter just simply said something about Mr. Mkhwebane, Mr. Siyabi. I didn't even know at that stage who that person is because, sir, I have not been a public protector for almost 6 years.
Okay, all right.
So
And,
to say to me, I should randomly answer to those questions. In fact, can you read onto the record all of the questions that you asked me to answer in the first
Yes.
letter, and all of the questions that you asked me to answer in the second one?
yes, no, I'm not going to read the first one because that was overtaken by events. But the second ones, which we responded to you at your invitation, we started with the two issues that I've just mentioned now. Your alleged role in the ill treatment of Mr. Nyatela by the Office of the Public Protector. The second one was the alleged role in the ill treatment of Mr. Siyabi by the Office of Public Protector. We've already covered that. The third one was relevant human resource issues and policies regarding security clearance issue. And you regarded that as well as putting you under the bus.
Certainly, sir. You say
Okay.
you were asking me to respond to allegations against me. This inquiry
No.
is about
Okay.
allegations against Ms. Mkhwebane, not against
Yes,
me.
yes, just hold on,
Please, yeah.
Honorable Maute. Please conclude, Advocate Madonsela, and then I'll go to come back to Advocate Mpofu.
Yes, firstly, at that stage, I didn't know who Mr. Siyabi was.
No, I'm
And-
not there.
and-
I'm talking about 7.3 now, ma'am. Relevant human resource issues and policies. You've already answered the Siyabi Nyatela issue. I'm saying relevant human resource issues and policies regarding the security clearance issue. Did you regard that as putting you under the bus or not?
I regarded that as irrelevant. Let's use the language that I used in my letters. I would say, what is the allegation, against who, and what's the relevance to this inquiry? Please on the record say exactly what I said to you.
Okay, thank you. Just pause, Advocate Mpofu. Honorable Maute.
Yeah, no, thank you, Chair. I didn't want to interrupt as well, my apologies, but I need to raise this with you, Chair. I tried to call Tembinkosi as well. He's not picking up. I guess it's because he's operating there. The president of the EFF, Honorable Julius Malema, has been trying to log on since 10 o'clock. He's being parked somewhere on the passage. Can he be allowed to enter the meeting, please?
Thank you, Honorable Maute. IT, please attend to that matter. If there's a member in the waiting room, do we have a member in the waiting room? Okay, they say there's nobody yet, but I'll ask them to watch that space to attend to that. Thank you for that, Honorable Maute. Over to you, Advocate Mpofu.
Thank you. Madam, let's go back to what I said. If you please listen to the question and then answer that question, it will get us very far. These are your words. You said that the things that were asked were putting you under the bus. So I'm simply using your words. I'm saying whether asking you to assist the committee in relation to relevant human resource issues and policies regarding the security clearance issue, if you regarded that as putting you under the bus, yes or no?
No, I didn't regard it as putting me under the bus, and neither did I say that in my response to your lawyers, to which I still don't have a response back.
All right.
Thank you. Just
Then-
a pause, just a pause.
Sorry, Chair.
Honorable Maute, I guess that's an old hand. Please remove it so that I can see when it is a new hand.
Yeah, it must have been old hand, Chair, but still, Honorable Malema is still on the waiting list there. Can they please allow him in? He's got the correct link. Negotiator says must give him the correct link. He's got the correct
No,
link.
thanks. They are looking for him. Maybe the issue will be the correct link because in the waiting room, he's not there. So forward him the correct link that you used to enter as well, because that will be the correct one. But in the waiting room, he's not there yet. He's on his way, but there's a problem of a link, I'm sure. Advocate Mpofu?
Thank you. Okay, good. So that one is not putting you under the bus. Then the next one was administrative obstacles such as budgetary constraint. You regard that as, I'm sure you don't regard that as putting you under the bus.
The response I put there was, what's the relevance?
Yes, just answer the question, ma'am. I'm sure you don't regard the issue of administrative obstacles such as budgetary constraints as putting you under the bus.
Mr. Advocate Mpofu, I use the under the bus quip as an add-on. Are we going to latch on to a footnote? Surely you didn't come to this event prepared to latch on to a footnote. Can we deal with what we came for?
Can you please answer the question, Advocate Madonsela? Or do you want me to ask it for the third time?
Well, okay, I don't know, because the questions were vague. I had no idea whether the intention was to put me under the bus or not.
Oh, I see. So now you didn't know whether it was the intention. I thought you said that was the intention. Okay, that's fine. And then the next one was
on the record,
governance.
on the record, it would say differently.
All right. And then the next one we said we'd ask you on governance issues and audit outcomes. Do you regard that as putting you under the bus?
I regard it as irrelevant.
But not putting you under the bus?
I'm not sure, depending on
Not
what
sure.
was intended with it. Anything that was vague was potentially trying to put, not putting me under the bus, trying to.
I see. And then the next one was the management of backlogs and other performance challenges. Under the bus?
I don't know.
Don't know. The next one was scathing remarks made by the courts in respect of some of the reports issued during your term. Under the bus?
Irrelevant, sir.
Okay, but not under the bus. Then the next one was the impact of especially the EFF versus Speaker, the Nkandla judgment on the frequency of court challenges and the spend on legal fees, as well as clarity on the question of which version of the Executive Ethics Code you applied in respect of the Nkandla investigation and others. Under the bus?
Irrelevant. I am going to, when we are done, I am going to ask for permission to read the letter to this committee.
All right,
So that
no,
we
that's
can
fine.
stop playing games.
No, the letter is before the committee. I'm just.
Yes, but I would like to read it for everyone who's listening so that the auditory.
You are here to
perception
answer
is
questions,
useful.
please. I'm saying I've just read you the 8 issues which we gave to you at your invitation, and none of them seem to be putting you under the bus, or you don't know whether they put you under the bus. That's fine. That's let's leave it at that, and let's go to the statements now. The affidavits, or so-called, okay, let me put it this way. And this is the context I wanted to put to the chair before. The reason, madam, that we offered to assist you with a statement, as we do with all witnesses, and as evidence leaders do with other witnesses, is because we are, as you know, trained to do this. We do it almost day in, day out. And quite frankly, whether you were going to do it with the evidence leaders or us wouldn't make much difference, except that it would simply conform with the requirements of the law and the requirements of this committee. So let me just make it clear
that response to that.
No. Okay, let me context. Yes, you'll have your response, but let me contextualize what I'm saying. Your first issue was that the reason why you rejected our assistance was because there were things that put you under the bus, which turned out not to put you under the bus. I'm now telling you the reason for offering your assistance was not to put you under the bus, but simply for you to be assisted as somebody who might not be conversant with the practice of law and how these affidavits should or should not be done. That's all. That's really why we assist all witnesses. And
can I have a response to
I'll
that,
show you
sir?
just now that you actually needed the assistance. Yes, you
Okay.
may.
Can I just firstly clarify the under the bus? I
Yes.
said the questions that were putting me as an accused person were trying to put me under the bus. I have not suggested that everything that was in those questions was trying to put me under the bus. I said in my opening statement here, with you listening, that my objection to those questions was they were vague and their relevance was questionable. So let's just put the record straight. And secondly, regarding the affidavit was the very first affidavit was looked into by a commissioner of oath who is a qualified attorney, just like you. And in any event, being a qualified person who does all of those things every day does not necessarily mean you're the only authority who can do those things.
I see. So that relates to the first statement, correct?
The first statement, which just had typos.
No, but I thought you said there's one statement. So how can you have a first statement?
There's only one statement,
Okay.
Advocate
Okay.
Mkhwebane. Are we trying to play with words here, sir? Again, every minute is wasting taxpayers' money.
All right.
It is.
Yes, no, that's fine, ma'am. We'll try and save the taxpayers' money by make the first important thing you would accept, at least, that it's important for this committee to understand whether or not there's an affidavit before it, so that if there is, then we go through it. But if there isn't, then the law must take its course.
Well, that is important, but I would have thought, for me, just from a commission of inquiry type of investigation, that's a point in limine that should have been resolved last week. The chairperson announced on the 2nd of March, exactly a week from now, that the affidavit that was going to be used today was the affidavit that I sent as corrected on the 28th of March, which was the very same affidavit that was sent on the 25th of March, but corrected for typos and signed by a different commissioner of oath who has a business in Joburg, but lives here in Somerset West.
All right.
And was
No,
with me here.
I think you are missing the point. Maybe let me assist you. There is no affidavit by you, but we'll come to that just now. I'm saying that, do you know that you are, all right, let's start with the first affidavit, as you call it. It's dated the 23rd, and then there's a correction, it's changed to the 25th. You remember that?
Advocate Mpofu, there is one affidavit. It was sent on the 25th, and you know yourself that things can be corrected and annotated on the side where there are corrections. And that affidavit was replaced by one that was sent on the 28th. You didn't object to that affidavit. You had a whole week to say that's not an affidavit. To come now and decide that you're going to spend taxpayers' money arguing about whether the document on the 28th is an affidavit or not is shocking, to say the least. But anyway, no, well, it's the park protector that's paying, it's not me. So maybe I shouldn't be dealing with that.
Yeah, maybe not, ma'am. But
as a taxpayer, it worries me.
Yeah, no, that's fine. Well, as a taxpayer, it also
Chair.
worries me when it looks like there's a
Chair.
crime that is committed here. But do you know, maybe let's do it like, do you know that you may not correct an affidavit after it has been attested? Chairperson?
Sorry, what's that?
What do you mean, what's that? Don't speak like you are in a crawl.
No,
What do you mean,
you
what's
have
that?
not raised your hand,
We're in
Honorable
a
Malema.
meeting here. Don't say what's that.
You
What's
have
that?
not
What do
raised
you
your
mean?
hand, Honorable Malema.
I'm raising my hand. I'm raising
You have
my
not
hand.
raised it.
But
You
I'm
have
raising
not
my
raised
hand
your hand.
now. I'm raising it.
No, you don't raise it like that. You know how to raise a
How
hand.
do I raise it?
You know how you got in here. You use the same tools to raise a hand. Honorable
Yeah,
Malema.
but I don't know how to raise a hand here. I'm trying to get your attention.
Then if you can't
and then you
raise
can't
a
start
hand,
by saying what's that instead of
Honorable Malema,
recognizing me properly. Don't say
Honorable
what's that.
Malema.
Why do you say what's that?
Honorable
Don't talk to me
Malema.
like you are talking to a garden boy. Where man.
I am speaking to you now. If you can't raise a hand, you call a point of order, I give you attention. You don't just get into a conversation. It's
I'm
not how
trying to get your
done.
attention, Chair. I'm trying to get your attention.
I'm now recognizing you.
Please speak to the witness, not to interrupt Advocate Mpofu, because it doesn't come across as being dignified, and it's irritating to say the least. Let her give her a chance, because watching from here, when she just budges and interrupts the way she wants with the advocate, it doesn't look like the required decorum of these proceedings. Please.
Well, thank you, Honorable Malema. And that's not a point of order, but I hear what you're raising, which we attended to earlier before you joined, about the interactions and each waiting for the other, but also speaking through the chair. I attended to that, and I'm going to be watching that space. Thank you. Over to you, Advocate Mpofu.
When you say each waiting for the other, are you suggesting that I interrupted her?
No, I'm not.
Okay, thank you. Thank you, sir. Madam, Professor.
Yes, sir.
Yes. I was just asking you whether you know or you don't know that an affidavit cannot be changed after it has been attested.
I stand to be corrected, sir. My understanding that you can correct it, provided it's a proper procedure. That's why the affidavit of the 28th was attested to by a commissioner of oaths.
Yes.
It wasn't just changes randomly on the street.
But the second one, where you changed by putting hand changes, seems like it was just changed in the street, and it was changed after the public, or rather after the commissioner had signed it. Let me demonstrate that to you, ma'am. Can you put up the first affidavit? That's 31.6.2. Tsepo. Right, just go to paragraph 5. Right. 5, yeah. Okay, you see in paragraph 5 that it says the contents and intended appearance are in response to the letter of the chairperson of the committee, Honorable Q.R. Janji MP, dated 1st February 2023. You see that?
Yes, sir.
All right. Now, that version was then signed by the Commissioner of Oaths on the 25th of February, correct?
Yes, sir.
Yes. Now, after that, you then went to change that date to the 21st, correct?
Yes, sir.
Do you know that that is illegal? You cannot do that. Once it has been signed by the Commissioner of Oaths, you can't then change the date on your own in the street, as you call it. Do you know that's...
Can I explain that that's not what I did? Is it okay if I explain, sir?
No, firstly, just answer my question, then you can explain. Do you know that?
Yes, I do.
It's not done. It's illegal.
Yes,
okay,
I do.
Fine. Then you can explain.
Yes. I did not change the original affidavit by hand. I took a copy of it and I made the changes. You must look at the email that was sent on the 1st of March to everyone. The email explained properly that what we are doing is we're not replacing the affidavit of the 25th with the handwritten. We replaced it with the electronic version. And that electronic version was signed by a Commissioner of Oath. In my wisdom, which seemingly now seems to be turpitude instead of rectitude, I wanted to make it easier for the committee, because it was now short notice, to see what's the difference between the affidavit signed by a Commissioner of Oath on the 28th and the affidavit signed by a Commissioner of Oath on the 25th. So the handwritten version was just for ease of reference, and the email says so. I'm certain that the Secretariat can produce the email that was indicated.
Okay, then maybe let me assist you. If you know that it's illegal to change an affidavit by hand after it has been attested to, then can you go to the second affidavit, Seppo? 31.6.1. Right. So, okay, at paragraph 5, you did exactly what you say you know is illegal, which is to change the affidavit by hand after it has been attested to, and then you put your initials next to that paragraph, correct?
I have explained that this was to just show the committee where the changes are in the proper affidavit. I never proffered this as the new affidavit. I proffered the affidavit of the 28th as the new affidavit, which is the affidavit that has since been accepted by this committee.
Yeah, wrongly. That's what I'm getting to, but don't worry, we'll get there. We'll get there. I'm simply saying here, just on what is on the screen now, is it correct that you did what you say you know is illegal, namely to change the 1st to the 21st, and then you put your initials next to that?
Well,
yes,
I didn't change. This was a copy of the affidavit. for the
Okay,
purposes of
I'll take it.
the committee.
Yeah, all right. I'll take it. You don't want to answer the question. That's fine. And you did the same thing on page 2, Tsepo, where you again by hand change the affidavit and put your initials next to it illegally, correct?
I will admit that all of the changes that are now in this affidavit and in the one that is supposed to be the basis of the discussions today were changes that I made, which are typographical in nature. If you want to make them illegal, say, so be it. But if I knew, this is where I say points in limine should have been discussed, because you are now accusing me of criminality. Chairperson, I am now a criminally accused person. I asked for legal representation. I was not granted. And when you wrote to me, Chairperson, you said you don't need legal representation because you're not an accused person in this process. You are in this process to assist us in an investigation against Advocate Mkhwebane. So we dealt with this issue 1 week ago. These matters were not raised. If Advocate Mpofu wanted to raise these issues, he shouldn't be ambushing me right now. He should have raised them last week, and I should have gone for legal representation. He was not prepared to proceed with my affidavit for short notice, but he thinks it's okay to ambush me with issues of legality right now without having even just been sent a written notice of it. Forget about 7 days notice. So
yes. You remember me last week saying that we will have to raise issues for this committee regarding these statements which may be referred to the police?
Well, I don't remember you saying that, but if you did say so, I'm still saying it's a point in limine that should have been discussed last week.
But nothing was, sorry, ma'am, sorry.
You're speaking over me.
I'm sorry. Nothing was discussed last week.
But you're speaking over me.
Just allow her to continue to conclude, Advocate Mpofu. Please go ahead, Advocate Madonsela.
Right. This meeting today was convened by agreement. On the record, the chairperson, on the record, you said the statement that was going to be discussed is the statement of the 28th, or the corrected version of the 28th. And this was after Advocate Abraham had said that that's the statement that I'm prepared to go with. If Advocate Mpofu wanted to put me on trial for how the changes happened between the statements happened, he should have indicated last week, Monday, that he wants me criminally charged for that, in which case it changes the complexity of this event today.
No, ma'am.
I should have then had a lawyer to come and represent me because I'm now being accused of criminality.
No.
He insisted last week that he needs me as a witness on those matters.
Okay.
When he was saying why he needed me, he didn't say he needs me to answer for this statement. I remember when you had ruled, Chairperson, that this is the end of the matter.
Thank you, Advocate Madonsela.
Yeah.
I think you have canvassed and ventilated the issues quite firmly. Thank you for that.
Thank you.
Advocate Mpofu, I just want to go to a break. So if there's something you want to raise quickly before that.
Just to round off this statement. Okay, ma'am, I'm not accused you of criminality yet. I'm simply saying that at least I thought we were together. You agreed that to change a statement that has been attested to after the Commission of Oaths is illegal. We agreed on that, and you are right. Now, I'm simply demonstrating that you did exactly that which you and I have agreed is illegal. That's all really. And maybe just because there's going to be a break, let me short circuit this. At paragraph 5, paragraph 6, paragraph 7.3, Tsepo, maybe you can just run those so that for the witness to see. Paragraph 8.3 twice, and paragraph 9.6. So it's 1, 2, 3, 4, 5 places you did that which you have admitted is illegal by changing the statement by hand and putting your signature next to it at that point. That's the only point I want to make. Then we'll move to the third statement. Are you following?
May I just respond to that, Advocate Mpofu? Again, I've canvassed the issue of what you're doing, even by your standards, may be quite low. If you intended to accuse me of illegality or criminality, you had the time last week to say today will not be about the contents, it will not be about merits, it will be about accusing me of criminality or illegality. You didn't do that. And I disagree with you that I deny that I did anything illegal.
Okay.
All I admit to is I indicated where the changes in the electronic statements are. Last week, just my last word on this, last week when you had an opportunity to indicate why you want me today. On this matter, the only thing that you raised as an issue about this statement was the fact that the stamp of the Commissioner of Oaths of the statement of the 28th was in Joburg, whereas we claimed that this happened in Stellenbosch.
Okay, ma'am.
The evidence leader read the law to indicate that it's okay to have a business stamp for a different place, but if it can be confirmed that the statement has been done where it claims to have been done. So that was all that you raised. This incremental approach is quite shocking.
Okay, ma'am. All right. I'm sorry to shock you, but all I'm saying is we have to establish whether there is indeed an affidavit before this court. If you were all you were doing was to indicate, for example,
not the court.
No, the committee.
Yes.
Well, if you were to indicate, if you merely wanted to indicate that the first should be the 21st, then why did you put your initials next to that? Because
I wanted the committee to see where the changes were.
For the committee?
Yes, the statement was being sent to the evidence leaders, and it was literally around 10 a.m. when the event was starting. And it was important for whoever, I'm sending the electronic statement. You remember you raised the hullabaloo at that stage about the fact that you've been sent a 9-page statement. It turned out that it was 8 pages and one of the pages was repeated. So the statements were sent simultaneously to make sure that you could see from the handwritten version that this is where the changes are in the signed statement. It was sent as one email. It wasn't sent as 2 separate emails.
That's fine. Okay, well, I'm going to demonstrate, not now. The reason I'm asking you these questions, ma'am, is that you are here. So it's important for you to answer for yourself. Otherwise, if I raise them in argument when you are not here, that would be unfair. Let's just round off that issue by saying that I will demonstrate that what you've just said is completely untruthful. If you are merely indicating the changes, then you wouldn't have signed against them. And some of them, even the Commissioner of Oaths has signed against those changes, which, by the way, is the correct thing to do. But it's only you who has signed them, that is completely illegal. I think let's leave it there. Either you know that or you don't. That's I can't help it. But we'll then move to the next.
Can I respond to that? I deny what you're saying, and I think it's really low.
Thank you, Advocate Madonsela. Honorable Sukas, we are almost to a break, but let me hear you out.
Yes, Chair. Chair, I would like for Advocate Mpofu to please tell the committee what is the relevance of this line of questioning. Advocate Thuli Madonsela came here to answer or to speak to evidence relating to two cases. We've now spent almost half a day on this. Not half a day, but certainly a significant amount of hours. What is the relevance to that? Secondly, Advocate Madonsela is not here for oversight. She is not. And none of what has now been discussed or been questioned has to do with the aim of this inquiry.
Thank you, Honorable Sukas. Honorable Malema.
Advocate Mpofu is well within his right and is correct to ask the questions that he is asking, because we can't have defective papers before us, or to a particular extent even be told lies, and then we say it is not what Advocate Madonsela is here for. Advocate Madonsela's credibility and whatever he has put in the affidavit or the letter, because we are still not even sure if these are still going to be referred to as affidavits, have to be questioned so that at the point of deliberations, we don't get shocked. And that Advocate Mpofu has made that point, that I'm raising these points because during deliberations, I don't want to be told that I was unfair to you. We should all be worried that a committee like ours, even when people are not here as accused, they can come and lie here. Then it's a waste of time. No one must come and lie here. And if there is anything that suggests there is a lie, it must be exposed. If it's a correction, why does it have signatures of two people? Why do you need a signature of Commissioner of Oath to show that, no, I was just making a correction of a typo? Because that is not the document you are going to use. The document you are going to use is the one that I've given you with those typos. This one I'm just correcting for ease of reference. But you use the Commissioner of Oath to even attach a signature. To me, it's clear you were making amendments to the original document, and as they say, it's illegal. But that point will come, and it can only come if it has been exposed through this line of questioning.
Thank you. I will recognize you, Advocate Madonsela. Thank you, Honorable Malema, because I'm going to try and make a summary and make a ruling on this issue. Advocate Mpofu?
Yes, thank you, Chair. Chair, in fairness to the witness, I think the point has been made now repeatedly that she needs to be given an opportunity to respond to this. But the principal point I was making, Chair, is why we offered to assist her, so that these illegalities would not have occurred, because we know that she's not a practicing lawyer. And the only point I want to make before we take the break, Advocate Madonsela, is this. Even on your version that these were just corrections, that is completely false, because on three occasions, both you and the Commissioner of Oaths have signed on these so-called changes after the commissioning, which would amount to an illegality on both your parts. And then on 1, 2, 3, 4, 5, occasions you only signed on your own. Just that inconsistency. Either you were going to sign on your own or sign with the Commissioner of Oaths. But
May I assist?
those things, sorry, both of those things cannot be correct. The correct one, as you should know, is the one where you both signed. So where you've just signed on your own is incorrect, is illegal on your part. Where the Commissioner of Oaths has signed on his part after you have already commissioned, then that's illegality on his part or her part. That's really the gist of this. And it's not a small matter. This is Parliament. It is the Parliament that passed the law that defines what an affidavit is.
True.
So if this Parliament was just playing games when it passed that law, then they will tell us. But I'm sure they were passing that law for a reason, so that people don't come and misrepresent the truth. And so that is the importance of this exercise. And finally, sorry, Chair, finally, the issue is really as to whether there is or there isn't an affidavit before this committee. But we can round that off. I hope you understand those. Do you?
I disagree. Can I explain and assist you this time? Assist
I don't need your
I'm
assistance,
not being
ma'am.
paid to assist you.
No, I don't
Can
need
you
your
please-
assistance, nor your snide remarks, ma'am. Please,
I
you're just
do
here
want
to ask
to assist
questions,
you.
not to be sarcastic.
Okay.
I do
If
want
the
to
chair won't
assist
stop
you.
you, okay, I know the chair is not stopping you from all that. You've been insulting me and
Please
being
don't
sarcastic.
speak over me.
No,
I
no,
do want to assist you.
just pause, Advocate Madonsela.
I-
Can you conclude, Advocate?
Yes,
You must
thank you.
tool a man. Hey, Chair. Ah.
Okay, no, Miss Advocate Mdntv, I'm saying to you, and I'm saying it as kindly as I can master, despite all your insults to me this morning, I'm saying that now you're speaking over me. All right, let me start
Sorry,
again.
sir.
It's fine, apology accepted. I'm saying, ma'am, that I'm making 3 points here, and either you understand them or you don't. One is that your version that these were merely indicative changes is belied by the fact that you signed against it. Secondly, the fact that on some parts only you signed for it, which is wrong, and then other parts you and the Commissioner of Oaths signed against it, shows illegality on both your parts. And thirdly, I'm saying it's important for this committee to know, because our directives say so, that witnesses should make an affidavit. Witnesses are free not to make an affidavit, but once they purport to make an affidavit, it has to be an affidavit. Do you understand that or not? Well, I'm not saying you agree with it, but do you understand that?
I don't understand your logic, sir.
Okay, well, that's fine. Then maybe you can go and let's take a tea break. Maybe.
No,
No,
I'm
before then.
the chair. Sorry. Thank you, Advocate Mpofu.
I mean, Chair, no, sorry, sir. I'm not
Thank
taking
you.
over your meeting. I'm
Thank you.
saying
Thank you.
on this
Thank you, Advocate
segment.
Mpofu.
Yes.
Over to you, Advocate Madonsela.
Thank you, sir. What I wanted to assist Advocate Mpofu with are 2 points. There's one document on the table in 3 articulations. It's a 4-page affidavit. It was signed before an attorney who is a director of the law firm where he is on the 25th. On each page of that affidavit, both he and I initialed it, and it was sent to the committee. So now Advocate Mpofu has not only insulted me and criminalized me, he has now criminalized a fellow member of the bar by simply failing to read documents that he's paid to read. That affidavit of the 25th is in the document pack, I hope. And in any event, it was sent to the attorneys that are instructing Advocate Mpofu. The signature of the attorney who assisted me is at the end on page 4, and he's initialized all of the pages. So to fabricate lies here and suggest that those signatures only appeared during the corrections is shocking, to say the least. And again, this could have been corrected if we had had a pre-trial kind of hearing to clarify these things instead of trying here to play games. I've indicated that there are 3 articulations of one document.
Okay,
I have not proffered to this committee the version that Advocate Mpofu is latching onto as the document on the record. The document that I've offered to the committee was the version that is electronic, where the changes are made, and therefore a new commissioner of oath signed that document, precisely because we realized that if you made changes on the previous document, it would be a problem, legally speaking. Hence, a new commissioner of oath signed the document that I came to this committee today, understanding with the basis of our discussion. But 2 hours later, we are discussing things that should be discussed at a pre-trial conference, and certainly between learned friends, being the evidence leaders and the lawyers before we come to these events.
Thank you, Advocate Madonsela. I want to make a ruling before we go for tea, but I see the hand of Advocate Mayosi. Nobody wants tea today, but I'll have to make that ruling before tea. We've been at it for some time now. Advocate Mayosi.
No, Chair, I'll retract. You could proceed.
Okay.
Chair, please bear with me. I know you want to go to lunch.
I want to make a ruling,
to make a break, but can I just make a response just by one point? Advocate Mdntv, yes, ma'am. Okay. What you have just said is completely untrue, and I'll demonstrate it to you, ma'am. You said that where the public protector, sorry.
Can't be untrue.
All right. You said that you've just said now in your last answer that in the versions that you rendered to the committee, all the pages were signed by you and the Commissioner of Oaths, correct?
May I answer, sir? In the first version of this affidavit, the first version of this affidavit, being the one sent on the 25th, was signed by the Commissioner of Oaths. He never ever signed anything else after that.
No, that's not true. Let's go to that.
Sorry.
I just wanted to start with something else when I come back.
No, thank you.
Okay, let me just summarize then.
I want you to pause there now.
Can I summarize? The witness can either confirm or not. Okay. This is the truth, madam. On the first version, you are right. On page 1, you and the commissioner signed. On page 2, at 7.4, you and the commissioner signed. Page 3, 8.3, you and the commissioner signed.
Yes.
But on page 4 of 5, 9.6, the commissioner did not sign. In other words, you are the only person who signed that. That's where it talks about Gogo Dlamini and all that. Do you admit that, or do you want to dispute it so that we can put it up after the break?
I dispute it. The document only has 4 pages.
Good.
There's
Very
no
good.
document with 5 pages.
Okay, that's fine. So at 9.6, your version is that both you and the commissioner signed.
The commissioner was just signing each page, the commissioner of oaths. He wasn't signing changes, except the one where he had made a mistake on the date.
No, that's also not true. He signed 4 times, but I'm saying
He signed so 4 times, of course, because he initialized each page.
Yes. Okay, ma'am.
He
Look,
initialized
okay.
each page.
Look, okay, let me just tell you, yeah, you've just made it worse. I think that the sum total, which I will argue at the end, is that none of your versions hold water or consistently appear through the statement, and none of the statements therefore qualify to be called an affidavit. And to the extent that either you or the Commissioner of Oaths breached the act, then those matters. Are you a member of the Legal Practice Council?
Advocate Mpofu.
Yes, ma'am.
I'm going to stop you now.
That's irrelevant.
I thought you were saying you're
honestly
summarizing.
think, firstly, number one,
Advocate Madonsela, Advocate Madonsela,
No, wait.
Advocate Madonsela, please pause. I want you to pause as well. We're now going to take a tea for 15 minutes, back after 15 minutes, and I will make a ruling. Thank you, so that we proceed.
But Chair, I'm still talking.
colleagues from the tea break. I had promised that we're going to, from the chair, make a ruling so that we proceed with our work. But before that, so that I'm fair, Advocate Mpofu did ask for the last opportunity. But before I go to you, I'm going to recognize Advocate Mayosi.
Thank you, Chair. Thank you. Chair, I don't want to interrupt Advocate Mpofu. I don't know how far he is with concluding on this issue, but I thought that it might assist the committee if you could perhaps indicate whether there is a problem with Advocate Madonsela's statement dated the 28th of February, because that is the statement that is before the committee.
Yes, thank you, Chair. Yes, that's a fair question. Yes, well, there's a problem with all the three versions, so that would automatically include that one. But that's not the issue. I mean, you can't tell us that that is the only issue before the committee. The committee has been presented with illegally signed statements against the, at least that's one thing that the witness and I agree on. But Chair, for the sake of progress, I'm actually going to move to that statement.
Yeah, I'm going to allow you to move to that statement, but I think that there's a
yes,
last issue.
Thank you, Chair. Just as a follow-up, Advocate Mpofu, could you just identify what the issue is then with the statement of the 28th one? And the evidence of the witness when you were asking her questions was that she didn't present the changed version as a statement before this committee. So there's a statement of the 25th, which as I take it from her evidence is replaced by the statement of the 28th of February before this committee.
Okay, well, Chair, if Advocate Mayosi wants to take the stand, I can indicate to her, but I thought it's better if I indicate it through the witness who's the author of the statements. But maybe if she had anything to do with this. Okay, the first, okay, maybe let me assist her for the sake of progress, Chair. On the first statement, the last question I asked, I indicated what the problem is. I don't know if you were following Ms. Mayosi, which is that on the last page at 9.6, only the witness signed and not the commissioner. Are we together on that one? Okay, good. So even if you wish away the second statement, where she makes handwritten changes and sometimes she signs alone, sometimes signs with the Commissioner of Oaths, that alone is a problem because there can only be one way of doing it. Though not both of those things can be correct. But I say for the sake of progress, Chair, if I can move to the statement of the 28th.
Yeah, yes, Advocate Mpofu, my ruling was going to go to that point.
Okay.
So are you now moving into that statement?
I am, Chair.
Okay.
Yes.
Let me allow you.
Thank you, Chair. Ma'am, Advocate Madonsela, Professor. Is the witness still with us, Chair?
Yes, she's with us.
I'm right, please.
Oh, good. Yes. Now, I want to show you that even the statement that you direct us to, which is the quote unquote affidavit of the 28th of February 2023, because I see your version and that of Advocate Mayosi is that we must forget about any illegality that might have taken place in respect of the first two statements. And because it's the statement of the 28th that is before this committee, right? Professor? I think
There
we've
was
lost.
no illegality. Firstly,
Yeah.
you made a mistake, sir, by saying that the Commissioner of Oaths signed the corrections, which means you did not look at the original affidavit, because you would have seen that anything that is signed by the Commissioner of Oaths is symmetrical between the statement of the 25th and the hand-corrected statement. So it would be nice if you were to withdraw that accusation of a fellow member of the legal profession by simply failing to look at the two statements together.
Okay, now you're bringing us back. Sorry, Chair, I was trying to avoid this. Can you then go to the statement bundle H, item 31.6? And I'll just deal with the front page so as to save time. Just the front page. Move up from a paragraph 4. Yeah, move up. Okay. Chair, are you able to remove those pictures of me and the professor?
Just minimize.
Or minimize, because we want to see the margins where the signatures are. Or well, whoever. IT.
Let's hide the pictures for now. Minimize.
That negative.
Take away the picture. Yeah.
Okay,
Yes.
you can see them now.
Thank you. Yes.
Okay.
You see there that the signature is just your signature. Sorry, I think that's the wrong statement anyway. That's the one of the 28th.
That's
Now
the
I want
wrong
the one. I want the one of the 25th. It's 486, page 486. Yeah, go down, go down. I mean up, whatever. Other down. Yeah. Further down. Yeah, that's it. Can you see that picture, Professor?
Yes.
Right. At the bottom, both you and the commissioner signed, correct?
Yes, as you will see in the original statement, it's exactly symmetrical.
No, just answer the question. At the bottom, both you and the of those three.
Yes, as in the original statement, it is symmetrical.
No, ma'am. Please just answer the question. At there are three. Go further down. I want all three to show at the same time. Yeah, like that. There's 1, 2, 3. The bottom one is signed by you and the commissioner, correct?
Yes, sir. As exactly as it's the same in the statement of the 25th.
And then
just play the 25th one, you'll see the symmetry.
That is the statement of the 25th, ma'am. I'm saying at the bottom, just answer the question. Don't worry about anything else. If I want something else, I'll ask you a question. At the bottom of those three signatures is you and the commissioner. Yes, no?
Yes, it is.
Yes. And at the top two signatures is just you. Yes, no?
This is where I was all by myself indicating the corrections. Yes, it is me, because the Commissioner of Oaths was not there. He signed all of the statements on the same day.
Good, thank you. So you signed there in the absence of the Commissioner of Oaths, correct? That's what you're saying.
Yes, because that statement is not what is presented to this committee. And I think Advocate Mayosi just indicated to you that the statement presented to this committee is the electronic version, which is signed by a Commissioner of Oaths.
Okay, then at least it's clear that on that page that we see there's inconsistency. On the one signature, both of you signed, and on the other two, only you signed. That's fine. Let's go quickly to the statement that you seem to be so keen to go to, of the 28th. Can you put that up, Tsepo? That's the item 31.6. Go towards paragraph 5. Yes, only you signed there, correct?
Yes, it is me only.
Yes, and so what you said before T is untrue, that you and the commissioner signed on the on the final statement, correct?
No, Mr. Ofu, are you trying to deliberately misunderstand me? Can I correct you if you're trying to
Yes, ma'am.
misrepresent what I say?
Yes, yes.
The statement of the 25th, which your team and the evidence leaders have, has my signature and the signature of the Commissioner of Courts.
At certain parts. At certain parts, we've established that is
on every page. That statement, don't play between the two statements. Play with the statement of the 25th separately, which, remember, your team received it and the committee received it through the evidence leaders separately. It was a 4-page document all by itself. It is signed by the two of us on every page.
That's a lie.
And that's why I was saying you should have read the two documents and not confuse them.
Okay, let's go to the statement of the 28th, ma'am. Let's not confuse anything.
Yes.
The one of the 28th is the one that you own. Do you agree that on what everyone can see now on the screen, only you signed?
Yes, sir. On the statement of the 28th, all pages were signed by myself.
Yes, and there's no signature of the Commissioner of Oaths on that page, either for the change or for for anything. There's just no signature of the Commissioner of Oaths. You accept that?
Yes, because it was now a new Commissioner of Oath attesting to the entirety of the statement and saying that as far as he's concerned, I have sworn before him that the statement in its entirety is a 4-page statement is
okay. Have you heard of the rule?
Nothing but the truth.
I'm sorry. I'm sorry, ma'am. I'm sorry to speak over you. Do you know or are you familiar with the rule that the Commissioner of Oaths must sign every page?
No, I am not familiar with that rule. If I were familiar, if you had asked me last week on Friday, he is here in Somerset West, I would have taken it to him to make sure that he signs all pages.
No.
Just a pause for the hand, Advocate Mayosi.
Thank you, Chair. If Advocate Mpofu could indicate which law makes it a requirement for the Commissioner of Oaths to signal, to initial every page, please.
All right. It's I'll give you the name of the act. The reason, let me show you how that you accept that the Commissioners of Oaths are ruled by the same rules. Madam.
I accept it, sir. I am just sad that you'd rather waste 3 hours when you could have raised this thing last week. There was an issue about the statement. Is it the right statement? Is it the wrong statement? And the chair ruled, with me having said there's nothing wrong with the statement, he ruled that this will be the statement. Had you said then, you have a new objection to the one you had, because on that day, the only objection you raised, sir, was that the Commissioner of Oaths signed with the stamp in Joburg, whereas he was here in Stellenbosch. Had you raised that, say, we would have not wasted taxpayers' money in 4 hours. I would have called him to come to my house or gone to his house to fix that and have a new statement for you.
Okay, no, it's not
7
fixable.
days.
Oh, no, ma'am, it's not fixable. You see, that's the whole point. That's the whole point of swearing to God and saying, I swear that the contents of this declaration are true, so help me God. Once that is done, you cannot alter that which you have sworn to God is the statement. Maybe you don't understand that part. But
can I respond to that?
Sorry, we will get the Commissioner of Oaths to give us an affidavit on all the contentious issues. But for now, I'm simply asking you, because you are the only one who's here, that let's go to.
Say,
Just before you go
Chairperson,
there, just before
Chairperson.
Madonsela, just before Honorable Maneli.
No, thank you, Chair. I just want to ask again, just for clarity on your side so that I know where we are. Chair, first, we were not supposed to convene on this witness as per the first ruling. But on argument put on the table, we were convinced to
Just switch
review.
off your mic, Advocate Mpofu.
Oh, sorry, Chair.
You were convinced to review the position of the committee, and you made that ruling that would use this statement of the 28th as the basis for the engagement. Assuming, Chair, that at that time there was no time to look at it in the meeting. Of course, we've had other days and that maybe something else would have happened. At least I would expect that there would be communication in this regard, that we may not be happy with the statement that is before the committee on the basis of its legality, right? But again, as we were starting now, I think one reasonably would expect that as a preliminary point, deal with whether there's question about the legal standing of this affidavit or statement that is before the committee, and that therefore the engagement you are having at this point is the motivation of the illegality of it. Because I make an assumption that if it's illegal, the advocate himself would not participate in illegality. So that at least we know what we are dealing with, whether we are in that motivation of demonstrating the illegality. Secondly, at least the last statement made now, that even if you try to fix this, it's not fixable. It's linked to the question that's not answered. And I thought, Chair, you would want the answer first to that question on which law. I think Advocate Mayose asked that, so that at least that matter is then cleared, and we know that we are listening to a motivation that the committee in its consideration should look at this affidavit differently, because it has already made a ruling to accept it and use it as the basis of convening Monday and Tuesday. Otherwise, from a point of the committee, there was no reason to go to convene, Chair. So I'm just saying, at least assist for a member like me who may not be in the legal space, but who really wants to participate in an inquiry of the committee, understanding that it's also not a court, and if there are other matters of criminality that needs to be pursued, there are channels to also deal with that aspect. So that's my point, Chair. As I say, I may be raising it because I'm swimming in confusion where we are. Thank you.
Thank you, Honorable Mandeli. I kept postponing the ruling, but Advocate Mpofu, because I need to rule so that we're able to get into the contents of the statement. And you were promising that you're going to the statement, hence I pulled back. I think you said you'll answer the question of Advocate Mayose. I did not want to rush you into that. I think the member is asking that you do provide that response.
No, Chair, I'm not going to be
on the floor.
Oh, sorry.
Switch off your mic. Thank you. So I'm saying I'm interested to hear that, because I can't hold back any longer in terms of making a ruling and directing these proceedings to a particular point instead of us being all over the place at one point. So I'm just going to give you that last opportunity to assist us on those issues.
Okay, Chair. I said, well, we're not here a legal argument at this stage. I'll give you and Mr. Mayose, Ms. Mayose and Mr. Maneli the name. It's a long act. I'll give it to you now about commissioners of oath passed by this parliament. I'll give you the section, but I wanted to short circuit this exactly for the reasons that Mr. Maneli is raising, just to make it easy for someone who doesn't have to read the Act. Chair, if you allow me, just 2 questions. I'll give you now, my team will get you that long title. Let's go to the statement of the 25th, Tsepo. This is going to be short, Chair. Yes, just go to the second page. We've already dealt with the first page. Go to 487. The bottom. You see that for that page, you and the commissioner, both of you signed, correct?
I have said the statement of the 25th is signed by me and the commissioner on all pages.
Yes.
Do you have difficulty flighting the original without the changes on it?
Okay,
because
that's
we
good.
really are wasting time.
No,
If
please,
we flight
ma'am.
the original without
please,
the changes, we would not have to keep.
You are
Answer the question.
Yeah, but don't interrupt her.
But she's not answering
Because you
the
can
question.
put your point that the question is not answered. It doesn't give you the power to interrupt her as she's speaking. We've come to this point.
I'm appealing to you,
much
Chair.
earlier on.
I'm appealing to you.
Thank you.
But
Please,
Chair, why
intervene.
are you not sitting on the same
Thank
chair as the witness?
Why
Why are you not sitting on the same chair as the witness?
Honorable
Because what you
Malema,
are doing
you've
is
not
to
been
protect
recognized
the
to
witness.
speak. Honorable Malema, you've not been recognized to speak.
Chairperson,
Just
you are abusing me
let
now.
me conclude this.
Okay.
I've addressed this matter early on, that you are not, there must be no interruptions. And early on, it was not done by you. It can't be right now that it is done by you before she concludes what she's saying. You must interrupt her, and then you complain to the chair that she's not answering the question. If you want to put that to the chair, then you will put that, but it doesn't give you the right to interrupt her while she's responding.
Okay, Chair.
Please conclude, Advocate Madonsela.
Yes, Chair, I'm sorry to correct you, sir. Earlier on, Advocate Mpofu did also speak over me, and I did call him on that. And if you play the record, you will find that more than once, he also spoke over me. But to the extent that I spoke over him, I do apologize, or spoke out of turn. I do apologize.
Thank you, Advocate Madonsela. Advocate Mpofu.
Thank you, Chair. You know, Chair, I'm trying to do this patiently. I'm saying, Chair, I've asked the question. The reason why we have you here as the chairperson is to assist all of us. I've asked the question, the witness, we've now taken 6 minutes on the question whether or not at the bottom of the page that she can see on the screen, there are 2 signatures. Yes or no? I mean, surely that must be the easiest thing to answer. To now get this whole lecture is uncalled for, Chair. We're on time schedule. You're going to tell me at a particular point to stop. And so in the time that's available, I must get as many questions and answers to those questions as possible. I'm asking a simple question. Okay, let me do it like this, ma'am, without showing you anything, because maybe that's where the problem is. In the statement of the 25th, did the Commissioner of Oaths sign every page?
Absolutely.
Yes. And then in the commission statement of the 28th, did the Commissioner of Oaths not sign every page?
True.
Good. Thank you.
Well,
so then,
just a correction. Sorry, sir. He did sign the last page.
Now you're allowing her to. to speak over me?
She had not concluded. Conclude.
Yeah, and the answer is yes. He didn't sign the first 3 pages. He signed the last page.
Great, great. Yeah. Now, thank you. So I'm saying, irrespective of the name of the act, which I will supply, I'm trying to simplify it as Mr. Maneli said we should, even for a non-lawyer. The one commissioner of oaths signed all the pages. The other one did not sign all the pages. Which one is correct of the 2 commissioners of oaths?
Chair.
I didn't know there's a competition between the 2 of them.
No,
I'm
ma'am,
not
please
a
answer the
commissioner of
question.
oaths. Yes,
No.
I'm not a commissioner of oaths. All I know is that I submitted to this committee the statement of the 28th that is signed by a commissioner of oath as the statement for consideration. And the chair ruled that that was the statement that would be the basis of these deliberations on the 1st of March. We are meeting on the 6th of March. Nobody came back to me and say, no, that statement will not be acceptable. And then you say, no, once you've said, oh, help me God, it's all gone. Well, oh, help me God, it was the truth. Don't try to imply just because the other pages were not signed on the statement of the 28th, there is a lie. I don't like the fact that you make statements at the end of things and then you jump to the next question. When you make a statement to me, let me respond to it. Thank you.
Okay, I'm moving away from this, but I just want to.
Or you move
Okay.
away. I've got my yours.
Thank you, Chair. Chair, because of Advocate Mpofu's line of questioning, I have to insist that he furnish us with the law that makes this a requirement. As far as I could see, the Justices of the Peace and Commissioners of Oaths Act contains no such requirement that a commissioner has to initial every page. Neither do the regulations governing the administration of oaths of affirmation. But if there's a different law that Advocate Mpofu is aware of, it will assist us in this line of questioning as far as this affidavit is concerned.
All right. Ma'am, when you were in your 7-year stint as the public protector.
So before you ask,
Yes.
so we now know the name of the act. It's
Yes,
just been
I know it too,
explained to
Chair.
us.
It was given to me.
Because we're waiting for it.
Yeah, so are you feeling better now?
Wait, I'm on the platform.
All right.
Don't create a dialogue,
Okay.
please. You've just asked me now to be the chair.
Yes.
Now I'm in that chair that you
All right,
want.
Chair. All right. All right.
So I'm indicating that we now have that clarity
Correct.
about that act. And there's a point that says quite clearly, and it's going back to you
Yeah.
in terms of within that act, what section of that act is really requiring that.
Right. Okay. It's the regulations, Chairperson. I don't have the act in front of me right now. If you want me to I can take a break of your time and go and find it. I'm trying to save that, and you are pushing me to give you a name of an act. What difference does that make?
Now, this is what we're going to do now. You asked that you're going to proceed.
Yes.
To the next point. I just want to indicate this now.
Yeah.
Your next point has got to be getting into the statement that brought us here for the following reasons.
Yeah.
When we met here on the 1st of March, and this has been quoted several times, we concluded in giving the directive that that statement which was corrected and cleaned up would be the statement that this committee was going to utilize for its own purposes, in terms of it being a written evidence. Okay.
Is it an affidavit?
Wait, I'm speaking. I didn't even give you to
Sorry,
speak.
Chair.
Please switch off your mic. And thereafter, as a chair of this committee, I wrote to the public protector to give a further opportunity, which is the proposal that you brought, to say, even though we've taken a decision to utilize that statement as part of our deliberations, we are offering you another opportunity to come today and tomorrow to interact with the witness, to which you agreed. There's never been any objection about whether that statement is now objected to because it's not legal and so on. So I regard the exercise that I've been very patient to allow it happen. It's now become a peripheral issue in relation to what we're here for today and tomorrow.
All right.
I want you to come and get into interacting with the witness based on the statement that this committee adopted here, that it is going to use for now in terms of the testimony, but also for its deliberations.
Okay. Chairperson, if I may just respond to that. Firstly, you are being extremely unfair. I said to you on that day, and I've been hearing the witness saying we should have raised this on the first, but there were no proceedings on the first. There was, at least I never interacted with the witness. But even under those circumstances, Chair, I told you that we have problems with these statements. That's number one. Number two, I told you that the statement of the 28th arrived at 10:13 while I was talking to you. I started talking to you at 10 o'clock. So when was I going to look at that statement and see all the defects in it when it arrived while I was busy addressing you? That's the second point. The third point is that, as you know, this witness has refused to consult with us. If she had consulted with us even after that time, all this would have been resolved with her. So the only and first opportunity for us to deal with this matter is now and here. So for you to want to suppress, and lastly, Chair, and very importantly, sorry, Chair, the most important thing, I've said this, I'm saying it, I think, for the fourth time now, is to establish, there's no point in saying you made a ruling on the first. In fairness to you, when you made that ruling, surely you are making it on the assumption that this is an affidavit, like all affidavits that we have seen here. And you are entitled to believe that. When it is now being pointed out to you that this is not an affidavit, you can't refer me to a statement you made when you yourself had not seen the statement because it came at 10:13. Now, so you're just bullying me for no reason.
No, let me assist you.
Yeah.
I'll give you back. Let me assist you. There's no bullying here.
There is.
And in fact, even on the day, we indicated that there was nothing substantial that was changed in the statement. I'm on record as having said that. And in fact, beyond that, the letter I wrote to you, which you responded yesterday, there's no objection in that letter in relation to this issue. And
No, that's not true, Chair. Can we get the letter of yesterday?
No. I'm not going there.
No, that's
You
definitely
will argue,
false.
no, you will argue your point. You will argue your point if you want to argue your point.
Okay.
I'm not interested that we're going to be all over the place instead of getting to the crux of what brought us here, Advocate Mpofu.
No, Chairperson.
We've been spending a number of times without getting into why we are here.
Okay. We're here to lead the witness on an affidavit. Are we not?
Go ahead.
Yes. If we are, then it's important to establish whether there is an affidavit or not. Because, Chair, let me explain to you.
Your committee had agreed that there is that statement.
But it's a question of law. It's not a question of the committee.
You are not able to prove which law that says it's not a statement of affidavit.
No,
you're not able to do that.
No, wait, no, that's about something else. You're just now.
Okay, just finish it. Then I'm going to invite members to
Chair,
chat with
if you want
issue quickly. Honorable members, we have to just quickly deal with this issue. I'm going to give you the last opportunity.
Okay. Yeah. Okay. Chair, since you seem to be obsessed with the name of the act, it's the Justices of the Peace and Commissioners of Oaths Act number 16 of 1963. I hope you are happy now.
It was raised.
Okay. And under that act, there are regulations, and I will give you the reference. But the witness has confirmed, and in fact, you stopped me at a point where this thing would have been done a long time ago, Chair. I was just about to ask the witness whether in her 7 years at the public protector, where she signed millions and millions of affidavits, does she know that in those affidavits, in fact, and we've got some of them here, the commissioner always signed every page or not? That's all I was going to ask, and then move on. If she knows,
That's fine. That's
Yeah.
going to be your last question, and then you get into the
Yes,
meat of
Chair,
this thing.
yes,
Chair.
yes, Chair.
Thank you. I'll give you that opportunity.
It will be. Thank you, Chair. But Chair, okay, you know, I really feel that you just I don't understand why you're not interested to know whether there's an. It's not me who drafted the directives that said statements that come here must be affidavits. There's a reason for that, Chair. There are proceedings, for example, in the Judicial Service Commission, Chair. The law there used to say that if you want to complain about a judge, you can make a statement. It was changed a few years ago to say, no, that complaint must come as an affidavit. There's a reason, Chair, that there's a difference between an affidavit and a statement. So I'm saying to you,
That shouldn't be a problem. That's
yeah,
fine.
that's really all I was establishing. If the committee is not interested whether what is before it is indeed an affidavit, well, that's the committee's prerogative.
Thank you, Edwin. I'll come back to you to ask the last question.
Let me ask
and then
that
you
question.
get into the
Yes.
actual content of
Yeah.
why we're here. But Advocate Mayosi?
Chair, I want to leave this point. Advocate Mpofu is correct. It's the Justices of the Peace and Commissioners of Oaths Act 16 of 1963. But I would still really request him to show us which section in that act says that the law says what it does. The regulations governing the administration of oaths and affirmation, which were updated on 23 April 1982. I would again request him to show us where in the regulation
All right.
there is this requirement that he relies upon.
Yes. I will.
Okay, thank you for raising that.
Chair, I will come to that, and I'll give you after the break, I'll give you the particular section. I'm happy now simply to ask that question that you allowed me to ask, so that we move on. And then when we come back, I don't want to waste your time. Otherwise, if you feel like giving me a break, you may do so. But I think this can be resolved by just asking that one question.
Okay,
at least
go
at this
ahead.
point. Yeah. Advocate Madonsela.
Yes, sir.
Yes. I want to ask you whether you, in your experience as a public protector or as anything to do with the law, in the affidavits that you have signed before, whether it was in the Nkandla matter or any other matter, you ever noticed that you would be required to sign every page, and so would the Commissioner of Oaths? If you remember, just from memory. If you don't, we will demonstrate later, but do you remember anything of that sort?
No, I didn't
Okay.
pay attention to the fact that
Good.
all of them were done the same way.
All right. Okay. No, that's fine. Then let's leave it at that. We will leave it for legal argument, at which point we will give the commission all the law regarding all the, can you give us the Commissioner of Oaths, the one from North Riding, is he available to give an affidavit? The one who did not sign every page?
He is definitely available. He lives
Good.
here in Somerset West.
That's fine. That's good. No, then we will avail ourselves of that opportunity. Thank you, Chair. Now I'm going to ask you the questions. I want to make it clear at this point that what you have presented to this committee is just we have demonstrated that it's a litany of falsity, but certainly what you have presented as an affidavit is not an affidavit, and we'll leave that for legal argument. I'm sure you don't agree with that conclusion, but we'll leave it for argument, correct? I mean, when I say correct, I don't mean you agree. I mean, can we move on?
I do have a question, say, because we haven't discussed the contents, and your conclusion to now say it's a lot of falsity, I do not understand that. My understanding is that on this committee's agenda today is the statement of the 28th. And my understanding is that last week, your concern was only that it had a stem from North Riding. And today your concern has changed to the fact that it's not signed on every page. Where does the falsity come from now?
No, I'm saying, ma'am, that it is not an affidavit. Let's forget how we got there. I'm just simply saying it is not an affidavit that is compliant with our laws. But I will ask you questions on it on the assumption.
Which law say?
It is the one that I just cited. Okay. All right. And I'll give you the, if you want it again. Anyway, no, let's not go there. I'm going to ask you questions now on the assumption that what you said in that, I think let's rather call it a statement, not an affidavit. What you said in that document is what you want to testify on. Okay, so we're now going to go to the document. I think I'll call it a document. Yeah. All right. Now let's go to, you have correctly, if I may say so, as a lawyer, you know that saying that says context is everything.
Sorry to disturb you. It's just a hand. Honorable Malema, just before you proceed. Honorable Malema.
No, I was worried that Advocate Madonsela is now asking Advocate Mpofu questions, and you allow that as a chairperson. Advocate Mpofu is not there to answer questions, and you should be directing that meeting in a proper way. Please.
Thank you, Honorable Malema. Proceed, Advocate Mpofu.
Thank you, Chair. No, I wanted just to assure the committee member that I'm exercising extreme patience for reasons that will become clear. So I'm not going to respond to the insults and the slurs and the snide remarks. I think it's better. The public is there to judge on its own. Yeah. All right, Madam, I'm saying then that let's go to your statement. Let's start at 9.1. Oh, sorry, I was asking you the question. You agree that in law, context is everything, correct?
No,
You
it is
don't?
not everything. It's part of the considerations you make. As a lawyer, you would also know that it's just part of what you consider. It's not everything.
Okay. You've never heard of the often repeated statement by judges that context is everything in law? Or if you've heard of it, you differ with it, correct?
No, I haven't heard of it, but you can guide me which judgment has said that. The Constitutional Court judgments don't say that. They consider context as one of the considerations they make.
Yeah, no, that's fine. Well, the Constitutional Court does say so, and every legally trained person who has come here, they've been maybe more than 10. I've always, if they're legally trained, I first ask them that question, and it's only you who has never heard of it, but that's fine. Let me move on again, because I'm going to be asked which paragraph of which judgment that is in. And unfortunately, even I don't have all the judgments without referring to them. But okay, it's fine. Let's not quibble about that. But okay, let's say you agree that context is important.
He who asserts must prove. Twice you have made assertions, and when asked to prove, you said you'll prove it later. I take issue with that. You said the affidavit should have been signed on every page. You signed the same law that the evidence leaders cited. And then when you were asked which regulation, you said you'll find out later.
Advocate Madonsela,
And
Advocate
yes.
Madonsela, I appreciate your interaction on that issue. I'd want you to answer the question that is asking if you agree that context is important.
Yes, sir, I had already said that. I had said that we are required actually by the Constitution and the law to consider context among other considerations.
Okay, thank you. I'm happy with that. So important is context that in your statement, you have 3 sections and 2 of them deal with context. Only 1 deals with the content of CX and Friede. Am I right?
Certainly not as everything, as one of the considerations.
Ma'am, did you hear the question? Is it so that in your statement you have part A, which is headed context, part B, which deals with the content, let's say, and part C, which deals again with context? In other words, of the 3 sections in your statement, 2 of them deal with context. Is that so or not so?
Yes, sir.
Thank you. All right. So on the basis that your statement is, let's say, 66% made up of context, then we're going to start with that context. Right. Now, I want to start at paragraph 9.1 of your statement. You said everything that is above paragraph 10 is relevant. So let's do it like that so that we stick to what you regard as relevant. You say at paragraph 9.1, I inherited a well-run institution that had been built virtually from scratch and improved step by step by my predecessors, correct?
Yes, sir.
Right. Okay, so let's deal with that part. Yeah. When the well-run institution that you refer to, you would agree that as a corporate leader, at least, I was once one, that refers to broadly to the people issues, the operational issues, and the governance issues. Those would be some of the signposts of a well-run institution, correct?
Yes.
Good. And of course, there's the output, which is the productivity. If you are producing sausages, how many sausages? If you are producing bread, how many loaves of bread, and so on. So those are the pillars of a well-run institution, correct?
Absolutely. Quantity
Good.
and quality.
Yes, absolutely. Good. And in fact, very good. On all those aspects, it's quantity and quality. So the people, the HR issues, the operations, the governance, and the output, those would be measured qualitatively and quantitatively. I agree with you. All right. So would you then say, if you say you inherited a well-run institution that can be built from scratch, you also left behind a well-run institution based on those parameters that you and I have agreed on?
Yes.
All right. And now, when it comes to the people issues, you had, obviously, there's never 100% in these things, but you had the necessary skills that you needed to run the institution, correct?
Absolutely. Although I'm not sure now whether this is now about me or it was just me giving context about the institution, because you're now asking me about my skills. I'm not sure what's the relevance of that question.
No, if you listen, you'll get the relevance. I didn't ask you about your skills at all. I didn't, ma'am. I was talking about the institution. I thought you said I inherited a well-run institution.
Well-run and having all the skills that you need are two different stories.
All right.
Interrelated, but don't have the same meaning. I think you know that.
All right. So what's the answer? Or do you not want to answer? Whether you had the necessary, oh, I see why you were confused. When I say you had the necessary skills, I don't mean you. I mean, did you have the necessary skills base to call it a well-run institution when you left it?
I'm not sure who's confused between the two of us at times. I know you like using that sentence, but sometimes I wonder who's the confused one. But let me answer your question. We had the right skills base. And what you had put now for the public view would show you that there's a logical sequence to what I said. That it was a well-run institution, but we kept learning and growing together. In other words, it was not a perfect institution.
Yes.
And it says so in the affidavit.
Yes, I think that's the same thing as what I just said, that it's never 100%, but if you prefer to say it that way, that's fine. And okay, so let's put that one. And then in terms of governance, were you satisfied with the achievements of the institution?
The institution kept growing. I know this is irrelevant, but it's you trying to insert your attempt to measure me instead of making this about your client. But I will answer you nonetheless, Sam, because you've been wanting this for a long time. The institution that I inherited was well run, built by two advocates of this country, one of them a judge, who built it from scratch. It was, though, an evolving institution. And when we came in, the concerns around, for example, issues of corruption ballooned because the scorpions had been discontinued. And obviously, this well-run institution had to be agile in adjusting to change, which, if you're talking about the skills base, anyone who had ever worked in the provinces had never dealt with a complex investigation unless they had worked at a national office.
Chairperson, please.
Corruption and good governance matters, or conduct failure matters, were never dealt in the provinces. And therefore, that's an institution that had to evolve and adjust to that. With regard to governance, when I arrived, the institution had gotten a disclaimer, not because my immediate predecessor was incompetent, because the CFO had died. So my first appearance in Parliament was to speak to a report where there had been a disclaimer. That's where we started to rebuild.
Okay, thank you. I was
so that really... well, sorry.
Okay, now I was just asking a simple question, really, which doesn't require all these stories. I'm simply saying, as far as governance is concerned, were you happy or not happy with the performance of the institution that you call well run?
When it comes to governance, I was happy. When it came to investigations, we changed the emphasis on numbers
Chair,
to
Okay,
balance numbers with the
yeah,
real.
that would be operations.
Advocate Mdntv, you did answer in terms of governance, so
yes.
you don't stretch it further than that.
Yeah.
Um,
In fact, Chair, yes, I'm not going to go to operations because I think then we'll spend another 15 minutes. All right. And it is indeed so that until recently, the institution never received a clean audit, correct?
I knew you were getting there, and because that's one of the irrelevant questions you had asked me. Of course, I would have been shocked if my successor never got a clean audit, because if you understand the auditing process, Sam,
No, ma'am, please answer the question.
Starting from a zero balance, which is where we started.
No, just answer the question. Sorry, Chairperson.
No,
I can't. We can't do this. Answer the question. I will ask you if I want to know about balance sheets and all that. I'm asking you whether the institution did or did not have clean audits before until recently. It's a simple question, yes or no?
Progressively, it arrived at a clean audit eventually with the systems we put in place.
Yes.
And the leadership we had. Progressively, it had to.
Yes, yeah. Okay, but yes, no, I understand that. But it could have deteriorated, so it improved recently.
Well,
correct?
From an audit point of view, you would say yes, because every year the points.
Thank you, ma'am. All right.
Oh, okay.
Thank you. I thank you. All right. Then, so that's your 9.1. So we know at least that there was this recent improvement in one of the areas. Okay. And then when it comes to the issues of, you know that one of the issues that bedevil any institution like that is the issue of backlogs, correct?
Yes.
Yes. And the evidence of Mr. Niels van der Merwe is that the backlogs are now at an all-time low.
An explanation. Why there's no one in the
Mkhwebane.
Apology both to yourself and Advocate Madonsela. Honorable Ngola, we're not interested to hear who's talking there where you are. Please stay muted. Over to you, Advocate Mpofu.
Thank you. Now, I was saying, do you agree with the evidence of Advocate van der Merwe, which you may or may not have listened to, but I will tell you what it said, that who has been there since the beginning of time with the institution, that currently, because of the systems that are put in place, the backlogs are at a considerable all-time low.
I don't know what was the backlog before I arrived. I said I inherited a well-run institution. But one of the things we had to deal with was the emphasis on speed versus rigor. And therefore the slowing down had to do with making sure that there was rigor. Okay. So I've never measured the office purely on the basis of backlogs, much as, in fact, in KZN, there was a time when they had cleaned up all of the cases, and they would have, of course, registered a nil backlog. We went back and reopened all of those investigations because they were improperly closed. So we were concerned that justice should not be sacrificed at the altar of speed.
Okay, so one of the reports that we're going to deal with specifically sat on your desk, as it were, for something like 5 to 6 years. Is that what you mean by ensuring rigor?
Absolutely, I did deal with it in my statement, if you will recall, sir. That's the one that I voluntarily chose to do against a decision of my team, and therefore it had to be my cross to bear.
Yes, no, I understand. I'm saying insofar as it went on for about 5 to 6
We're
years.
going to attend comrades to these things.
Exactly, it was an outlier.
We're going to attend comrades to these things, and we hope, Madam,
Just
that
pause at the
as we
Pofu.
attend to them, no one will think that they
For
are
the last time, can somebody for the last time
Our
mute
target
on
is one.
Mola
One
or
on
remove him from the platform?
Thank you, Chair. All right, fine, then we'll take that answer for now until we get to that report. Now, you then say that at 9.4, or let's start with 9.5. We'll come back to 9.4 when we come back. 9.4, you say, I resisted being spied on by the State Security Agency through sudden repeated requests to vet me as I was finalizing the Waterkloof landing incidents by the Gupta family. When you're saying you consider vetting by the State Security Agency as being spied on, is that how you characterize that?
No, sir.
Okay,
And
what did
can
you mean by?
Can supplement my answer.
Yes.
I had been public protector for 4 years or even 5. And as I was finalizing the Waterkloof landing matter, the last person I interviewed was from the State Security Agency. And then 2 things actually happened. A few days later, there was the first of those crazy spy stories. And then suddenly, in the middle of nowhere, the State Security Agency wanted to vet me. And this was the time when we knew that that agency was full of shenanigans, and we now know that it was captured. But I knew for a fact that this had nothing to do with trying to vet me. It had something to do with wanting to follow me with the permission of a judge. That's the context in which I'm talking about being spied on.
Being spied on, okay, good. So, but you yourself were never vetted, correct?
I wasn't vetted. Public protectors had never been vetted before me.
Yes, and you never had security clearance yourself, correct?
No, never did. Not for this post. I was vetted for other things as a consultant with government, including for work with the State Security Agency itself.
No,
previously.
Yeah, that's before. I'm saying as a public protector, you refused to be vetted, or rather, sorry, let me withdraw that. As a public protector, you were in fact never vetted or got security clearance, correct?
Yes.
Yes.
Can
And
you just get your last one so you can
yes.
take a pause?
Yes, thank you, Chair. Just to wrap up that point, it is correct, isn't it, according to the evidence of one of the witnesses, that you are the person who authored the security clearance policy at the public protector before the arrival of Advocate Mkhwebane, correct?
That you'd have to check with the Auditor General. I didn't initiate the idea of staff being vetted. As one of the audit findings, we were talking about governance issues. It's the Auditor General that tells you what needs to be done. And one of the things the Auditor General said we needed to do was staff at a particular level needed to be vetted. And it didn't include the deputy public protector, by the way.
No, I'm not talking about the deputy public protector. I'm talking about you. I'll show you when we come back, because the chair correctly wants to take a break now. I'll show you when we come back that you signed the policy that said people at a senior level should be vetted. But you're telling us that you yourself were not vetted. You were just, what to call it? Although you had access to those documents that are referred to in your policy, you were not, in fact, security cleared.
Yes, and I had done that for 5 years without it being an issue. And there was no policy that said the public protector must be vetted. And my predecessors, who were two, had never been vetted or security cleared.
Okay,
Thank you, Chair.
let's pause there. We'll take a 45 minutes lunch and be back at 2:05. Thank you. We adjourn for
Recording
lunch.
stopped.
2:05. We're going to resume with our inquiry. Let me quickly check if we are connected with honorable members. Honorable Malema, can you hear me? Honorable Zungula, can you hear me?
I can hear you, Chair.
Thank you. Professor Madonsela, can you hear us?
Yes, sir. Thank you.
Thank you. Thank you. We now proceed. Over to you, Advocate Mpofu.
Thank you, Chairperson. Yeah, I'm going to require your protection to deal with the questions. I'm going to try and ask them in a simple manner that requires short answers. But Chair, I just wanted to make the references to the passages or the references in law that you were harassing me to do. And I said that even I don't have all these things registered in my head without looking at them. The first one, Chair, is, and we'll deal with this obviously when we argue, but just for the record, it's the act that I told you about, the 1963 Act, the regulations governing the administering of an oath for affirmation. If you go to regulation 4.1, which is the one that I was dealing with the witness with about below, where there's a co-signatory, so to speak. Yeah. So it says below the deponent's signature or mark, the commissioner of oaths shall certify that he knows and understands the contents of the declaration, and he shall state the manner, place, and date taking the declaration. Now, the point I was making to the witness, Chair, is that the interpretation of that signature or mark, a mark could even be just initialing. Below that, the commissioner has to certify, and that must not be confused with regulation 4.1, rather 4.2, which deals with the signature at the end of the statement, where it says the commissioner of oaths shall sign the declaration and print his full name and business address below his signature. So that's the reference to that, to the issue of signature. The other one, maybe when we argue, I'll give you the full quotation. You'll remember that, Chair, I'm sure you remember that virtually all the legally trained witnesses have asked that question, and they've confirmed it because it's so trite that to borrow from
where he had lived in Swaziland. I didn't know where he came from. I never asked him.
Oh, come on, Advocate Mdntv. This is something that was being discussed in the public domain, but that's fine. That's your answer. That's your answer.
That's
And
my answer. I never asked
yeah,
him.
yeah, no, I know it's your answer. I just find it incredulous, yeah. But anyway, that's fine. Mr. Malunga was called as a witness, but it was decided that he shouldn't come. So I don't think it would be unfair to discuss him in his absence. But you yourself, you were born in South Africa?
I was, certainly. You know that information, don't you?
No, I wasn't there when you were born, ma'am. I'm just.
I think it's in the public domain. Like you say, I should have known about Malunga. You should have known about me too.
Okay, so then you agree with me that you should have known about Malunga now?
Well, I'm saying by your logic, I don't agree with you. I'm just saying by your logic, then you should have known about me. It's not my logic, it's your logic.
I see. No, that's fine, ma'am. The public is listening. No, I was simply distinguishing. I was saying that in your case, rather, in his case, there was that issue, but that issue did not arise in your case. And so I'm just wondering, okay, let me ask this question so that we move on to the next topic. When, for example, as you correctly say, this was raised with you when you were investigating the so-called Gupta landing at Waterkloof, don't you think that that particular issue, obviously the landing of a foreign plane in Waterkloof, which is a military airport, would be a matter dealt with by the SANDF and, among others, military intelligence? Don't you think that your lack of clearance of cleared status would limit you in investigating something like that, because it might involve documents to which somebody like you would not have access? And just, if you don't think so, just say so, don't tell me why. If you do think so, just tell me.
I don't think so, in the same way that it doesn't limit judges. But you are correct, you are incorrect. Again, you've distorted what I said. I said, as I was, can I just correct you?
No, but you can't insult me at will like that. Chairperson, can you ask the witness to stop saying that I've distorted anything? She's been insulting me.
But we've done that, sir. Can I correct you?
Okay, go ahead.
Thank you, sir. It's on the record. Everything that we're saying is on the record, and there are people listening. I did not say that they asked to vet me for the Gupta landing. I said, as I was concluding that, the last witness that I interviewed was from the State Security Agency, and they knew where this whole investigation was going, because we had done a forensic and we caught them lying. And shortly after that, two things happened. One was the spy story. The second thing was a letter requesting to vet me. The issue of me being not vetted and not having an objection to me accessing information was not in this case. It was with the Nkandla case. We discussed it and we agreed with the ministers concerned, a whole cluster of ministers that had been appointed by President Zuma to deal with me in this matter. We agreed that the public protector goes through public scrutiny that is similar to vetting, and therefore it was improper to refuse to give me the documents from Nkandla. So that was a totally different thing, and it was agreed to. And then out of the blue, the State Security Agency wanted to vet me.
Thank you.
Not in relation to any case, just out of the blue. And they said it would be good for me to do that in writing.
Your point is well covered, Advocate Mdntv. Advocate Madonsela. Over to you, Advocate Mdntv.
Thank you. All right. now I'm going to start protecting myself because the chair is refusing to do so. Let me just tell you for now that your accusation that I was distorting information is unfounded. I have no reason to distort anything, madam. I'm just asking you questions. It is you who said in your statement that you resisted being spied on by the State Security Agency through sudden repeated requests to vet me as I was finalizing the Waterkloof landing incidents by the Gupta family. I'm simply asking, based on that statement of yours, which I've now quoted verbatim so that you don't accuse me of distorting information, which would be highly unprofessional. But the issue I'm saying is that, don't you think, and you may agree or not agree, that for an investigation such as that one, it might be a limitation not to have access to certain documents when by its nature that investigation involves classified information?
It was being finalized, sir. So all of the investigation and access to documents had already been done. As my statement says, it wasn't before I did the investigation this was raised. It was when I interviewed the last person who was a member of the State Security Agency. A few days after that, when I'm talking finalizing an investigation, I'm talking writing the report, which for whatever strange reason never saw the light of day.
Yes, okay. Let's quickly go to the bundle C folder 2, item 27, please, Tsepa.
Are you winning, Slow Tsepa? Okay.
Right, thank you, Chair. If we go to the first page. (1.1), it says, yeah, the Public Protector South Africa depends on its personnel information and assets to deliver services that ensure the health, safety, security, and economic well-being of South African citizens. It must therefore manage these resources with due diligence and take measures to protect them. You remember that?
No, I wouldn't remember it. It happened so many years ago and we live in the digital age. But
okay,
I
well,
take it that
okay,
it's from my institution,
yeah.
my former institution.
Okay, ma'am. Let's assume you don't remember it, but you can't dispute that it was part of the policy.
I cannot dispute that. I cannot see my signature on it because the policies that were signed by the Public Protector would have my signature on it. I have no reason to say yes or no.
Fine, let's go to page 459.
If you show my signature, then I will say yes.
Let's go to page 459. Down. Is that your signature?
Yes, it's my signature, but it's not initialed every page. So I don't know if it's changed, but I want to believe it because it is an old statement that it must have been.
No, I agree with you. Yeah, in fact, the facility of initialing every page is meant to stop fraudulent activities. You are right to make that qualification. Am I right?
I know where you're getting, Advocate.
No, don't worry about where I'm getting, just
Advocate
answer the question.
Mpofu.
Just answer the question.
I don't know.
Oh, so why did you tell the chair that because it's not initialed every page, it might not be authentic? If you don't know now, when the implications of that question are made
It's
clear
not
to you.
about fraud, it's about you were attributing it to me and I was saying, I don't know. And I said, if it's got my signature, then it must be me. But since it's not initialed, I don't know if it's been changed because policies are changed over time. But let's just accept that this is a policy that I signed and it's a policy where I was required by the Auditor General to sign and I complied.
Okay, that's fine. And as it happens, also what you've just said is not true. You did initial every page because you knew that that is the correct procedure. Let's
Well,
go to
I
page-
didn't say, I didn't say I didn't initial. I just said, if it's signed by me or initialed by me, that's okay. Because you're showing me these things. I don't even know what's the procedure here. Normally, just common decency is such that if you're going to put things to people, you send to them in advance. I mean, you were not prepared to put your client through an immediate process, having been given a document 4 days ahead. And you're throwing documents to me without having shown them to me in advance.
Okay.
So supply the same rules you want for your clients to me, sir.
Okay, thanks, Advocate Madonsela. Just a pause there, Advocate Mayosi.
Chair, this particular policy is initialed on every page.
Is initialed.
On every page.
That's what, yeah.
Okay.
But that's what I just said. I don't know why Advocate Mayosi is jumping in as to use Advocate Bauer's expressions. I've just said to the witness that as it happens that this is signed every page. So
Initialed every page.
Initialed every page. So
Okay.
what's the purpose of that intervention, Chair?
Okay, that's fine. Maybe she didn't pick that up. Let's proceed.
How do you know
Over
that?
to you.
How do you know that she didn't pick it up?
She's saying now.
Oh, okay. That's fine. Ma'am, please, I don't want to debate with you. The record will show that you said it's not initialed on every page. So there's no point in me debating that with you. All I'm saying is the significance of that. You raised the point, not me. Okay? I did not raise the issue about signing every page after lunch. You raised it.
May I
So
just
I'm
respond?
saying- No, wait, let me finish, please, Chairperson.
Yes, finish, Advocate Mpofu.
Madam, I'm saying that you raised the issue, and I'm simply saying that the only reason you raise it of your own volition as part of either an attempt to disown this document or discredit the fact that it has your signature at the end is because indeed the practice of initialing every page, which you did here, ensures that the signature at the end is not just inserted, because all sorts of things could happen. And I know earlier you denied falsely that in the many affidavits that you signed over the years at the public protector, you and the Commissioner of Oaths signed every page. But let's put that aside. I'm saying you're raising it in this context here. And the fact that you did do the right thing of initialing every page means that you know, despite your fake or feigned ignorance, that that is a guarantee, the signing every page. It's a guarantee.
And I respond to that, sir, because that's an attack.
You don't want me to finish? It's fine. If you don't want me to finish, you can.
Yes. I just want to respond to the digression.
Before I speak, before I
and-
finish.
yes, please, sir.
Don't you, isn't it better to respond once I've finished?
Because you're going to go to a different issue. I want to respond to the lie you've just made.
No, ma'am, I will never go to another issue without giving you an opportunity to respond. Believe me.
Okay.
That has
please,
never
let's do it.
happened.
Okay.
All right. So I'm saying, madam, that the reason why you, not me, raised that issue is because you know very well, despite your earlier false denials, that the issue of signing every page is intended as a bulwark against forgery or fraudulent documents or people claiming that this is your document. This one in particular, I think, has 54 pages, simply because your signature is on page 58. You know that. You can now respond. Thank you, ma'am.
Thank you, Sam. Here is the distortion again advocated for. Earlier on, when we had a conversation, it was about commissioners of oath. You're not telling the truth, sir, when you say, I said, I never signed every page. You asked me, in the practice of commissioners of oath, and I've been public protector for many years, do I know of any occasion of where there was no joint signatures? And then I said, I don't know, because I don't have a recollection of every document. And this is on the record. I will ask that the committee, when this is debated, we get the verbatim. Secondly, on the issue that you're accusing me of, on the one issue, it was commissioners of oath, and currently we're dealing with a policy. These are two different things. It's signed by one person, and all I asked was if it is signed on every page. To now distort my words and say, I said it's not signed on every page. It's a 59-page document that you've just put in front of me right now. Am I a clairvoyant to have known that it's not signed on some pages? But lastly, on that issue that you've argued here about the fact that if something is not initialed on all pages, it is therefore unlawful or illegal, or it's not an affidavit. You cited something from 1963. I will cite to you something that happened here in this province, which becomes precedent. That is the case of Minister of Safety and Security versus Mustafa Mohammed. It's an April 2010 case that contradicts what you just told this committee, say.
Chairperson, please. Advocate or Ms. Madonsela. Well, she didn't, I asked her, are you registered with the Legal Practice Council? Because there's a member who's, pardon?
It's immaterial.
No, but no, there's a member here, Honorable Malham, who's
just stop trying to bully me, Advocate Mpofu. Stick to the rules here.
No, I just want to know, ma'am, please, this is important. So, a member says that you are an advocate. So I want to know if you are registered as such with the Legal Practice Council. That's all. It's a simple yes or no.
It's immaterial.
So I'll take that as a no.
Take it whatever way you want, say.
Yeah, thank you very much. Yeah, no, I'll take it. Yeah, anyone who's registered with the Legal Practice Council would not struggle with that question, but that's fine. Then it means then I was doing that for the sake of knowing where to report these transgressions. At least with the Commissioner of Oaths, I'm sure he's registered with the Legal Practice Council, so we'll refer him there, and other people involved will be referred to the police. That's fine. All right. No, I was saying, ma'am, I don't want to quibble with you. You would agree, though, that the principle doesn't matter whether in the one case we're talking about an affidavit, in another one we're talking about a policy, in another one we're talking about whatever. The principle of signing or initialing every page is the same, which is to ensure that that document has been properly signed by the person whose signature appears at the end, the principle. Did I agree?
Such as suppose.
Subject to the Zeman judgment of 2010, sir. Thank you.
Thank you, Honorable Malema.
Chair, the advocate, when he asks the question and the witness is not answering or deliberately refusing to answer, I thought it is your role to come in and check if she will not answer the question. Because that thing of her belonging to any professional body is very important and can't be left hanging like that for simple reasons that the advocate had mentioned.
Thank you, Advocate. Honorable Malema. I was satisfied with the answer she gave. It's how she feels to answer that question by saying, in relation to the motion that we're dealing with here, for her it is immaterial. Over to you, Advocate Mpofu.
You're saying you're satisfied with that?
Over to you.
Your satisfaction is very easy to achieve, Chairperson. This is, anyway, it's fine. We're going to be patient. So
Okay.
Anyway, the public knows, I mean, it's very clear now. We had a public protector who's not security cleared, who's not an advocate, as at least as defined in the current law. And what are you a professor of?
Advocate Mpofu, I'm a professor of law.
Which law?
I am a professor of, I'm appointed as a chair in social justice, as the affidavit says.
Oh, yes.
And the affidavit did not claim that I am an advocate. But again, there's a role of advocates in this country. If you want to know whether I am registered as an advocate, you just need to find that out. But I find your conduct unethical, that you keep trying to threaten me with reporting me. Let's just deal with this case and stop these threats. Let's just deal with this case. Let me answer the questions and let's finish this business and stop with these subtle threats. You're not bullying me.
Okay, ma'am. No,
Chair.
Honorable Malema, I see your hand again.
No, but when you say you are satisfied with the answer, and then if I'm not satisfied with the answer, what happens? Because if these people are answerable to you and you are satisfied with the answer, why are you not taking them to a dining room? Because we are here also, we are not satisfied with the answer. So what happens when we're not satisfied with the answer? That everything satisfies you, then automatically it means we are satisfied ourselves. That question is very relevant for us who are going to be making follow-ups on this question. So please, you can't say you are satisfied and then we must move on. What happened to some of us who are members of this committee who are not satisfied? And we must be satisfied through you. That, Chair, please, can we get an answer for that question? Then you say you are satisfied, as if we are here to satisfy you.
Chairperson, my answer remains.
No, I've not recognized you, Advocate Madonsela. I've not recognized you. Honorable Malema, please conclude.
Yes.
Chair, maybe
Honorable Malema, please conclude.
it looks like there was interference, Chair. Maybe he'll come back once he has reconnected.
Okay, he's frozen.
Thank
That's okay. Advocate Mpofu.
Thank you, Chair.
Sorry, Advocate Mpofu. Honorable Manel.
No, thanks, Chair. I just want to, for purposes of clarity, so that we understand if we understood it the same. And this is because interjections before, when you tried to come in between witnesses and what is raised by the legal team, have been that you should be satisfied that the witness has responded. It's not about you being satisfied as a person with that response. So I'm just saying you need clarity on that because it will come back again. I don't think it's about you being satisfied because you're not asking the question. The question is asked elsewhere and there is a response to the question. You may not be happy with the answer, but the question is whether there's been an answer to that question. And if that answer is not there, surely the reasons follow-ups have been made is to try and establish the answer to such a question. So I'm just saying, Chair, so that it helps us to also make progress. Thank you, Chair.
No, thank you, Honorable Maneli. There has been an answer, not once. Honorable Sukas.
Yeah, Chair, I also just want to add, Chair, the witnesses cannot become the subject of this inquiry. And we cannot subject witnesses continuously to intimidation. And earlier, there were insults hurled at the witness currently on the currently providing evidence. We cannot do that. It goes against the directives that this committee has accepted. Thank you, Chair.
Well, thank you, Honorable Sukas. Honorable Malema, are you back?
Yes, I got cut when I was still pursuing my question, and then Ms. Madonsela spoke, and I was not talking to her. You see, she must not say that she can't be bullied by people and think she can bully us. I was talking to you, and I was going to expect an answer from you. She just abruptly interrupted me and say, my answer remains, and then that's when I got cut. I was not talking to her. I was talking to you, and I was saying to you, how do we proceed in that regard? Please, no one is bullying her here, and she's not going to bully us. You see, staying at Stellenbosch does not give anyone any right to bully us. It's not going to happen that one. Never. It will never happen with some of us.
Thank you, Chair.
No. Are you done, Honorable Malema?
Yes.
Thank you. Thank you, Honorable Malema. You got cut and frozen. Members are still going to have an opportunity to interact themselves directly with the witness. For now, it is an interaction between the witness and the legal team of the public protector. So we're still going to allow that, but I repeat, and I've been directed properly that I'm satisfied with the manner the witness has responded, not once on the issue. It might not be an issue that from the one who's listening that it's not satisfying in terms of what has been asked, but she has tried to respond to the matter.
Yes.
Advocate Mbofu.
Yes, thank you, Chair. No, she has tried, but she has not succeeded. I'm saying, Chair, just to assist Honorable Maneli, your role as chairperson is not simply to be satisfied, and I think I've said this before, to be satisfied that somebody has moved their lips and they're speaking. So if I, for example, I say, are you an advocate? And the person tells me the score of the Kaizer Chiefs game yesterday, that's, you might be satisfied that they've responded because they have, but you should be satisfied as to whether they answered the question. That's really your role. Because to be satisfied that someone has responded means that people can just come here and do anything.
Which is not the case.
Yes,
on
but,
this. That's
but
an,
yeah. So and that's why I wanted to understand. No, Chair. In
Thank
fact,
you.
you're quite right. So I wanted to understand that you are satisfied that she is refusing to answer that question, which is crucial. The very first question, very first question I asked this witness this morning was whether I should refer to her as professor or advocate. And she said, I can use both. And I'm simply wanting now, given the demonstrable lack of knowledge of the law and the regulations, to establish whether indeed, particularly the issues that have to do with affidavits. And I was really asking that, Chair, not to embarrass the witness, but simply, as I said, to know whether any allegations against her should be referred to the Legal Practice Council. There would be no point in doing that if she's not registered with that body. But it's fine, Chair. The public, I think, will make its own conclusions. I don't want to waste time on this. So, Ms. Madonsela, the policy that you signed says, can you go to, I think it's 40. So yeah, 40 in the policy itself now, which you initialed every page, thanks. It's 4.3.5.1.1. Yeah. You people at the Public Protector know how to number documents. 409. 4.3.5.1.1. Okay, so it tries to cover it says all employees, contractors, and consultants of PPSA who require access to classified information and critical assets in order to perform his or her duties must be subjected to a security vetting investigation conducted by the state security agency in order to be granted security clearance at the appropriate level. The level of security clearance is given to a person will be determined by the content or access to classified information entailed by the post already occupied or to be occupied in accordance to their respective responsibilities and accountability. Then a security clearance provide access to classified information subject to the need to know principle. I'm just paraphrasing. The essence of that is that people who are going to have access to sensitive information must be subjected to a security vetting investigation. Is that a fair summary?
No, it doesn't say people, it says staff. It says personnel.
No, I didn't say that, but it says.
It doesn't say people, sir.
Yeah, it doesn't say staff either. It says employees, contractors, and consultants, and those are people, human beings, you understand? So I'm saying those employees, contractors, and consultants, those people who require access to classified information must be subjected to security vetting. Is that a fair summary of what the policy that you signed requires?
It speaks for itself, say yes.
Yes, thank you. All right. And now, right, we've already established that you signed this because its absence was seen as a deficiency by the Auditor General, correct?
Yes, sir.
Good. Right. Okay. Then I think, yeah, we're making some progress. So no security clearance, sorry, and no advocate. So the next issue that you deal with in your statement is after this thing of being spied on, you say, oh no, before we leave that, you indicated that at some stage when you were dealing with, I think, CX, you had a document in London which arrived from SSA that you had given to DECO. Am I right? Is that a fair summary?
Yes, sir.
Yes. And why did you give that? Why did you not travel with that document yourself to South Africa?
Because the documents were bulky. These were documents from Mr. Otley, and the person whose name I have on the minutes on my minutes of the 15th of October 2015 had sort of substituted an investigator for me because I was alone in the meeting with Michael Otley.
Okay. So you gave them those documents away because they were bulky. That's
sorry,
basically
it was some of the bulky ones like liver arch, if I'm not mistaken, and I took the ones that I could take. But what we agreed, the bulk of the documents, it's a box. I didn't have that box. That box was provided by Mr. Michael Otley. I don't know what Mr. Michael Otley provided to parties, but I don't know where this is going to. But let's
yeah. No, okay. I think that's your problem, really. You mustn't worry about where anything is going to. Just answer the question. That's
I don't
all.
worry, sir.
Yeah. Yeah. Well. Yeah. Okay. Then don't tell us if you don't know where it's going. Because yours is just to answer questions. All right. Then you say at 9.6. We worked as a team building an executing system that tried to balance rigor with promptitude, gave priority to what we refer to as Gogo Dlamini cases, while ensuring that the investigation standard applied and the duty of care was uniform. This is a term that you've used again in the public domain, so even I would know. But just for the record, when you talk about Gogo Dlamini, you are indicating really, you are differentiating the ordinary South Africans as opposed to some of the high profile people that you deal with, just ordinary South Africans effectively with nothing much, correct? Yes?
Yes, sir.
Thank you.
Okay.
Yes. Now, we had here two Gogo Dlaminis, except that they were males. So I'll call them Mkhulu Dlamini. Both of them, or at least one of them, said that you took 11 years without resolving their problem. Would you categorize that as giving priority to what you refer to as Gogo Dlamini? And maybe before you answer, so that we save time, the other one was a real Mkhulu, was 80 years old, and he was here, and as I indicated last week, he cried tears because he says you ignored him when he told you that he had been assaulted by a member of your staff.
Right.
Mr. Samuel, now, would you agree that, at least from the evidence before this committee, the Gogo Dlaminis that we've had testifying here have had only praise for Advocate Mkhwebane, who in both cases intervened on their behalf, ordinary people, but they gave us horror stories about your lack of response to them. I'm saying that in relation to your claim of giving priority to Gogo Dlaminis. You would agree that, and I want to give you an opportunity to deal with it, that doesn't leave, that doesn't give us an impression that you prioritize Gogo Dlaminis. Actually, it gives us the impression that you terrorize them.
I knew you would want to insert this in the back door. These are two of the cases that I had objected to being asked about, and I asked, whose impeachment inquiry is this? Given the fact that these questions are about my conduct, and they also are selective cases. But nonetheless, because you have decided that I am on trial, despite the fact that this committee said I did not need legal representation because I'm not on trial, I will answer you. We gave priority to Gogo Dlamini cases as an institution. And that's what my affidavit says. We gave priority to Gogo Dlamini as an institution. Giving priority to Gogo Dlamini does not mean you will submit in relation to each case at the time you choose to submit. For example, in November, or it was in December, when I was at UJ, a student came running to me in front of the other students and insisted she wanted to take a picture with me because I am the reason she's at university, because her mother was part of a group of employees that had been dismissed, that I gave the jobs back. I didn't know that. So it's just one example of Gogo Dlamini and of this child who I took a picture with because she has taken law because I dealt with their case. They were traffic officers, they were Gogo Dlaminis. So you selected the cases of Sarah. Sarah is a case of artists. As far as I recall, I did conciliate that. And why conciliate? Because we gave priority to Gogo Dlamini cases. If you look at my schedule as a protector, and this you can get because the diaries stay back there in the office, you will see that the majority of cases that I dealt with were cases that involved common people, despite the fact that we had an institution that was divided into the service delivery, its access to justice and service delivery, as the affidavit of Ms. Mokhaladi says, and my role was the overall institution plus special attention matters from any of the branches, from all of the provinces, plus the good governance in the property branch. But I still sat on those cases. I can talk about the Mahlangu, that I had transcended 3 public protectors. So you're gonna say if the Department of Arts and Culture did not implement the agreement on time, then that means I did not prioritize the cases.
Yes, okay.
Inverted logic.
Yeah, no, that's fine.
But
you would agree.
No, can I finish, sir? Even the very fact that I got involved was precisely because of prioritization, because that branch was the deputy. And at the time that matter started, my deputy was Advocate Shai. And then the other case was a human resource matter. Again, human resources, if you had bothered to ask for institutional documents, you would have found how the structure was shared between me. Again, that matter was dealt with properly according to the institution in terms of the procedures. And this person, you must show me, and I did ask you, who's accusing who? Provide me with the documents. You never did. And you talk about lawyers who know their stuff. Lawyers provide people with documents. They don't rely on ambush. If I accuse you, I write to you and say you're accused of 1, 2, 3. Here is the person accusing you. Here is the information, and you let people respond properly.
Okay, thank you, Chair.
If you haven't done.
Yeah, well, are you finished now?
Yes, sir.
Okay. No, that is why, Madam, we were at pains to beg you to consult so that we could have put these things, but you rejected that offer. But be that as it may, you are now saying that making a person like Mr. Nyatela to wait for 11 years until the current public protector came to his rescue, is you saying that counts for nothing? It's he just had to wait for 11 years and forever. If your term was 20 years, he would wait for 20 years.
I didn't say that. There are matters that are resolved. This matter, for example, transcended 3 public protectors. And as far as I recall, because I don't have the information now, there was one resolution after the very first time I got involved. There was a resolution between the Department of Art and Culture and this person. And I haven't had an opportunity to get that information, but I do know that there was a resolution. But having said that, I am saying your effort is to try and to resolve these matters. And if at the end of the day they're not resolved, it doesn't mean you haven't prioritized it. In the same way that there are matters that I have resolved, there are matters that come to me now where there was a finding of no wrongdoing. There's a case, for example, that I want because of the names of the people that I was dealing with, and my successor found no wrongdoing. And when I dealt with the department, we've moved an inch on something because there were clearly files were lost. And somebody, but the finding was that there was no maladministration. Yet this person's files were lost. How can you say? So I'm just saying, when we're dealing with these matters, sometimes the outcomes are in the hands of other people. Yours is to make sure that you assign people, and when you personally need to get involved, you get involved.
Yes, okay, that's fine. I won't bother you with the gory details, but the evidence of Mr. Nyatela in front of this committee is uncontradicted. And I was just giving you an opportunity to deal with it, but you're telling me about students at University of Johannesburg who I assume also fall under Kokotlamin. But I'm going to ask you about the specific case then of Mr. Siabi, because you may be right that you rely on others and so on. Mr. Siabi, who cried here, said that he told you, not somebody else, that this person who is chairing your meeting assaulted me, and you said you'd talk to him after that meeting, and instead you just drove off to Tabazimbi, and he says the only thing you did was to take Mr. Samuel to the Free State, and there was never any comeback for his being assaulted by Mr. Samuel, and that's evidence is also uncontradicted. Would you agree that that doesn't demonstrate prioritization of Gogo Dlamini if you allow septuagenarians like that, who's now an octogenarian, to be assaulted by members of your staff?
Firstly, that's not true. That whole story is not true. It's also not true that that matter was never dealt with. Again, when this matter was put among the accusations that now made me the person who's being impeached, I did ask you specifications, and you shouldn't say to me, I needed to come for consultations. Earlier on, you asked me about my practices as a public protector. As a public protector, when people were being accused of things, we wrote long letters to them indicating specifically what are they being accused of and what do we know. And I do not understand, for you being highly paid, why were you not able to write specifically and say, what are you accusing me of? Because if you had told me what you're accusing me of, and if you had told me that you will insist on bringing these matters on, I would have then insisted on driving to Pretoria or flying to Pretoria to get these files of what exactly happened. But I do know that what you're saying to this committee is not true. It is just not true. You're using an old man, and I'm sorry about what happened to Mr. Siabi. We do know that there was a matter there, but that matter was dealt with through a proper HR process in the project. The details of which I don't have at this stage, because I didn't know you were going to ambush me further with it. We did agree that the focus of this inquiry was going to be the 2 cases.
No, ma'am. Ma'am, you, your statement says you gave priority to Gogo Dlamini. It's not me who said that. So I'm simply testing the proposition that you make, if you don't mind. So the old man, if you are saying that he's lying, he was not assaulted. Well, I can tell you that there's a court decision that says that he was assaulted and Mr. Samuel was sentenced for that. And that's it. So it's not me if all that is made up. It's either Mr. Siabi or the court that found Mr. Samuel guilty. I was not even asking you about that. I'm asking you about your callous and cruel refusal to attend to Mr. Siabi, about which he testified here, you know, in a very sad way, and about an incident that involved you personally. And if you don't want to deal with it, that's fine. But please be assured
May I respond again, sir?
No, please allow Advocate Mpofu to conclude.
Oh, okay, sorry.
So now I was saying, Madam, that the evidence of Mr. Siabi before this committee in that respect is not contradicted. And in relation, sorry, Chair, in relation to the issue that you raise of relevance, that is very relevant. This is just 1 second, Madam. Mr. Siabi, that you'll find it at bundle K, Chairperson, page 6456, if you can put it up. He was invited by the chairperson to make concluding remarks towards the end of his evidence, which, as I say, was quite, can be sure there was not a dry eye in this room when he told his story. He said, 6456, I want to thank you from the bottom of my heart, said to the chairperson. I know that now I will be at ease. I could not report people like Advocate Madonsela anywhere. You gave me a platform and I know that my case is being attended to. To which Honorable Siwela then said, Advocate Madonsela will be part of those who will appear at the honorable members, and as the honorable members have said, but we condemn the issues of violence. And to which Honorable Tlakude said, regarding Advocate Madonsela, we will handle that on your behalf. And to which Honorable Ngola said, in that regard, is that Advocate Madonsela is due to come and appear before the committee. We will surely ask that question on your behalf. So there's no doubt about the relevance of what I'm raising to the issues that are before this committee. So all I'm saying is, do you have an answer or not to the allegations that you are complicit in the criminal assault of Mr. Siabi by Mr. Samuel?
Two answers. The first one is, this is another low, even by your standards. Firstly,
Chairperson,
you
please.
are making.
Okay, no, wait. Chairperson.
Okay, just pause,
Yeah.
Advocate Madonsela.
Chairperson.
Advocate Mpofu.
Yeah, I'm not going to tolerate this forever. If you allow this witness to insult me as she has been doing, then I'm going to have to deal with her myself. And it's not going to, it will be ugly. Let's just say on both sides.
Just pause there. Let
No,
me
it
attend
will
to
be.
the issue.
Yeah, I'm not here to be
Let me
to
attend
be
to
insulted by a witness.
That's fine.
And what is your problem, Mr. Myla?
No. Leave that.
No, you must not do that. Don't do that. Okay.
Advocate
Person.
Advocate
Must
Mpofu.
not do that.
Advocate
I'm
Mpofu.
being assaulted here and he's laughing, giggling.
Advocate Mpofu. You know.
I'm being insulted and he's giggling.
Advocate Mpofu.
Please, Chair, protect me from both the witness and from the likes of Mr. Milham, the husband of the complainant.
I'll attend to both issues. The first one, let me start with switch off your mic, Honorable Milham. I didn't recognize you. I would want you when you to speak through the chair.
Yes,
so that we avoid.
No, sorry, I was addressing you.
I would want you to register that point and then I attend it as a chair. But the problem you attend to it yourself.
Yeah.
And it doesn't help.
Well, Chair, because you are failing to protect me.
Then you are making another statement, which is also not correct.
Okay, sure. I'll leave it to you.
I'm going to ask, firstly, Honorable Milham, let's keep our calm and not even try and interject. In the House, we do that, but this is just another platform about whatever was. If you have something to raise your hand and raise the matter so that we avoid this issue. I'm not saying raise your hand now. I'm saying when you have to raise something, that's what you do. I'm not there now. To Advocate Madonsela, maybe it might be important. I know that there's been a lot of exchanges between yourself and Advocate Mpofu to refrain from that kind of language of this is a law or another law from you. I would want that you tone down on that language.
No, Chair, I'm sorry.
So what are you doing?
No, I'm
on the platform. I'm not speaking to you even for that matter.
Okay, but that's not the insult.
Anyway, switch off your mind.
Okay, Chair.
So Advocate Madonsela, I'm asking that you tone down on that kind of a strong language. I'm going to be asking everybody to do that in the process. Honorable Sukas.
Chair.
I've noted your hand.
Yes, Chair. No, Chair, you actually covered it that by saying that you are saying it to everybody. Because as I referred earlier, even the exchanges prior, the subtle intimidation of the witness has now twice, I think thrice, spoken of the fact that if she is if she is the subject here of the inquiry, that then she needed legal protection, or she should have consulted with her legal with her lawyer. So the issue here, Chair, is Advocate Madonsela is not the subject of our inquiry. She is not. And I would like it to be noted in terms of the time, because we have not progressed to the two cases that has been the focus of this testimony, why Professor Madonsela is before the committee.
Okay. Thank you, Honorable Sukas. I am watching that space, but I was also happy with the fact that some of the issues raised are arising from the statement. Yeah. So it's important that we don't just brush that aside. And Advocate Madonsela is competent enough to respond to those issues. But I take your point about issues of subtle threats and intimidation. Honorable Milham.
Chairperson, I'd like to point out that I did not laugh at Mr. Mpofu. I made a comment quietly, and my comment arose because Mr. Mpofu threatened a witness. He said, I will deal with it myself and it will be ugly. And Chair, that is absolutely unacceptable in a committee of parliament. And I'd ask that you deal with that matter, Chair.
Okay. Chairperson.
Thank you, Honorable Milam. As I also get back to you, I'm also going to be asking the same.
No, you can't ask the same. Chair. I'm the victim here.
Wait.
I'm being insulted.
Wait.
Ask the same for what?
You're going to have to tone down your language here, Advocate Mpofu. You are not going to be treated special at any time. So whatever that I've just asked Advocate Madonsela to do, I'm asking you also to do that. You can't expect special treatment from the chairperson. I'm addressing both of you. Please proceed.
Thank you, Chair. All I'm saying, Chair, is that when I'm being insulted by the witness, you can't say that you are addressing both of us, because I've refrained the whole day. I've been patient. I did not insult this witness. I did not intimidate her. I'm simply saying that if you fail, as you have dismally, to protect me from her insults, then I'm going to have no option but to do it myself. It's called self-defense. I cannot be just insulted at will by anybody, including the witness, you, anyone, human being alive, okay? So my lack of response must not be mistaken for not being able to do so if I want to.
Yes.
Please,
Let me
must
just
not be
indicate
made.
this, and I'm going to say it once. Whatever self-defense you want to do the outside of this inquiry.
No.
In this inquiry, there's a chairperson who directs proceedings and who does everything.
Who's supposed to defend us?
You might feel that you don't feel protected. I'm playing a role that a chairperson must play, which must be fair to everybody.
All right.
If we have to initiate self-defense, it will be outside of this inquiry.
Okay.
Thank you.
No, well, anyway, that's fine. Thank you. Madam, when you say even by my standards, what do you mean? What are those standards? Other than the intention to insult me and my professional integrity. What are the low standards you're referring to? Because that's not, the chairperson did not address the actual insult. I tried to assist him. So I'm going to ask you to answer that question.
You have insulted me, you have berated me, you have ambushed me, you have threatened me. That I considered low. But out of respect for you as a fellow professional, and out of respect to the chair for his ruling into this house, I have withdrawn the statement about it being low.
You've only withdrawn that part, but you don't withdraw the rest of it?
No, you have insulted me, sir. You have berated me. You have threatened me.
You have not insulted me? Have you
don't
insulted
have
me?
that self-awareness,
No, I'm
then
asking, have you not insulted me today since the morning, and I've appealed to the chair?
Sir, I didn't argue that I had not insulted you.
All right, that's fine.
You said you've not insulted me, you've not berated me, you have not threatened me, and I'm saying that's not true. You've done all of those things, and you've ambushed me, which legally is improper. You understand administrative law, but if you are going to be accused of something, you need proper notice and time to apply your mind. You're asking me about things that happened 6 years ago with no information given to me now or in advance.
Thank you. All right. Yeah. Anyway, I think as the chair said, everything I've asked you arises from your statement. Now, the other issue that you've referred to is the OR Tambo Declaration on Minimum Standards and Effective Ombudsman Institution. We had evidence about that from Honorable Zulu Sokoni, whom I understand you know her.
Yes.
Yes. All right, we'll come back to that one. I just want to go to the remaining third. As I said, your statement was 66% or 66.6% to be exact, made up of these sections that you called context, both of them. So let's deal with the remaining third of your statement, which is part B thereof. Now, you've testified that you were the lead investigator in the CX matter, correct?
At the beginning, as it says in the statement.
No, there's no such thing as beginning. It says, I was the lead investigator on commencement only, working with a trainee investigator. And when he left, the investigation was stalled until I was given a young investigator who had just been promoted to the status of an investigator. So in respect of both persons, you were the lead investigator, correct?
At commencement means the same thing as at the beginning.
Yes, ma'am. And then you say after that, after the commencement or beginning or start, the investigation, you were given another investigator who had just been promoted. Were you the lead investigator even at that stage, which was no longer commencement?
It was now at this stage shared because he did some of the work. And I was there only for, you see, okay, can I explain what is a lead investigator? A lead investigator is the person who will draft the rudimentary report. So before I had Advocate Livuani, I did the document drafting, and the initial document that I was consulting with was drafted by myself. But once I had somebody who was an investigator, that's why the report writing and scheduling of meetings.
So is your answer then that when you were given a young investigator who had just been promoted to the status of an investigator, that person was the lead investigator, or you?
It was a shared.
Okay. Were you?
Can I finish the answer?
Were you a co-lead investigator?
I would say that I wrote that it was an outlier because it had never been done that the public protector does an investigation. Because as public protector, you don't have the time to do that. So he was sort of the main, but with me there every step of the way. I think, yes, to say we were co-investigators would be fair, except that he was more main than me because the rudimentary documents now fell on him. Whereas when I was still with Tevane, the rudimentary documents still fell on me.
But the investigation was virtually being conducted by you.
It was conducted by me and this young investigator who has appeared before this committee.
Yes, but your statement says the opposite, ma'am. You say it's 7.1. The CX investigation was an outlier in that it was the only investigation that was directly supervised by and virtually conducted by myself, which is just the wrong grammar. I'm sure you wanted to say by me, conducted by quote unquote myself as public protector. I'm saying that the is that a statement of fact, or are you now changing that?
So that's again, those slides, when we start talking again about pointing each other's mistakes, just be sure that you have started again and don't be offended if it's brought back. Okay. As I said, it says virtually. So virtually doesn't mean exactly.
Why are you threatening me now? With bringing back whatever you want to bring
I'm
back.
just letting you know that virtually means exactly that. Like I'm with you now, virtually.
No, come on, doesn't mean the same thing. That's okay, that's fine. But you accept that the investigation was virtually conducted by you as the public protector?
Yes, that's what I've said, sir.
Right, yeah. Okay, so no, it's what you did not say, but I pointed it out to you, it's fine. And then that, as far as the CX investigation is concerned, then made it, quite frankly, unprecedented and even unsucceeded, because I can assure you that I don't think any other public protector, including you, had ever conducted an investigation at that level, or even after you. Now, so you might want to explain to the committee why such a, okay, sorry, let me ask it like this, madam. Would you agree that as a matter of policy, it is undesirable that the public protector himself or herself does the investigation, but that it's better for them to supervise? That's the structure of the act.
No, that's not true.
Okay, so you think
That's
it's
simply
quite
untrue.
so all right. So why then has it never happened in the history of mankind that the public protector investigates himself or herself at that level? And you said 7.2 correctly. Before then, no investigations were conducted from my office and no other was. So why was that practice or policy or culture developed?
Okay, when I say before then, I meant during my time. So I'm sorry that I didn't explain that I'm talking about my time, that before then, I had never conducted an investigation. I had personally done investigations before as public protector. And after this, there was no other investigation that was conducted by myself. I cannot speak for what happened under Advocate Mkhwebane or Bagwa, who dealt with the arms deal and other investigations. I would be lying if I said I know that they never conducted any investigation.
Okay, but at least you know that you never conducted an investigation before the CX one.
I said so. Even the virtually that you now claim to have corrected me, it is in my affidavit, sir. I said
No,
so in my own affidavit that this was an outlier. An outlier is an unusual thing, something that is out of the ordinary, because it came out of extraordinary circumstances.
Yes, yeah, that's what we're getting to, ma'am. I'm saying that an outlier is like an exception to the rule, correct? Yeah. I'm saying this was not an outlier as such. It's something that had never happened either before or after the CX investigation, at least during your term. You're quite right that you might not refer to other people's terms, but it was unprecedented and unsucceeded by anything like it, correct?
Was accordingly an outlier. I hope you don't intend for us to get dictionaries to define outlier.
Okay, that's I thought I'm avoiding, ma'am, the dictionary. Let's just use simple English. Before this investigation or after it, you had never conducted an investigation yourself? Yes?
In the office where I do the groundwork, yes.
Thank you. All right. Now, and now let's go to the reason that you give at 7.3. You say the reason for the anomaly was that the request by Advocate Paul Hoffman SC, sorry, to have this investigation conducted was rejected on grounds of the fact that the matters it dealt with preceded the genesis of the public protector. Who rejected it?
There was an intake and assessment committee, and then it also then goes to the think tank. So it would have been rejected by one investigator, and it went to the team, which is the assessment committee, and then it would have then gone to the think tank that also said no.
Okay, so effectively, that's what happened. This was rejected by an investigator applying the policies of the organization, and also rejected by the think tank. And you basically overruled both those structures, well, the person and the structure, correct?
I did, but this is what I did. Of course, you go back to the committee and say, there's additional information. What you didn't pick up is that there's this statement and the statement that I made this morning. It wasn't just they made a decision and then I overruled it. It was a decision was made. Then I traveled to Barcelona and met Advocate Paul Hoffman, who gave me additional information. And then I asked him to supply the additional information. And given the workload that people were already battling under, and the fact that at this stage, he seemed to think that there was no investigation that was going to be required, I then took it. So it wasn't just overruled arbitrarily. It was after additional information, I was persuaded that this could be done.
And you did not think it would be. Yeah, yes, no, I know that. You did not think at that stage that you should have then taken it back to the people who rejected it?
And of course it gets taken back. You don't just make this arbitrary decision. Nothing was ever done from my office. It still goes back to the registry, but I request that we accept it on the grounds that I am going to do it. So it didn't just go into a little corner in my office. It went back again. Advocate Paul Hoffman, that's why you'll see the new request is late dated. I think it's not dated in 20, oh God, I'll have to look at my notes. He had to resubmit the investigation. But again, that we can get from the files from Mrs. Sigele, who was responsible, I think, at that stage for intake, assessment, and customer service. Nobody did things in the little corner during my time.
Okay. Okay, so if whether it was a little corner or a big corner, the issue is that you're saying that there were also concerns regarding the efficient use of resources given the lapse of time, making this a cold case compounded by prescription rules regarding the recoverability of the relevant funds. So not only was it rejected on the basis that it preceded even the promulgation of the Public Protector Act. Do you think you have a right to conduct an investigation for a matter that even precedes the promulgation of the Act?
No.
Let alone about the 2 years thing for now.
No, definitely I don't. That's why my original report does not read like this report. I never investigated whether the gift was a gift, whether it was a lifeboat, whether it was a loan, whether it was corruption or not. No, even though some witnesses took me through that, like Judge Bertelsmann and others, I was clear that my investigation was what happened in 1998. My investigation was not whether it was a loan, a lifeboat, theft, or gift. My investigation was simply on receipt of the CX report. Did government act properly? And I had been made aware that it was not going to be an investigation at that start. It was the thinking or the impression that I was given by Advocate Paul Hoffman was not. It was going to be something that is almost like a mediation. By the way, with public protector investigations, when it's conduct failure, it would not be mediated. But if it's a service failure, then it could be mediated.
Okay, you've just said that your investigation was not whether it was a lifeboat or a gift. I'm putting to you that that is false.
Well, you can put it to me that it is false, but I will tell you that I didn't investigate whether it was a lifeboat or a gift. I was investigating the conduct of government at the point at which the CX report, that's why we called it the CX investigation, because it was all about what happened. In fact, I can share you my notes with Michael Otley. You will see that my concerns with Michael Otley, with all of these people, actually, my concern was about what happened.
Yes. Okay,
can I just finish the sentence? What happened when Michael Otley approached the government of South Africa as a bounty hunter, so to speak? And what happened at the point at which he submitted this report, which was different from what he was contracted for, by the way, but I still wanted to know what happened, and if what happened is not what should have happened, and then the implications financially thereof. It was always with the view that possibly some mediation would take place in this matter, which was my style, by the way, on some of these matters.
Okay, thank you, ma'am. I'm just going to ask you one thing. You've now twice said this here. Now, can you tell us, you know that you had that well-known style of naming these reports, secure and comfort, and those kinds of things. What did you call this one of CX?
We hadn't named it yet. Remember, I didn't leave an approved provisional report.
Yeah, okay, I'll tell you when you come back that you named it lifeboat or gift, which is what you are saying you did not investigate, but we'll deal with that
Thank you.
after tea.
Thank you, Advocate Mpofu. Thank you, Advocate Madonsela. We will pause for 10-minute break for tea and back 8 minutes to 4. as we finish our teas where we're sitting, let's proceed. Baba, lego hlula ucango. Aw. Ukuthembeka ngakho. Yeah, no, I finally got you. Thank you. Welcome back. Over to you, Advocate Mpofu.
Thank you, Chair. Ms. Madonsela, I was showing that the report, you know, Advocate Chualule.
Yes, sir. He was the investigator that I ended up working with.
The young one.
Yes. Brilliant
Yeah.
young.
Yes. Now, he told us that the draft that you left behind, and to be fair to you, you did say that this was not a provisional report in the sense that it was an approved one. I take that point. But that the draft that you left behind, because as we know, you did not finalize this report contrary to your intentions to do so by the time you finished your term, correct?
Yes, sir.
Yes. Now, if you go to, okay, Tsepo, you're going to have to help me here. Advocate Chualule's statement, it's bundle D3. I want specifically to go to 3222. I'm told it's item 15.
Okay, you can flight it.
But all right, just go to the end. We'll come back to the beginning. Just go to the right at the end. Sorry, but that's 3279. So that's the draft, which, as you correctly pointed out, you did not sign because there were still outstanding issues and so on. But it indicates your name and his, correct?
Yes.
Right. Now, you testified before T that you never investigated whether this was a lifeboat or gift. And I was telling you that that is false. And if you go to 3222, you see what name did you give to that report at Roman 1? Can you read it out?
This is a name that was given by Advocate Chualule. You went to the end of the report, Advocate Mpofu. All public protector reports look like that, regardless of who investigated them. It has the name of the protector and the name or names of investigators as assisting parties. So that doesn't mean it was my report. In fact, reports that I hadn't seen would have had the same ending. So that's not true. That's simply because Advocate Chualule, who states very honestly that I had asked him to go in and fix certain things, but also it was my style that after they fix certain things,
I think she's gone.
Are you there? You are muted. You are muted, Advocate Madonsela. Unmute yourself. You are muted.
I think somebody else muted me. I was just finishing a sentence that my style, which can be confirmed by everyone, is that once they had written and I had made certain comments of things that they themselves can change, then the final report would be done by me, and literally sitting behind my laptop, modifying language where appropriate. And of course, then it would also still go to the quality assurance team. It would not go to the think tank sometimes if it's a SAM, but it would certainly go to the quality assurance. So I didn't investigate the lifeboat, but here's the thing, sir. The fact that the title says lifeboat or gift does not necessarily mean you investigated the essence of what happened. You are still investigated the essence of if let's say it was a lifeboat, why was there no collection? Because all we were looking at, and you will see with the set of questions that we asked, and I refer you to what is online now is my interview with Chris Stolz. It's fully online. And then you will get what I said to him. I was investigating because he had been the governor of the Reserve Bank at the time this happened.
Ma'am.
Okay, just pause, Advocate Mpofu. Advocate Madonsela, firstly, before I intervene as a chair, I'm going to ask you, Advocate Mpofu, because once you start that conversation, you remain in charge of that, so that when you ask when you wanted to pause at a certain point, you have to do that or indicate. It's only when that is not happening, then I'll come in, but I don't want to disturb the flow between the two of you.
Yes, I understand that.
Yeah.
Okay. Ma'am, do you even remember what the question was? Or what I asked you to do?
The question was, no, it wasn't a question, it was an accusation that it's not true that you say that you did not investigate the lifeboat. And I said that you are the one who is incorrect.
Yes, no, it's fine. I think, no, it's understandable. You forgot what the question was. And I don't blame you. All I said was whether you could read what the title of the report was.
I can read the title, and then you accused me of being responsible for that title, and I was telling you that no, I was not responsible for the title.
All right. Now, okay, let's do it like this. When you receive this draft, let's go, I'll just take a random example. And I think you've just described it. Go to 3242, Tsepo. The bottom. So at those remarks on the right, those would be your corrections and additions, correct? Your comments.
No, these are cosmetic comments by someone, not me. I don't.
When you say what is the figure? Well, according to Advocate Shaulule, he sent these drafts to you and you were working on them. And he agreed with you that you had not finalized, you were still raising certain issues. So he never said he sent it to anybody else. So those comments would be yours. And according to your evidence, it was only you and him, you were the co-investigators. So let's not waste time on this. Those reports, those comments were yours, correct?
Mine, they would say that they're from me. Usually the computer says whose computer is it from. My comments were extensive towards the end, and they were not cosmetic.
All right. Okay, that's fine. If there were only two of you.
So I don't know which version is this one. It's certainly, I wouldn't have done the cosmetic.
All right.
But I also don't understand where this is going, because the Constitutional Court has ruled on this matter. Are we going to try and review that ruling?
No, we are not going to. And I told you earlier, as a witness, it's not your duty or obligation to say where the questioning is going. That's my duty. Yours is to answer the question. All I'm saying is that what you're saying now is startling, to say the least. You testified that this was a so-called outlier, and that means that you and Advocate Chalule were co-investigators and nobody else. That also coincides with his evidence. And now I'm saying to you, there is a comment, for example, at 3242, which says, what is this figure? Something about 1.5 million. So he could not be asking himself that figure, that question. If
Did
it was
you ask him? Did you ask him who asked this question? Because
yes, he did say. Yes, he said, like you said, that it was only the two of you. So
no,
who else?
He specifically said in his statement, sir, that on his last day, 3 days before I left office, he submitted the final report, which I responded to. So where is that version? Because that would have been the only version that should be material.
No, ma'am. Okay, okay. You know, really, I think you're just
that is in his statement, sir.
Okay, all right. In your estimation, just as a matter of logic, if it was you and him only involved in this, and he made a draft, and the other person commented and asked about figures, who else could it conceivably be other than you?
Towards the end, he does say that towards the end, some of the quality assurance people, we would ask them questions. And I wouldn't be surprised if he asked somebody who was a quality assurer these questions, because this is more technical questions. My questions were substantive questions.
All right. Anyway, the point I want to make is a simple one. When you received these drafts, you made comments yourself. Let's assume these ones are not yours. You made your own comments, correct? You did?
I did, and usually by hand, actually.
No,
usually it was by hand.
Yes, okay. And in none of those comments that you made, did you change the name of the report from lifeboat or gift, correct?
We changed the names at the end, and that you can confirm with the team. Because that was not, we were not in a hurry. Some of the names would actually change hours before we release it, like secure in comfort. The answer came as so no, we wouldn't be bothering about names at that age.
Okay, all right. So it would seem therefore that your evidence that you did not investigate whether this was a lifeboat or gift is false, because that's exactly what it was. That's the first impression, or the very first 3 words.
May I just clarify once?
Yes.
You asked me when we started that with this matter having been rejected by my staff, a proper intake and assessment team, with me having signed, because when they reject, they don't just send it. I sign and I agree to the rejection. Why did I investigate it? The only way I could investigate it was if there was a coincidence between our remit and what we were trying to do. And you must realize that, as you can see in the report, we interviewed so many people. They themselves would ask us, what allows you to investigate this matter, given the fact that you were not born before it started? And then would explain to them that we're investigating from 1998. And I have said to you, instead of me and you hagging and tackling about what exactly was I investigating, one of the key people that unlocked this matter was Chris Stolz. My interview with him is fully online. Just check it out.
No, that's fine. That's your answer. That's your answer. I was just pointing out to you that that was the title of the thing. That's fine. Then you say at 7.4 that you were persuaded to take this case on, irrespective of all these weaknesses. When the complainant, that would be Advocate Hoffman, assured me it would be a slam dunk. Now that's slang for saying it would be easy. It would be something that was not going to take long, correct?
Yes, I apologize for the language there.
No, that's fine. I think we all know what that slang means, yeah. But it's fine. There's a whole thing about slang in affidavits, but that's fine. Okay, that it would be a slam dunk in that there were documents indicating that the debt is admitted and funds set aside by the bank at the center of the complaint. I don't know what that means. What were you trying to say there? You wanted to say where at the center of the complaint?
I was persuaded to take it when the complainant assured me that it would be a slam dunk, in that there were documents indicating that the debt was admitted and funds set aside by the bank at the center of the complaint.
Yes, no, I understand that. I'm saying, how can that make any difference? If it's illegal, or rather if it's against the act, or if it predates the act, whether it's a slam dunk or not a slam dunk, cannot be a reason for you to investigate something that is that falls outside of your jurisdiction.
That's why I have explained to you that with the conversation that I had, it was very clear that I'm being asked to investigate the CX report, not. Okay. And that's why it kept being regarded as a CX investigation, because it was all about what did you do with the CX report? I mean, I can show you my notes with Billy Masetla. The focus on it, there's no way where I even asked anybody, why did you give away this money? Some volunteered the information about the money because they had done the work already, like Justice Dennis Davis and Bertelsmann. But everyone else was asked about 1998. Only.
Okay, ma'am. All right. And then you say that the matter ended up being, you didn't answer my question, but it's fine. Let's move on. The matter ended up being far more complicated, though we persisted even after loss of time, after the trainee investigator left. So even when it became clear that it's not a slam dunk and it was more complicated, you continued to spend money on it, correct?
I did, because...
Yes, thank you. No, I just wanted to know that you did continue, yeah.
I don't like these hanging questions. You, not me, insisted that context is everything. You didn't even allow me to explain that it's not everything, it's an important factor. Even if Justice Kampempe said something about it, that was in obiter, not res. Not reason.
You want to say ratio decidendi? Yeah, that's Latin. It's very difficult. So, okay, that's fine.
You love actually getting these small jibes, eh? They make you feel a little bit more competent.
I'm assisting you. You wanted to find the words ratio decidendi, the reason for the decision. Yes. Yeah.
But I was in the process of saying that, and then I thought that for other people, it's important that they understand there's a difference between a comment and a reason for decision. And what Justice Kampempe said was not reason for decision.
So that then, I mean, that's okay. Let's not go there. You want to debate stare decisis with me?
Oh yes, you've just missed it actually with the one case that you insist on, the one about the affidavit. So you've just missed it.
Okay, that's fine. That's fine. It's not okay. Let's not go there. Let's not go there. You and I, if you want me to explain the principles of stare decisis, the ratio decidendi and the obiter dictum has got nothing to do with what we're discussing, but that's fine. So you say the matter ended up being far more complicated, though we persisted. I'm simply saying that you rather, even after you realized that it's not a slam dunk, you decided to proceed with it. That's really just a simple issue, yes or no?
I had answered, and then I said to you, I must explain. I don't like the hanging.
Okay, go ahead.
Yes, so I did say, yes, there were reasons to proceed because I still saw the prospect of some success. And at that stage, it was the prospect of some kind of mediation on this matter, of negotiation of this matter. If you know that the powers of the public protector include conciliation and mediation, and on matters like this, that was being considered. And in fact, that's what I was beginning to put forth on many of the parties that I was talking to, because I knew that if we're talking legality, we would have problem. But if we're talking morality, there was room for moving forward.
Okay, let's do this, ma'am. Before we get way laid into topics that are going to get one of us into tight corners. Let's go to your next paragraph. What you say you left no final report or approved provisional report. We've established that.
Yes,
correct?
sir.
Yes. So, and you are familiar with the principles of the mail-in guardian case. Because of time now, I won't be able to take you through them. But effectively that the public protector is not bound by the four corners of the complaint, and he or she may broaden or limit the complaint. And in fact, the best example of that is the fact that the public protector, in terms of the act, can even start an investigation without anybody's complaint.
Absolutely.
Good.
By the way, I'm the one who wrote the public protector's standard operating protocol. It started with using the mail-in guardian as our training tool.
Yes, good.
Discussing it as a team, extracting those principles initially as guidelines, but later extrapolating them. And I got one of the investigators, actually, if it's not Matlawi, I can't remember. Or it must have been Dicheni. And then we extracted them in they are in the standard operating protocol that I drafted. So I wouldn't not know the mail-in guardian principles.
Yes. No, nobody said you don't know. In fact, I said the exact opposite. I don't know why you want to be defensive about it. I said you are familiar, of course, with the mail-in guardian. And then I went on to explain what it says. I was just asking you whether my summary was a fair one about...
it is fair.
Pardon?
It is fair.
Thank you. And therefore, if that's a fair, and this is now for the purposes of the absent Ms. Mazoni, who's not here, or who's being kept away. So it would be, I'm trying to say this in the most charitable way, it would be, I can't find another word, nonsensical to accuse the public protector of broadening the scope, because that's exactly what mail-in guardian says you are entitled to do. You can broaden the scope of the investigation, you can narrow it, and you can even invent it. I'm exaggerating. In other words, you can investigate when there's no complaint at all, correct?
I wouldn't say it's nonsensical. It would depend on context, and I wouldn't say context is everything, but I would say we would want to know what is the narrowing, what is the expansion, And again, this is a matter that has been ventilated in court.
Yes. No, let's not go to the court. I'm asking you now. It's not the court that is on the stand. I'm saying that generally, we in terms of the principles of male and guardian, the public protector has wide powers to broaden the scope of a complaint, to broaden the scope of any investigation, and to narrow it. And I'm saying, to illustrate that point, he or she has even the scope to create an investigation when there's no complaint at all. That's the essence of male and guardian, correct?
I didn't read male and guardian to say you can broaden the scope. I understood the male and guardian to say there's no barrier to how far you can go to find information. For the people who don't know the male and guardian case, this is the so-called Oldgate case, which I got to litigate. That's why we have this jurisprudence, taking it over from my colleague, Mkhwebane. And the issue there was not about broadening the scope of an investigation. The issue was about self-limiting. When the public protector didn't follow the money when it went with Mvome, and saying that that was now outside the scope of the public protector because it was outside state entities. So I don't think the male and guardian principle is about broadening the scope of an investigation, unless you read it differently, sir.
Really. Okay, so you don't think male and guardian, which says that there could be effectively a complaint about, let's say, a car. And if the investigation then leads to a bus and a train and an aeroplane, and I don't know what other mode of transport, then that's what you must do. You won't be, unlike a court of law, you won't be limited by the four corners of the pleadings or of the complaint, but you can broaden it in the sense that I've just explained, in that if the evidence leads you to the bus and the train and the aeroplane, you investigate that too. You don't regard that as broadening. Let's say an investigation.
My understanding, which is what we put in our investigation standard operating protocol, is that you've got to follow the evidence wherever it has gone. And that you've got a lot of powers and you should not self-restrain. But you're right that the powers of the public protector include the power to investigate both what is alleged and what is suspected. But for me, with my team, when I trained them, which is the same training that is given in Canada, etc., and in other places, is when you investigate, you have to still be clear what is the issue, what is the evidence, and what are issue creeps.
All right. Okay, and you say you wrote a manual on male and guardian.
No, I wrote the manual that the public protector is using, and the male and guardian case was the basis of how we started our training each other on what is a proper investigation as determined by the public protector versus male and guardian as decided by the SCA.
Yeah. All right. No, that's fine. I think we'll at least we had some expert witnesses who correctly interpreted the male and guardian case. That's fine. And anyway, people can read it for themselves. It's not a very complicated case. Okay, so you've already testified about the SSA issue and the shenanigans that happened in London. So let's just go maybe to the gist of what you say in G. I'm chairperson, I'm at paragraph 7.6, which is on the third page. The pages, your pages are not numbered, Professor. So it's paragraph 7.6 at G. You say there, and I suppose this is the culmination of what you want to say about this. Key changes that I have observed in the final CX report include the remedial action regarding changing the powers of the Reserve Bank, which was not an issue as the issue concerned lending and debt collection practices. Where did you see those changes?
In the final report, the issued report.
Where did you get that?
In the remedial action. Okay, do you want to fly to the report? I don't have it now.
No, I don't.
The report.
I don't want to flight it. I'm asking you, there's nothing to flight. I'm asking you, when you say the key changes which you observed,
yes.
It was in what was that? You observed them where, on what occasion, for what reason, and so on.
You see, if you had asked me in advance, I would have flighted the report. So I'm going to paraphrase the report. The final report deals with the need for an instruction to Parliament to change the powers of the Reserve Bank. This investigation was only about the lending practice and debt collection, because when you lend, you've got to collect the debt. And I've already indicated here that from the evidence that we got, the interest, though agreed as collectible, had not been collected. So there was nothing beyond that in terms of what we were remedying, because in each report, you ask what happened, what should have happened, is there a discrepancy? And if there's a discrepancy, has somebody suffered an injustice, and how do you remedy it? So there's no remedies that just fly from the blue. Your remedies are determined by that logical framework of what happened, what should have happened, is there a discrepancy?
Okay.
And to the extent that there's a discrepancy, was there harm caused? So the remedy is to remedy the harm. That's why you call it remedial action.
Yes,
so
thank you very
remedy much. If there's no harm that has been caused in your findings.
Okay, please try and limit your answers to my question. I've not asked you any of what you're talking about. I'm saying, maybe let me just explain what I'm asking you and why I'm asking you. When you say you observed the final, that includes the remedial action regarding changing the powers of the Reserve Bank and so on. Because there's no such thing in the report. I was just establishing whether you established it from newspapers, from whatever it is, or did you actually read the report itself? That's all, really, ma'am. It's really that.
So if you say I am lying and I did not
no,
read
I'm not saying you're lying, ma'am. I'm asking you, where did you observe this from? I didn't say you're lying.
It is in the I'm saying it is in the report. So
you observed it from the report. So is your answer that you observed it from the report?
You keep asking me,
okay.
And then as I'm speaking, you
can I ask?
me.
I can't.
I don't understand. Do you want me to answer, or do you want to answer yourself?
Just hold back, Advocate Mpofu. Can you complete the answer on the, Advocate Madonsela?
Sure. Right. My reading of the report is that that's the remedy. One of the remedies is one of the changes is the requirement as a remedy that the powers of the Reserve Bank be changed. That's my reading. I don't have the exact wording right now, But if you want me to look for the wording, I can quickly scroll into my documents, find the report, and then
I'll
flight
put it up.
it.
I'm going to flight it, ma'am, when we come to that. We are not there. I've asked you a very, very, very simple question. Where did you make these observations? Was it from a newspaper or from the report itself or from
the report itself?
Interview? Thank you. That's all. Okay. Now, if it was from the report itself, then I'm going to ask Tepo to flight the, and you say, Tepo, it's at page 69 of A1, I think. And you're saying that there was an instruction to who?
Where did I say there was an instruction?
You just said it 5 minutes ago in that long speech you made. You said there was an instruction to Parliament to change.
I didn't even mention Parliament.
Okay, you didn't say there was an instruction.
I just said there was a remedial action to change the powers of the public protector. And then
Yes,
my
ma'am.
long story was about, for every wrong, there's a remedy, but there's a logical framework to how
Yes.
you arrive at the remedies.
You didn't use the word instruction in what you said.
I don't remember using it. If I did, it's so weird that I've forgotten that. But of course, we're on record. So
No, the whole
something
thing is weird, but I'm simply saying you did say it was an instruction, but that's fine. Let's not quibble about that. Whether you said it or not, the record will speak for itself.
I don't remember saying it.
Did you read an instruction from anything that was said?
I never used the word instruction. I used the word remedy.
Okay. I'm not going to argue with you, ma'am. You did use the word instruction, and as I say, the record I will send it to you once it has been transcribed. But so, what are you saying now? Was there an instruction or no instruction?
I am saying there was remedial action. I haven't spoken about instruction. I spoke about remedies, remedial action. And I said there was remedial action about changing the powers of the Reserve Bank.
Okay, ma'am. Well, I'm sure you'll somewhere on social media, it will be played for you that you said the instruction. So we don't have time now. So, all right. But whether you said it or not, you are saying that there was an instruction. Okay, are you saying there was an instruction or no instruction? Now, forget about whether
there was remedial action. Can we stick with my language?
Yeah,
Stop
but I'm
trying
asking
to
you
put language into my mouth.
I'm not. No. Then you don't understand what I'm doing. I'm asking you questions. You can. I don't have to stick to your language. I'm the one who's asking questions, so I use the language that I choose. I'm asking you whether. And I'm not saying you said it or you didn't say it. The record will speak for itself. I'm now asking you afresh. Did you read any instruction in what the public protector put as remedial action or not?
I wasn't looking for instructions. I was looking for remedial action.
All right. Now, you would agree that one of the things that Mail and Guardian and I think the EFF Nkandla case also says is that the public protector, the wide powers of the public protector include going to what he or she regards as the source of the problem, the root cause, I think is the words that are used by Mkhwebane. Correct?
Yes.
Yes. Now, and you therefore agree that if the public protector regards in his or her wide powers the root cause to be X, then that root cause has to be addressed, correct?
Yes, absolutely.
Good. Okay, now we're getting somewhere. Now, in this case, the public protector identified the root cause, and she not you, not me, was the public protector, as including what she said at 5.3.227, that's page 65, which was that the Republic has an obligation in terms of the Constitution and international instruments to improve socio-economic conditions of its citizens through legislative and other measures to alleviate poverty and ensure social justice for all South Africans. Government must realize economic rights to its people. And then she goes on to say the decision not to recover is seriously prejudicial to the people of South Africa, particularly the poor, who would have benefited through social development programs. You don't quibble with that, correct?
I do. I would have put it differently because with the investigation that I did, I think I have no quibbles with this, but do you want me to give you a bit of context?
No, that's fine. If you have no quibbles, that's good enough for me. So, okay, then I'm now saying that the public protector, rightly or wrongly, because she's the public protector and not you, not me at that time, having identified as part of the root cause, the mandate of the Reserve Bank, then made the remedial action that you're referring to. And I'm going to send you there. It's on page 69. It's the one to the Portfolio Committee on Justice and Correctional Services. That's a committee of parliament. This is the one that caused all the hullabaloo with the chattering classes and those types of people. So she says, the chairperson of the Portfolio Committee on Justice and Correctional Services must initiate a process that will result in the amendment of Section 224 of the Constitution in pursuit of improving socio-economic conditions and citizens of the Republic. You understand, okay, you may not know the processes of Parliament, but a process, you know that a process which is aimed at amending something like the Section 25 of the Constitution, the process that we had 2 or 3 years ago, is something that is allowed, but it may not result in an actual amendment. Do you understand that? Just as a constitutional scholar or understanding of how our parliament works.
I do, but I think there's a word that we are forgetting there, must, on line 2 of what you are flighting.
Yes, yes.
I think when we are finished with this, sir, please allow me how I understood, because you're now asking me to second guess my successor. All I had confined myself to what changed. I didn't say what change was right or what change was wrong. That's up to this committee to make that decision. It's also been up to the courts. What I can do as your witness, sir, is to explain to you how I dealt with powers of the public protector versus things that I observed as the public protector, but that were not in my remit. Again, understanding my powers long before the Nkandla judgment, but understanding my powers correctly.
Yes, no, that would be very interesting, but if you can just stick to the answer my questions here. So if we get time, we'll get to that interesting debate. I'm saying, do you know what a motion is in Parliament? A motion is like a proposal, correct?
Yes, but it's by parliamentarians. Must. Yes. I think the issue for me is the word must.
No, just answer the question, madam. Do you know
yes,
that
I understand what's a motion? we are on a motion right now. The trigger of this process was a motion, sir.
Exactly. So that was a motion of Ms. Mazoni, correct?
A parliamentarian, yes.
Yes. And so that motion is then a proposal. Parliament could have rejected Ms. Mazoni's motion, correct?
Exactly. You're
Right.
very correct.
Okay, good. Now, the public protector then says, yeah, the pursuit of socioeconomic by introducing a motion in terms of section 73(2) of the Constitution in the National Assembly, and thereafter deal with the matter in terms of section 74(5) of the Constitution. So that would be, as you correctly say, like the motion of Ms. Mazoni, it would be tabled in Parliament, and it would either, if it achieves the correct majority, it will succeed. If it doesn't, it will fail. That will be the end of the matter, correct?
Yes.
Thank you. Now, then the rest of it is then the proposed wording of that amendment, which may or may not, with you and I have established, may or may not succeed. And it's a banal or a harmless thing that says, the primary object of the South African Reserve Bank is to promote balanced and sustainable economic growth in the Republic while ensuring that socio-economic well-being of the citizens are protected. You wouldn't quibble with that as well, correct?
I would quibble with what is it doing here?
No, ma'am.
If one of my investigators wrote a draft with this, I would ask, what is this doing here, say? Number
Yes,
one, our power to instruct Parliament. Two,
yes, ma'am.
what are we remedying in terms of what the wrong we were looking for and our findings about that wrong?
Yes, but you're taking us back now. I said to you earlier, and you agreed, that the remedy is for what the particular public protector, not you or me or anyone else, regards as the root cause. So that public protector is not going to ask that question. You might ask it because you might have a different root cause. I might ask it as well because I might have a different root cause. But a public protector who has identified as he or she is entitled to do a different root cause will not ask that question, correct?
But the public protector, and so we're now talking a hypothetical, a reasonable public protector, not, so a reasonable public protector would have contested inside the report why this is an issue. It couldn't just randomly pitch at solutions.
Yes, ma'am. And that, okay, if you just listen, you know, one of the attributes of a leader is to listen. I'm saying to you, I'm not talking about a reasonable public protector or an unreasonable one. I'm saying to you, this public protector identified as the root cause, rightly or wrongly, let's put that aside, identified as the root cause the issue of the mandate of the Reserve Bank. And we've agreed that she was then suggesting that there should be a motion in that regard. So take that as for granted. So that a public protector like that is not going to say, what is this doing here? Because he or she has already identified the root cause, rightly or wrongly. Do you understand that? Do you grasp, do you understand that notion that
no,
a person—
I don't, sir. On the
You
one
don't?
hand,
Okay,
you want
fine.
me to
No,
put
fine,
in
then let
the
me not bother
shoes
you.
of this public protector. On the other hand, you don't want me to use my brain. I therefore don't understand what you want from me, sir.
No, that's fine. That's fine. No, you don't understand. I think that's, we'll forgive you for that. Yeah. But anyway, let's now talk in broad terms of the Nkandla report and the Mail and Guardian report, or rather judgments, sorry. I don't have time now to take you through Mkhwebane CJ's judgment, but you know that in that judgment, as well as the one that you and I were involved in, your very last one, which was state of capture, that the wide powers were affirmed in those two judgments, correct?
Absolutely, sir.
Yes. And in fact, just maybe anecdotally, so that people can understand where you and I come from with this, without the intervention of the parties that were represented, the state of capture report might never have seen the light of day, correct?
Certainly, sir. And we thank those parties. Our country would continue to be under the grips of severe state capture, which is still in, but not that severe.
Yes, that's fine. That's fine. All I'm saying is that the state of capture report which was released literally on your last day. There would have been no Zondo commission and all these things had we not intervened at that moment. There might not have ever been a Zondo report, correct?
No, sir, it's not true that it was released on my last day, because President Zuma litigated and I left without releasing the state capture report. It was released much later. Thank you.
Yes, but it was litigated upon on the 13th of October when you were leaving on the 14th. So had that litigation been successful or not opposed, then that could have been a successful, you know what I mean? If it was successful, it might have led to a situation where we might not have had the Zondo commission and all what followed. We know what followed. You're right, on the 3rd of November, actually, it was released by the court to the hands of the speaker and you were already gone. So that's fine. I'm addressing something else. I'm saying without that intervention, because that was released by a court order, then whatever else followed would not have happened, correct?
That's
yes.
true.
Thank you. All right. And in fact, I can tell you for free that you have Honorable Malema to thank for that, because he's the one who made us not to sleep the whole night to make that intervention. And
I'm grateful to Honorable Malema, and I'm grateful to every human being who made sure that as a country we push back against impropriety, and grateful to you for your role too.
Thank you. Thank you very much. But as it were, and this is something that I just wanted for you to confirm, because there's a fixation sometimes. You spoke very well, and I agree with you about the balance between fairness and rigor. In other words, you can't just chase deadlines. You also have to make sure that in the process you produce a quality product, correct?
Yes, sir.
Yes. And that lesson, I think, can be learned then from that example that you and I are talking about. The reason why you wanted the Commission of Inquiry to be set up was because you had estimated that that investigation would cost 130 million and 6 months. You did not have the 130 million, correct?
No, that's not correct, sir. I think we had asked for only 6 million.
Only how much?
You mean from our side? The investigation
Yes.
done by the purporter, we asked for 3 million. We didn't ask for 130 million. We asked for only 3 million.
Okay, so you suggested a commission because you thought that it would cost 3 million to do that exercise.
Okay, no, please repeat the question. I thought you were
okay.
asking.
Yeah, no, it's fine. If you listen, it will help. I'm saying in the state of capture report, you proposed that there should be a commission of inquiry, which we now know ended up being the Zondo Commission, because
Yes.
you could not afford the amount that was required to do that investigation, which you had estimated at 130 million rand, correct?
That's totally incorrect. Very untrue.
What was the figure?
we had estimated as the power protector that we were going to need 3 million to conclude that investigation. We only got 1.5. So the only reason we didn't finish that investigation was time, not money. We got the money late, and by the time we went full speed with the investigation, we ran out of time. There was never 130 million. I have no idea where you got that figure from.
Okay. No, that's fine, ma'am. We will deal with it. The evidence is all there, but let's say it was 3 million. The point that makes my point even bigger. I'm saying that, so I'm happy to work on your figure. So that job which you had estimated to be 3 million, you know that it ended up the actual commission cost anything between 1 billion and 2 billion, depending on who you listen to. But the point is that it was far more than the whatever you had estimated, whether it's your figure or mine, correct?
Absolutely, sir. Yes. I had a particular understanding of how soon the commission was going to take off.
Yes.
It would have been cheaper because he would have been able to get all of the witnesses on time. And of course, the longer it takes to conduct an investigation, the colder the case becomes. And also, I had not expected President Zuma to expand the mandate of the Commission of Inquiry. So the investigation I ordered was based on certain circumstances, which is simply conclude the one that I was doing.
Yes, ma'am. That's my next issue. You also estimated that the exercise would take 6 months, and we now know that it took 4 years or whatever. And you're right. The reasons is that is what you said earlier, namely that you had to you had to balance. I mean, the chairperson he got about 5 or 6 extensions, I think, simply because the evidence that was before him could not just be cut at half mid-sentence, correct?
No, that's not what I said, sir.
No, I'm not. It's what I'm saying. Do you agree or not? Not. It's not what you said. It's
no, I don't agree, sir.
Okay, good. All right, that's fine.
The delay I said to you, sir, was because the mandate was expanded far beyond what had been asked. But also, at the end of the day, it's about processes such as like this, where, for example, we spent a whole half a morning dealing with things that we could have dealt with elsewhere.
Yes. No, I'm saying, ma'am, okay, maybe you're not familiar with this. Do you know that Justice Zondo, on his own estimate, when he knew the mandate, right, and how expansive or not expansive it is, then estimated that, for example, he was going to finish by the end of a particular year, and that turned out not to be the case. And then he went again, and then he went again, and then went again. He knew the mandate. So let's forget about the expansion of the mandate. I'm simply saying that because of the evidence that was accumulating before him and the need to give people a chance to refute the evidence and all that, he was, in fact, even in the end, I think he had not finished his work. But that's why there were those extensions. You don't agree with that? Is that what you're saying you're not agreeing with?
I really don't know the complexities behind the delay of that report. All right. Because you didn't indicate to me that, sorry, sir, can I just finish that? You didn't indicate that you're going to make me an expert witness on that. I would have reacquainted myself with the report and what Justice Zondo said about the reasons for the delay.
No, ma'am.
And then assess them based on my own rationality. Okay. Yes.
No, you don't have to. Okay, you don't have to be an expert, ma'am. You just have to be a South African. I'm saying every South African knows that they might not know the number of times. I know it was 4 or 5 times, but they know that the committee asked for multiple extensions. That's all. You are aware of that.
Yeah, I'm just battling with where are we now? Why are we now discussing the state of capture report?
No, don't worry about where we are. I'm saying to you, okay, let me assist you. When you were going towards the end of your term, you had about 10 reports that you wanted to finalize before you leave, including CX and Friede and state of capture, correct?
I can't remember the number, but there were many. And of course, the exact names of the reports, I think there were more than 10, but we can be guided there. We shouldn't speculate. I wrote a report that indicated what was outstanding.
Yeah, okay. Just answer the question, ma'am.
I don't know what was the number, because again, if you had asked me these questions, I would have asked the public protector to assist me with that preparation. This is what makes commissions of inquiry take forever.
Okay, yeah, especially if witnesses behave the way you're behaving. I'm asking you a simple question. I'm saying, if the reports, don't worry about the number, whether it's 9 or 7 or 8, but did the reports that you wanted to complete by the 14th of October on your departure include CX, Friede, state of capture, and I think the Mandela funeral report? There's evidence here that those were the reports that you had intended but failed to conclude at the end of your term. If you can't remember, just say you don't remember. You don't have to cast
aspersions. They are among the reports we planned to conclude as it.
I'm grateful. Thank you. I'm grateful to you. Thank you. That's all I wanted to know. Yeah. Now, I'm saying therefore that despite all those good intentions, because you couldn't just meet the deadline for the sake of meeting it, certain things had to be done. You therefore did not finalize or release those reports as you had intended, correct?
Certainly.
Good. You see how easy that is. All right. Now, the issue that yes. Before we get to the Friede report, you mentioned we were just talking about the Nkandla report. Is it correct that in the Nkandla report you used the version of the code that was subsequently found to be inapplicable by the Constitutional Court?
In terms of reliance, this is where again we spoke earlier about the difference between obiter and ratio. I definitely did not rely on it, because had I relied on it, I would have actually asked President Zuma to be punished for saying nobody built him, government did not build him a house, whereas government had built him a house. In fact, it's one of my, I didn't expect you to go there, but it occurred to me that there will be a lot of curveballs here. I have a note here about that had I relied on the version other than the one on the booklet that Sibongile and I did, I would have not arrived at the conclusion that I did.
Okay, so you're denying, that's fine.
So I'm saying it may have been, it may have been mentioned in that version, but I did not rely on that version.
Okay,
because it may have been a mistake, but in terms of what I relied on, read the report. In fact, I have, I didn't know, of course, again, that it was going to be thrown like that, but I thought that
you prepared on it, yeah. But you said you prepared on it. The point I'm making.
No, I said I did, yes, come across it.
Yes. So what's the answer? Are you denying that you used the 2007 version of the?
I'm not denying that I used it. I'm saying it may have been quoted, I haven't checked it, but in terms of my reliance there, we deal with, in fact, I deal with the president's bona fides. And I say in that report that members of the executive, look there, article, item in that report 2.3. I did not rely on that. You talking of members of the executive may not willfully mislead the legislature to which they
or inadvertently.
I did not rely on the inadvertently.
Okay, so
read my report. You will see the reasons. You were very happy to talk about the ratio dissidendi. Read the ratio dissidendi in that report.
Madam, as you might recall, maybe you don't, I was in that case and I was one of the senior counsel who was acting in that matter. So you can be sure that I've read that report many times and I've read the judgment, and there is reference to inadvertence in your report and in the judgment, but that's fine. That's, people can read for themselves. You and I don't have to quibble. If you don't know what you wrote, you don't know what you wrote. But
okay, sorry, I have not said I don't know what I wrote. I have said to you, I have, oh, sorry, sir.
Just a pause, Advocate Madonsela. I was addressing Advocate Mpofu to say you now need to start wrapping up your interaction. Advocate Madonsela.
Yes, sir.
Advocate Mpofu.
Thank you, Chair. Thank you, Chair. Let me just thank you. I think I know you appreciate the kind of what I'm dealing with here. Yeah, but I think I'm going to move, for example, from this because, as I say, the report speaks for itself, the judgment speaks for itself. So there's no point in me having a debate about whether inadvertence was mentioned or not. Okay, so then let's go to Friede. I'm just going to ask you a couple of questions on this because you basically, your statement doesn't address the issues in the motion. But just since you're here, I'll ask you questions that we would like you to assist the commission with. Again, you did not have a final report or a provisional report in this matter, did you?
No, I did not, sir.
Yes, thank you. So any notion by Ms. Mazzoni or anyone else that the public protector altered a provisional report by you would be, let's avoid that word, nonsensical, would be illogical because you never had a provisional report, correct?
I would not enter that space. If a report was issued that pretended to be a provisional report from me, then I wouldn't say it's illogical, I would say it's a mistake, but I don't know. I don't want to speculate about people's thinking.
Okay, ma'am. No, I understand that. You don't have to speculate. I'm asking you as a matter of logic, okay? If someone says somebody altered a letter written by me, and we can establish that I never wrote that letter, that would be illogical, just as a matter of logic. In other words, if the premise, it's what's called a premise if you studied logic here. So if the premise is false, then the deduction from that premise cannot stand. You understand? Just as a matter of simple logic. Yeah.
I think we studied logic differently. My understanding would be untrue, not necessarily illogical. I would say it's untrue.
Very good. Okay, then let's stick with untrue. Yeah. So it would then be untrue for anyone to suggest that Advocate Mkhwebane altered your provisional report if there's no such thing in existence as your provisional report. Just as a matter of logic, or simple logic, actually, not even as in philosophy, just like street logic, correct?
It would be untrue, not illogical.
Yes. All right. Okay, that's fine, whatever. But it would be logical. Is that what you're saying?
It would be logical for somebody to think that a report was issued if they saw one, or they read a judgment that said there was one. I don't want to enter into that space, Advocate Mpofu. I have said to you, I did not leave a report. You're asking me now to speculate about how to judge then anybody who
says that true statement.
I am not qualified to do that. You yourself said context is everything. For me, I think context is a factor. So I would not jump into illogic. I would look at the context.
That's fine. All right, I'm happy with that. And you, again, you had this report for what, 4 or 5 years? 2013, 2014, 2015, 2016, I think.
It was quite long, yes.
Yes. And you never finalized it, correct?
It was not finalized, yes.
Yes, and as we've now established, you never even had a provisional report.
Yes.
Right. Now,
are you going to ask me why? Because if you open a storyline, to be fair to me, I need to conclude it. These yes or no answers that want the public or the committee to fill in the gaps is improper. Maybe in adversarial justice, that's how you do. My understanding of the commission of this nature, or of a structure, not a commission, a structure of this nature, is that it's an inquisitorial process. So in an inquisitorial process, you want to know what happened, how it happened, why it happened.
Yes, ma'am. If I had my choice, we could be here the whole week and we would get into all those details. Unfortunately, I have to cover some ground in no time. Anyway, it's fine. Litigation doesn't work like that, yeah. But it's fine. So the reason why I'm asking you questions and sometimes leading questions is because the narrative is contained in my question, and you can agree or disagree with it. But fine, let's not go into the techniques of litigation. I'm saying that the report, or rather after that period of 4 years or so, there was not even a provisional report, and I think we've established that. And really all I wanted to say was that the new public protector who then came into office, obviously then because of that failure of yours to finalize it, which is not your fault because you tried, then had to take it over, and hers was not simply to just rubber stamp whatever you had done, but she was now the public protector and it was going to be her product. At least you'd agree with that.
Absolutely.
Thank you. and I'm sure that same thing happened to you when you got there, because there's always work in progress. Yeah. All right. Now, what I was really going towards, Ms. Madonsela, is that in that period of 4 years or so, you never met with the beneficiaries.
No, I didn't meet with the beneficiaries.
Yes. Okay.
It was not necessary. The most important thing that I did was to give a whole day training to the team on how to conduct a proper investigation using the standard operating protocol, which unfortunately, when I look at the final product, was still ignored.
Yes, no. And in that 4 years, you also never visited the Estina dairy farm?
No, I didn't. When the public protector is not the investigator, you don't do all on-site visits.
Oh, thank you.
It's just
because sorry, ma'am.
You trust your investigators. I had Advocate Celia doing that. And when Advocate Celia was struggling with it because she had been doing early resolution for the longest time, I assigned Mr. Samuel to do that. Of all of the investigations that I have done, I didn't visit every corner of the country to see everything. It was impossible.
Yes, no, I'm just establishing the facts. I'm not.
Okay. I'm giving you context.
Yeah, that's fine. The reason, let me give you context. The reason is that one of the criticisms leveled against Advocate Mkhwebane, who dealt with this matter in 7 months and finalized it, by the way, just as an aside. The reason why, one of the reasons she's criticized is because she did not meet with the beneficiaries. I'm simply saying that in 4 years, let alone 7 months, you did not meet with the beneficiaries. You've explained why. I just wanted as a factual fact that you did not meet with them. That's fine. So
sorry, sir, you made an aside. She did conclude it in 7 months without a forensic, and it was sent back by a court of law.
Yes, well, she finished it in 7 months and it was sent back by a court of law. That's a
balancing rigor with speed. Excellence is about both.
So excellence is sitting on it for 4 years. You regard that as excellence, and not even producing a provisional report?
Advocating Mpofu.
Are you being serious?
If you're sitting here to try and compare me with the public protector, I'm going to ask this committee. Now, wait a minute. I'm going to ask this committee to go and check at the public protector office if there isn't any case right now that is as old as these cases that you're trying to make me look bad for.
11 years. You won't find a case that is 11 years or 7 years or 6 years or.
Okay, let's do that.
Yeah, no, Mr. Niels van der Merwe already assisted us in that. I'm not saying you're the one, madam, who says that because something was reviewed, therefore it means it was not of quality, which is a ridiculous statement to make here. But the point I'm making is that I'm simply saying to you, it is better to produce a report, and if it is reviewed by a court, that's good too, because that's a learning opportunity, than to sit.
Can I respond to that, sir?
Yeah, that's all
Can
I
I
was saying.
respond to that? In my training, which I've trained even under Advocate Mkhwebane at the center that I helped establish in Durban. I have said, no, rather than do a shoddy job, do not conclude, because the worst thing that you do, and this is the training that you get in every training as a purported, is that when you say there was no wrongdoing, you are throwing your whistleblowers under the bus. When you say there was maladministration, when there was corruption, those who have committed corruption rejoice. That's a universal understanding. So yes, it's better not to conclude an investigation than to sign off on an injustice. That's my approach. What Advocate Mkhwebane, your client's approach is, that's her approach. But I'm just putting on the stand my approach. And that's the training I give to people is do not sign off on a shoddy job, because there's a lot of people that will suffer, including the complainants.
Yes. Well, I hope by that you're not suggesting that the report, simply because it was reviewed, it was a shoddy job. But if you are, that would even be more ridiculous than what I was commenting on earlier, because you know that there were many reports of yours that were successfully reviewed, or in your language, they were shoddy jobs, including the SABS judgment, correct?
There's no judgment that has been issued that has suggested that I did not understand the Constitution, that personally held me accountable, even with personal orders. There's no judgment that even suggested that I was dishonest. This was one of my responses to your letter when you were trying to surreptitiously throw this into this.
No, ma'am. I'm saying now you're talking about completely different things. You see, that's the problem with you. You said, I put a proposition to you that you did not do a report in 4 years that the public protector finalized in 7 months. Your response was that, well, that report was reviewed successfully. So let's keep it there. So I'm saying that the fact that a report is reviewed successfully is something that happened to you many times, including the judgments and National Empowerment Fund versus Public Protector. That is a 2017 judgment. SABS versus the Public Protector, where the following was said at paragraph 2.8. Oh yeah, you can please, it's, oh, sorry. It's bundle C, page 1460. I'm wrapping up, Chair. Item 41.
Please let me respond when you're done.
Yeah, like I've done all day. Believe me, we're not going to move to the next question before you respond. So I think that's, you would have noticed that's what has been happening all day. Yes, which one is that? SABS. Yes, can you go to paragraph 2.8? Okay. Sorry, Ms. Madonsela. It says there that, so I'm just trying to find the paragraph. It says the public protector exercises discretion to entertain these complaints despite the expiry of 11 years from which the second complaint was lodged, and despite Section 6(9) of the Public Protector Act of 1994. You remember that? That was another one where you had, according to this judgment, at least breached the 2-year rule and went over something that was 11 years old.
Right. Do you want me to respond to that, Sam?
Yes.
Number one, I did not involve myself in that litigation. Number two, the 2-year rule is not a rule of a prescription rule. It's a discretionary rule. Number
Yes.
three, which I asked you in all of the, in the wild accusation that some of my reports have had negative comments from judges. I said, I'm not aware of a single one of my reports that was litigated up to the Constitutional Court, not even up to the SCA. The very first case that I litigated as public protector was Advocate Mushwana's case. That's the male and guardian case. The NEF case, I disagree with the judgments. In fact, I have included in my teaching on administrative law every year ever since. It's the subject of my, if you read online, my inaugural lecture, my social justice lecture, I talk about how that acting judge erased the complainant. You know what, the things that you said last week about how your client was being ignored, the inconvenience to her was not mattering. That's exactly what happened in the NEF case. And the judge even comes to a conclusion where he says she knew that she did not qualify, when that evidence was never adduced. It's not even in the judgment itself. So that judgment is pathetically wrong. If I had been public protector, I would have litigated the NEF judgment right up to the Constitutional Court. Because if there's a judgment that is so far removed from proper administrative justice and Ubuntu, it is the NEF case.
Yes, no, I accept that you disagree strongly and you have strong words to say about the judgment. That's fine, join the club. I'm saying that so you agree therefore that the fact that a judgment makes such scathing remarks about you does not necessarily mean that they are correct. It could be shocking or all these things that you've just said.
I think if it's the Constitutional Court, we can't escape the issue of shoddiness.
I see. So the Constitutional Court, unlike the lower courts, is incapable of getting it wrong. Is that what you're saying?
He is the ultimate guardian of the Constitution.
Yes. No, I understand that, ma'am. I'm saying, therefore, if this finding in the NEF case was made by the Constitutional Court, you would no longer think that it is shocking and all the things that you've said.
I would be sad, but I would understand that that's the law now. The complainant doesn't matter. All that matters is inconvenience to an institution. If an institution strings you along, it's okay. And if a constitution fails to do triaging, which is a basic in every institution, whether you're doing UIF, whether you're doing the social grants, or you're going to hospitals, triaging to determine whether you are at the right place or not is a standard requirement. And a judgment that says it's irrational to have required the NEF to do triaging is incorrect.
Yes.
It's totally incorrect. But if it had been done by the Constitutional Court, yes, I would have been sad, but I would then understand that's the new law of the land.
No, absolutely. That's a different question. It would be the final, in other words, there will be no other court
Yes.
to go further, but it would still be as incorrect as it was when it was made by a lower court, correct?
Absolutely, if it's approved. And none of my decisions have been taken even as far as the Supreme Court of Appeal.
Good. No, we're together there. So it would be wrong. And that in the SABS case, I'm just trying to save time. It says that the public protector joined the second, paragraph 14, sorry, ma'am. That's 1477, Sepo. Public protector joined the second complainant with the first complainant because of the view that the withdrawal of the permit was directly connected and in revenge to Praduba's allegation against SABS. Despite not being able to decide the first complaint, the public protector persisted in entertaining the second complaint. Upon a reading of the papers, this acceptance of Praduba's view was not done with an inquiring mind as required by the public of the public protector. So in this other judgment, Judge Potterell said that you had approached the matter without the inquiring mind required of a public protector. Was that one also outrageous and all the epithets?
Well, no, I don't think it's outrageous. I think that's Judge Potterell's opinion. And of course, I would have still taken it on appeal. And that's the case that we dealt with extensively as a team at the Public Protector, and think tanked that whole entire brains trust. We think tanked a lot of times, and I do disagree with the judge respectfully, but I'm not saying it's one of those judgments that horrify me. The NEF judgment horrified me to the core. As a result, I've been using it in my teaching since then.
Yes, but I'm saying that on the SABS case, the final word is that you approached it without the open mind. In other words, in a biased fashion. You accept that?
I did not do so. If I had been involved in the litigation, of course, I would have defended myself. When Advocate Mshwana was no longer Public Protector and I had to deal with the mail and guardian judgment, I asked him what his thoughts were on it. But that said, all I am saying is I disagree with this judge, and I'm saying there is no judgment by the SCA or the Constitutional Court that suggests that I do not know what I'm doing.
Well, okay, ma'am. Would you agree that if you are biased, as this judge was saying you were, in the approach to the matter and not approached it with an open mind, that is a serious accusation against a public protector or a judge or somebody entrusted with so much power? Bias. If this judge said you are biased.
It certainly would have been, and I suspect that given the kinds of monitoring that I was subjected to during my time as Public Protector, this matter would probably have been brought to a committee like this. Unfortunately, the decision that you're talking about was made when I was no longer Public Protector.
Yeah, no, ma'am. I think I accept all that. I'm saying there's a judgment, which is the final word. You've said that correctly, that is the opinion of Judge Potterell. That's not what I'm disagreeing with. In fact, I agree with that. There's a view out there with those who don't know that would differ with you, that the judgment is the opinion of Judge Potterell, but I'm not one of those because you and I at least are educated in law. That's not the point I'm making. The point I'm making is that this is a judgment. It is what it is. It's a judgment of the court, and it is a final judgment. And it says that you were biased in your approach. And I'm saying that that is the legacy of your dealing with this matter. Let me I'll read you another part, paragraph 9. The public protector dismissed the complaint of the SABS that after 11 years, the file and documents pertaining to this matter were destroyed, and therefore she should not consider the complaint. In fact, she took umbrage with the SABS for doing this loss of records. This is an astonishing stance. If the SABC knew there was a complaint 11 years earlier, they could have safeguarded the documents, but the public protector simply did not inform the SABS of the complaint. She ignored the fact that the relevant person who withdrew the payment was available for an interview in lieu of the destroyed documents. What makes matters worse is the public protector herself submitted that her office unfortunately misplaced the original complaints and correspondence submitted to Pradubas. The pot calling the kettle black. The public protector balanced the mismanagement of the documents of the SABS with the prejudice Pradubas would suffer. Herein lies the substantive irrationality and the decision of the public protector as set out below. This is what I call scathing remarks against not only your bias, but also allegations that you ignored evidence, which is even worse than bias. You engaged in what the judge called the kettle, calling the pot calling the kettle black, the pot being you in that example.
Well, again, with due respect, I disagree with the judgment. Yes. But again, I don't know where this is going. I do realize that I am being impeached long after office. Unlike Advocate Mkhwebane, for whom this was supposed to be about, she has been given in advance what the allegations are, as opposed to what's happening here. I need now to go and look at the case that you're putting forth. I need to look at the investigation file and look at who was I working with as an investigator and to see what really happened, because I wasn't involved even in the litigation. In fact, even with the NEF case, I only discovered that it had been reviewed successfully when I was talking to people about the potency of the public protector to give remedies that are unusual. So I'm going to say I disagree with the judge's finding, but I would say that the finding of a judge of the High Court that is not upheld by the finding of the Supreme Court of Appeal or the Constitutional Court does not have the same weight in terms of who you are and what you can offer than the finding of the SCA and the finding of a Constitutional Court.
I see. So you
that's my opinion.
Yes, that it is your opinion and it's wrong. Yeah. But the finding of a court of law, which is final, is a finding of a court of law. It's correct that it's an opinion of that court, but it is if there's another case that comes up in Gauteng, this judgment would be binding on the judge, unless, as you know, unless if they find that it was clearly wrong. But the point is that there's no such thing. The binding effect of a judgment is the same, whether it's a magistrate court or a high court or a SCA or whatever. If it's a final judgment because it has not been disturbed. But that's fine. You can deal with that maybe when you're dealing with your students. The point of the matter, the only point I'm making to you is that you are the one who started making the snide remark that if a report is, you'd rather not finish a report than have it reviewed. I'm showing you that not in these cases, you finished the report, quote unquote, but it was reviewed. So you had the worst of both worlds. Because the churches found it as biased and astounding and astonishing, and the pot, you calling the kettle the other, that would be the respondent, black.
May I just correct you there, say?
Yes, ma'am.
You are not telling the truth when you said, I said I would never finish a report rather than have it reviewed. I said that I would not finish a report if the investigation has not been thorough. And I said that if I have to choose between promptitude and rigor, I choose rigor, and that's what I teach my students, and that's what I teach practitioners, and that's what is in many of these documents. So I do disagree with you when you are saying there's no difference in waiting to a judgment of a high court and the judgment of the Supreme Court of Appeal and the full bench of the Constitutional Court. I disagree with you, say. But again, lastly, to say, you've put me on the stand as a counter being impeached person. Because I don't know really why you brought me here. You brought me to answer for cases that I dealt with. You should have told me so, that this is about me, in which case then I would have spent days at the Public Protector team to get all of the information, because context matters. Earlier on, you accused me of not prioritizing Gogo Dlaminis. These are two Gogo Dlamini cases. The NEF case is a case of a Black woman of foreign origin who was promised money wrongly because he wasn't Black under the Black Empowerment Act.
Okay.
And after toing and froing, after the NEF going to the extent of establishing a bank account with her, and therefore her having a legitimate expectation that the
We've
NEF
got the
pay
judgment.
the money
We've
into
got the
her.
judgment, ma'am.
No, but I know, Advocate Mbofu, you can't have your cake and eat it. You can't.
No,
if you want to
I'm
bring
not-
these matters here, they have to be contextualized.
Yeah, but we don't have time, ma'am. You know,
But
we
then
don't
don't
have
bring
time.
them here.
The
Don't bring
judgment
them
is in
here.
front of the committee. I'm sorry, madam. I'm simply saying this judgment is in front of the committee, so don't worry about going chapter and verse. It was already submitted last year. So we
you've
know what.
spoken over me again, and it's okay when you do it, because I'm giving everyone the context.
Chair, please.
You're the one who said context matters, so it matters when you want it to matter.
Okay, ma'am.
It
Carry
doesn't
on.
matter when I want
The
it to
chair,
matter.
I'm sure the chair will give me extra time. Go on and be my guest.
Thank you, Advocate Madonsela.
Thank you.
We're about to wrap up now.
Yes, Chair. I was really, but yeah, really. Now, Madam, all I'm saying is that in this case of SABS, your report lacked in both rigor and promptitude. That's the point I'm making. You said you balance rigor and promptitude.
Yeah.
Because it was said that there was an 11-year period, and yet the report was found to be not only shoddy, but biased by the judge. Would you agree with that? Rightly or wrongly?
Firstly, I was public protector for 7 years. So if the case took 11 years, that would explain why some things somehow could not be found towards the end.
Yes.
I just think the first thing in this case is to find out from the public protector files what really happened. But I disagree with you, say, with due respect.
Okay, good. No, you don't disagree. You disagree with the judge that says it was a shoddy job. I'm saying it was like Mr. Nyatela's case where the 11 years included the entire 7 years of your term. So I don't think that's an example of someone who balances rigor with promptitude, because this was worse than shoddy. It was biased, and it also took extraordinary amount of time, and as Judge Potterill called it at paragraph 19, quite astounding. And she said, this is the remedial action that you made was nondescript. She says, the vague and nondescript and unobtainable remedy ordered was provide the complainant with a remedy, including a reasonable amount as a settlement for consolatory compensation to address the distress and trauma experienced by him and his family as a result of the manner in which matter has been concluded. It says, leaves one dumbfounded and needs no further address, said the court. That is shoddy.
If I may help you, Advocate Mpofu, in
Yes,
ombudsman decisions, it's not unusual to ask for two things: to ask for an apology and to ask for the wrong party to give some kind of compensation that is determined by them. You remember the case, the Sowetan case, where a young lady had been raped and her matter was postponed for over 8 years, and then we did an own investigation on it. What we did, we asked all of those who were involved in the conveyor belt to, number one, an apology from the Minister of Justice, and two, what we called sorry money, which of course the NEF judgment says there's no such a thing. We said some kind of sorry money determined by the Department of Justice, with the Department of Justice did come up with that sort of money. In fact, the report was accepted even before we finalized it. That's why we called it, no, it's not, they called it justice. And then what Dawkins says in hard cases, taking rights seriously, is in these very hard cases, when you can't find hard law, either in common law, the Constitution, or statutory law, you have to look at public policy. And one way of ascertaining public policy is what has been accepted by government before. It was on that basis that I decided these cases.
Yes.
Thank you.
No, yes, thank you very much. I understand. And public policy includes the mandate of the Reserve Bank. I'm still, ma'am, maybe you're getting me wrong. I'm on your side here. I agree with you. In fact, I've read that report in the SABS case, and I think that it's not that bad. Could have been much better. There's room for improvement, but that's not the point. The point is that the judge, and there are people who think that once a judge has spoken, then we should not inquire. The judge says it left her dumbfounded as to how you could give that kind of. It didn't leave me dumbfounded, but the judge said it left her dumbfounded, and it was quite astounding. And she says she doesn't even know what was going through your head when you made such findings. That's the issue.
Well, Advocate Mpofu, do you remember the SABC case, what the judge said in the High Court? And because I was public protector at the time, I litigated it and took it right up to the SCA, if I'm not mistaken. And eventually I prevailed. So I do think that I give respect to High Court judges, but that's why we have an appeal system. I give more weight to decisions of the SCA and the Constitutional Court.
Yes. Okay. Well, for the sake of time,
10 minutes remaining, and then we'll
I'm
close.
wrapping up now. Yes. Thank you, Chair. Chair, can you make it 15? I promise I won't go 1 minute over that.
You will do it in 10 minutes.
Okay.
All
right. Ma'am, I think you're getting me wrong again. I'm saying that my point is not the point you're making. My point is that judges can get it wrong, and that the mere fact that the judge said this is outstanding, astounding, and she was dumbfounded by your conclusion. Does not mean that that is so. If someone had to inquire into that, then they would have to look into the report and themselves be dumbfounded. You agree?
I agree. They would have to look at the facts. They would have to look at your understanding of the law,
Absolutely.
just logically, and see whether it was reasonable for the judge to make that conclusion.
Thank you
You're
very
right.
much. I am. Thank you. That's a hallelujah moment. Thank you very much. That's what we've been trying to explain that ad nauseum here. Yeah. All right. Now, thank you for that. Now, in fact, if it was a court, I would just stop there because that's the $1 million answer that you've given. But seeing that we're here, let's just wrap up. This chairperson, is going to ensure that did you ever say to, or rather, why did you reject the Friday report more than once?
There were various reasons. I think in the earliest drafts, for example, there was a version that said somebody said the Premier said this. And then the question was, why then was the Premier not interviewed? And then because in the public domain, as you said yourself, that the powers of the public protector include looking in all spaces. In the public domain, there were already allegations of corruption involving the Gupta family and others. So it was important to then, in terms of our standard operating protocol, to look into those relationships and how those relationships played out. And also in Mr. Magashule at some stage dropped at my office for a cup of tea. It wasn't included in the report because he just said he was visiting me, but he indicated that the person at the center of this was Minister MEC Zwane. That's why I had said to Mr. Samuel that all of these things should be considered. The important thing was when you do an investigation, everyone who was involved in the conveyor belt must be held accountable. And then the report at the end of the day has to cover all of that. So the early one had indicated that the Premier had some role in it. And then the next one had excluded now all of the names. And then the next one had the names, but had not done the in-depth forensic.
Yes. Okay. No, let me just try and summarize it because we don't have time. So you were not happy because they had not interviewed some of the role players, correct?
Yes.
Right.
And they had not decided the accountability. I think the key was not so much the interview, it was both the interviews and the accountabilities of those role players who had already been mentioned in the investigation.
Right.
And the Mail and Guardian again is whatever you hear in the evidence seeking process, you must follow it through until get to the bottom of it.
Yes, and the public protector, that's Advocate Mkhwebane, then did that, and actually, unlike you, went to see Premier Magashule. According to Mr. Samuels, she insisted that they go there. She went there, and then she invited him, as she should in terms of the law, to respond in terms of section 7.9. You're familiar with that section, which was to give him an opportunity and the MEC to respond. You would agree with that? That's how it should have been done. That's what you were asking for, actually, correct?
Well, by the time I left already, we were considering Section 7(9) notices on those people. And you will see that in the evidence of Mr. Samuel.
Yes, I know you were considering, but
they were being
there's a
prepared,
difference.
so it wasn't a new thing. Yes.
Yeah. No, that's it. That's a difference between a considerer and a doer. I'm saying that Advocate Mkhwebane actually went physically herself with her body to the office of the Premier, which is what you did not do. And she sent, not considered, the Section 7(9) notice. I'm saying that's the kind of thing that you wanted to be done so that these people who were mentioned should be confronted with adverse findings and be asked to comment, which is what Section 7(9) is all about, correct?
I don't think what is at issue, I think we keep running into spaces. I think what is at issue here is how those names then disappeared from the report, if you're saying that was what was decided.
No, but you see, that's the problem with you. You make these judgmental statements. Do you agree that Section 7(9) is an opportunity for aude alteram partem? In other words, if you have a finding against me, and you give me an opportunity to explain it away. That's what the purpose of Section 7(9) is, correct?
It's an extension. There's various stages of Audi. Yes, I agree. But in the first Audi is the letter that is written to you to tell you that there are allegations against you. Meetings are also part of the Audi. And yes, Section 7(9) is one of the instruments for exercising or for extending the Audi to implicated persons.
And therefore, if in the exercise of my Audi alteram partem rights, I then respond to your Section 7(9), and I respond in such a way that is satisfactory to rebut the adverse findings, then those findings do not disappear. They must go, because I would have answered. That's the whole purpose of Section 7(9). It's not just to go through the motions. It's to give somebody an opportunity to explain what might be a provisional adverse finding. So why do you say that the findings disappeared? What do you mean by that? Because they were not there simply because there was an answer in a detailed Section 7(9) response.
Well, again, we are talking about two different approaches. I will speak to my approach. In my approach, I would indicate all of the evidence presented against a person, and then I will indicate what they said. And then you and I would not be sitting here speculating about what was the original allegations that seemed to be worth considering as implicating someone, and how they responded to them and how you resolved it. Again, it's in the manual that I left, and the processes that investigators are supposed to follow.
Yes, but that's exactly what happened, madam. The report details the allegations against the Premier and the MEC. The report refers to the letters that were written to them. I think one of them was the 7th of July, 2018, if I'm not mistaken. And the report deals with their responses. So I think it might be a good idea for you to withdraw the snide remark that the findings disappeared, because it's exactly what the law requires, that when somebody gives you a satisfactory answer, you should you cannot continue to make adverse findings against them. In fact, that was one of the criticisms that was made against Advocate Mkhwebane in the rogue unit matter. So if the Section 7(9) response is satisfactory, then those findings must go. So would you withdraw that snide remark? that they
I will
disappeared.
not advocate Mkhwebane, I mean advocate Mpofu. I am going to revisit the report and revisit the information.
And we'll send you the section 7.9. I'll send you the section 7.9 letters. And once you have confirmed that what I've just told you is what happened and what is in the section 7.9, will you withdraw that slide remark?
If it's proper to do so, I will do so. But you must understand that we no longer, or at least during my term as Board Protector, we no longer concluded purely based on what the response was from the other side. We evaluated all of the evidence together.
Yes, that's exactly what happened. That's the point. So if you can show that the evidence was evaluated and it was covered in the section 7.9, then you will withdraw that snide remark, correct?
Well, if you call it snide, I will withdraw it if there's a need to withdraw it.
Yes.
At this stage, I do not see the need to withdraw it.
That's
I just
fine.
said the findings did disappear. I mean, the names did disappear, and the names did disappear.
No, by that you mean the Premier and the MEC, they are referred to. So that's a second snide remark, which is incorrect. The Premier and the MEC are referred to in the report. I'm telling you as a matter of fact. So that's also a false and unnecessary accusation. But it's fine. We'll cover it in a letter, which we'll send to you for you to withdraw the snide remarks.
No, please, let's keep it everything in this meeting. I don't have an attorney advocate, Mpofu. I cannot keep responding to your litany of letters.
Okay, no, it's fine. Well, you'll deal with it as you wish.
Let's keep it on this platform. It has been aired on this platform. Let's deal with it on this platform.
No, that's fine. I'm just telling you that we will send you a document that requires you to withdraw those snide remarks because you are making them in public and they are uncalled for, vindictive, and based on completely baseless. And if I may borrow from Judge Potterell, astounding, and I am dumbfounded. And she was right that the pot is calling the kettle black. That's the sum total of your evidence. Thank you, ma'am. Thank you, Chair.
Well, it's so good that I haven't called anybody anything. If we're talking about outstanding, insulting,
no, I'm just quoting the judgment.
If you
I'm just quoting the judgment.
No,
thank you, Advocate Mpofu. Please switch off, Advocate Mpofu. Thank you.
Okay, no, Chair, thank you. Yes, ma'am. Sorry, the chair will give you an opportunity. Before I switch off, I just want to say I was just quoting the judgment. Thank you, Chairperson.
Thank you, Advocate Madonsela. Over to you.
If we're talking about things to be withdrawn, you have maligned me. That's okay. I could see those snide remarks from the very first letter that I received from you, from the attorneys. That's fine. But I would like you to withdraw other insults and snide remarks that you've made against the commissioner of oath who did the first document. And for the purposes of this committee, I have indicated that the status of an investigation, the status of an affidavit was dealt with in a case here in this province. If we're talking about third decisis, it was in this province, and the case is Minister of Safety and Security versus Mustafa Mohammed. And that case says that the fact that an affidavit is not initialized on every page does not invalidate it. And to pass words such as illegality, criminality, that was low. Thank you.
Chairperson, if you allow me just to, firstly, ma'am, yes, I I was not talking about invalidating. I was talking about the criminal actions of signing an affidavit after it has been attested, but that's a separate thing. But on the second point, if I have made any snide remarks to the attorney, unlike you, I definitely will withdraw them. We're certainly going to pursue that matter with the attorney. We'll ask for an affidavit. If it turns out that indeed he was not in, what's the place, Randburg, or forgot the name of the place now, in Johannesburg, but he was in Stellenbosch, then that will be clarified in his affidavit, or when he supplies us with an itinerary or a plane ticket to that effect. It has happened before. But if all that turns out to be kosher, I will certainly have no problems with withdrawing as a professional person. But your postponed withdrawal will be dealt with in due course. Thank you, Chairperson.
Thank you.
Thank you, Advocate Mpofu. Thank you, Advocate Madonsela. Honorable Sukas, I just want to get to the next stage.
Yes, Chair, my hand is up because actually both advocates has now raised the issue that I actually wanted to request. The issue of whether an affidavit must be signed or initiated by the Commission of Oaths has not been settled, I think, for us as the committee. I have looked at both the Act and the regulations. And in my layperson's view, it is not the case. But as a member of the committee, we cannot judge a matter unless the law is made clear to us. So I would request, Chair, that the evidence leaders address this point, or failing which that the legal staff put it before the committee. Thank you.
Thank you, Honorable Sukas. This is going to be an adjournment. We're not done yet. The time now is 6 o'clock. We'll adjourn our meeting and start tomorrow at 9. It's a shorter day. And when we start tomorrow, we'll start with Advocate Mayosi. We'll interact with the witness, followed by the members. So at that point, I want to say thank you for, we have stretched the day up to 6.
Thank you, Chair.
Whatever time you would have given before, you've taken it back and even more to get them both. Honorable Maneli.
No, thanks, Chair. Just on the point raised by Honorable Sukas, I'm not sure whether you are saying then, Chair, you are ruling that because we are adjourning, it's a matter that may need to be clarified in the morning on the standing of this affidavit, because we've now gone through point by point as we listened to Advocate Mpofu interacting with it. I think it's important because in the records of the committee that we can place it on record in the morning, whether there's clarity now on this matter or not, right? So I'm just saying she made that point and I thought you were coming to just clarify it, but if not clarified, I think we'll still need it on record, because there was an opposing view that said it's not an issue and we should proceed. And that's cool. Thank you.
Thank you. Advocate Mpofu.
Thank you, Chair. Sorry, it's just to be helpful. Chair, if the issues of law and legality and what have you will be argued at the end, but if you want to, which seems to be what is being suggested now, if that legal argument is going to be brought forward, then it should not be confined to that point. I've made about 4 or 5 serious criticisms, including from about 10 to when we broke for tea, on the so-called affidavit, which I call a statement. So all those points, then, if we're going to now get into legal argument, both sides will have to address them and if they, I don't know why they must be addressed now, because all the legal points, including the binding nature of judgments and whatever, have been left towards the end, correctly so. But if we're going to have a stop-start legal argument, then it's fine. Let's do it, but let's not just do it on one point. Let's do it on all the issues that have been raised, because the status of that document as an affidavit or not is dependent on all the 4 or 5 criticisms that are leveled. Thank you, Chair.
Thank you, Advocate Mpofu. Honorable Maneli, I thought I'd responded when I said we're not concluding today. You are adjourning to start tomorrow at 9. If there are any other issues, we'll deal with the issues tomorrow, even before we conclude.
Sure.
Thank you. On that note, honorable members and everybody else, colleagues, Advocate Madonsela, we will adjourn the meeting and meet tomorrow at 9. Thank you very much.